All memos you give. Wait, mentioning wait. Then 1 minute. Writ petition or memo? How many pages? Oh, collecting. Okay, okay. One ನಿಮಿಷ. ಆ ಕಡೆ ಬನ್ನಿ. Wait. Account has been frozen. Why? When was it frozen? When was it frozen? Give it. Tomorrow. Wait. Please, I'm coming. Don't interrupt in the middle. Yes. That's on Friday, madam. Friday. Madam, part heard matter. Friday hack. Sorry? For what? first. ಎಲ್ಲರಷ್ಟು ಏನೇ ಇರೋದು ಏನು ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಕೊಡಿ ಗಿವ್ ದ ಮೆಮೋ ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್ ಪೆಂಡಿಂಗ್ ಅ ಫ್ರೆಶ್ ಕಮ್ ಗಿವ್ ಇಟ್ ಥ್ಯಾಂಕ್ ಯು ಸರ್ 2:30 ಟುಮಾರೋ ಬೇಡ 2:30ಗೆ ಬರ್ರಿ ನೀವೇನಿರೋದು ಬೇಡ wait. So what? Why 1:30? 2:30? What were you doing till now? So what? ಕೊಡಿ ನಾಳೆ ಕೊಡಿ ಎಸ್ ನಿಮ್ಮ ಹತ್ರ ಬಂದಾಗ ಅರ್ಜೆನ್ಸಿ ಆಗಲ್ಲ ಅದು ಎಸ್ ಸ್ಟೇ ತಗೋಬೇಕಾ ಹಂಗೆ ಕೊಡಲ್ವಲ್ಲಮ್ಮ ಟುಡೇನೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಮೇಡಮ್ 9th ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ ನಾಳೆ ಬರ್ರಿ ಮೆಮೊ ಯು ಹ್ಯಾವ್ ಗಿವನ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಮೇಡಮ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಎಸ್ Thursday give it. Why sir? Thursdays. XMLA ಏನು ಅರ್ಜೆನ್ಸಿ ಸರ್ ಏನು ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಸರ್ ಇಲ್ಲ ತಾನೆ ಫ್ರೈಡೇಸ್ Your case is set down for evidence. Why are you worried? Oh, then we'll dismiss this also. Give it. Yes, both will dismiss. Day after tomorrow, madam. Wife and father-in-law. Complainant husband. So what? No, bail ತಗೊಂಡಿದ್ದೀರಲ್ವಾ ತೊಂದರೆ ಇಲ್ಲ ಕೊಡಿ ಭರತ್ ನೋ ಡೇಟ್ ಕೊಡಿ ಯಾಕೆ ಕೊಡ್ತಾರೆ ಮಾಡ್ತಾರೆ ಸ್ಕ್ರೂಟಿನಿಗೆ ಹೋಗುತ್ತೆ ಮೆಮೊ ಅದು ಕೇಸ್ ನಂಬರ್ ತೊಂದರೆ ಆಗಿದೆಯಾ ಈ ಕಡೆ ಬನ್ನಿ ಕಮ್ ದಿಸ್ ಸೈಡ್ ತಗೊಳ್ಳಿ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್ ಏನ್ ಕೇಸ್ ನಂಬರ್ wait I said come this side yes ಆಗಿಲ್ವಾ ಕೊಡಿ ತೊಂದರೆ ಅದು ನಾಳೆ ಹಾಕಿ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು wait sir which year sir ಯಾವತ್ತು ಮೇಡಮ್ not Friday Wednesday I can't take it according to your wish yes so Wednesday yes if you want to come on Wednesday or it will go 4 weeks later 2:30 ಏನು ಯಾಕೆ ರೋಹಿತ್ ಆಯ್ತು ನಾಳೆ ಕೊಡಿ ಅದಕ್ಕೆ ಯಾಕೆ ಅವ್ರ he will collapse Wait. You barged in there. Wait. Calling for police station. Answer the call. And that pending. ಕೊಡುತ್ತೆ ಕೊಡಿ. Yes. ಸ್ಕ್ರೂಟ್ ಅಲ್ಲಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಹೋಗಿ ಎಲ್ಲ FR ಇರುತ್ತೆ ಎಲ್ಲ. Next week give it. Yes. ನಾಳೆ ಕೊಡಿ ಅದು. tomorrow ತಗೊಳ್ಳಿ. Fresh matter tomorrow ಯಾವುದು ಇಲ್ಲ. If you want to give fresh matters, give it. No tomorrow. We will post all first ಎಲ್ಲ FR ಇರುತ್ತೆ, ಕಂಪ್ಲೈ ಮಾಡಿ ಹೋಗಿ. Wait, pending, wait. All fresh matters give. Give all the fresh matters. Matte don't wait for mentioning. Give all the fresh matters. Even if it is 10th, no problem. Give it. Give all the fresh matters. ಮೆಮೊನೇ ಹೋಗಿಲ್ವಾ? ಎಲ್ಲಿಗೆ ಹೋಗಿದೆ? ಕೊಡಿ, ಅದು ಯಾವ್ದು ಕೊಡಿ. ಕೊಡಿ ಸರ್. ಪರವಾಗಿಲ್ಲ ಸರ್, ಕೊಡಿ. ಎಸ್. ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ ಅದು ಮೆಮೊ, ಅದು ತಗೊಳ್ಳಿ. ಅಲ್ಲಿಲ್ಲನಾ? ಅಲ್ಲಿ ಅದೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಸರ್? ವಿಲ್ ಸಿ. ಎಸ್. ವೇಟ್ ಫ್ರೆಶ್ ಆಯ್ತಾ ಎಲ್ಲ? ಸೊ ಕೊಡಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ. ವೈ ಕೋರ್ಟ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆಯಾ? ಕೊಡಿ, ನಾಳೆಗೆ 2:30. Wife has filed second FIR. Works in the home department. Give it 2:30. Yes. Fresh ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. Fresh ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ please. It will come, then give it. Yes. Whichever writ number alert ಆದ್ಮೇಲೆ ಬಂದೇ ಬರುತ್ತೆ, ಕೊಡಿ. Vacating stay. ಏನ್ ಸ್ಟೇ ಕೊಟ್ಟಿದೆ? ಪರವಾಗಿಲ್ಲ, next week. Yes. ವೇಕೆಟಿಂಗ್ ಸ್ಟೇ ಎಲ್ಲ ಒಂದಿನ ಹಾಕ್ಸ್ತೀನಿ ಮೇಡಮ್. ಯಾವ್ದು 7A? 13 is 8th, I guess. 8th or 7th? ಕೊಡಿ. ಎಸ್. ಯಾರು? ಕೊಡಿ, ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಕೊಡಿ. Please give all the pending matters. No dates in any pending matters. No dates. Maybe, sir. Maybe. Give it. No problem. Give it. Yes. Huh. 21 ನನಗೆ ಬರಲ್ಲ, ಬೇರೆ ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಬೇಕು. ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ. Give the memos. No submissions. Give the memos. Please give all the memos. Pending matters, all the memos you give. Fresh matter also kodi. Give all the memos. I am not assigning dates in any pending matters. Give the memos. Friday, that is Friday. WP number agidella barutte kodi. Give all the memos, please. Give all the memos. ಒಂದು ನಿಮಿಷ, ಯಾವ್ದು ಮದುವೆ ಇದೆ? ಏನದು? 138 ಅಲ್ಲ, ಅದು ಯಾವ್ದು ಮೇಡಮ್? ತಗೊಳ್ಳಿ. ಅವ್ರ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗೆ ಯಾವ ವರ್ಷದ ನೋಡಿ ನಾಡಿದ್ದು ಹಾಕಿ. ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ. ಎಸ್. ಎಸ್ ಸರ್. ದೇರ್ ಇಸ್ ಇಂಟರಿಮ್ ಸ್ಟೇ. ಎಸ್ ಸರ್. No problem, sir. Please give the memo, sir. Whatever memos you want, please give, sir. What? No dates, sir. No dates. Whatever memos you want, please give. Settlement birth code yavattu. There are 300 matters today. If you permit me, I will start. Please give all the memos. Please give all the memos. No, sir. Yes. What exception? There are 10 memos moved, sir. It will come. Stay idya. Bharat. It will come. No problem, sir. We will give it. Yes. No problem, sir. Give it, sir. Give it, give it. No problem, sir. Give it. I can't handle all the cases in a day. We'll see, sir. We'll see. Give it. Yes. Pending matters, please give, sir. So what? Please give. No mentioning, no dates. Please give. Whatever it is, sir, give it. Yes. Parvaila. Yes. Give it, give it. Why? Fresh. Ayenu. ಟೆಂಡರ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ತೊಂದರೆ ಇಲ್ಲ. ಗಿವ್ ಇಟ್ ಅದು ಟುಮಾರೋ ತಗೊಳ್ಳಿ. ವೈ ಕೊಡಿ 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 ಡೇ ಆಫ್ ಟುಮಾರೋ. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಕೊಡಿ ಅದು. ಅಯ್ಯೋ 2:30 ಈಗ 11:30ಗೆ ತರ್ಸೋಣ. ಅದಿನ್ನೂ ಬರ್ಲಿಲ್ವಾ ಅದು ಮೇಡಮ್? ಅದು ಅವತ್ತು ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇರಲಿಲ್ಲ ಅಂತ ತಗೊಳ್ಳಿ. 2:30ಗೆ ಹಾಕಿದ್ ಏನ್ 7 ಏನೋ 13 ತಗೊಳ್ಳಿ, ಅದು 7 ತಗೊಳ್ಳಿ. ಆಯ್ತು. ಎಸ್ ಎಸ್. ಸಾರಿ, 20% of the order. It will come, give it. Yes.
The forest matter, the reserved matter, that is supposed to come on Friday.
Madam, I was not sitting Friday. Yes.
So 138 to
We'll post it this Friday.
This Friday.
Yes.
138 to stay vacate file ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮಾಡಿ ಕೊಡಿ.
ಜೊತೆಗೆ ಫಾಲ್ಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕಂಪ್ನಿ ಪಾರ್ಟ್ ಮಾಡಿ.
ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ, ಕೊಡಿ
ಪ್ಲೀಸ್.
Yes.
ಎರಡು ವೆಕೇಟಿಂಗ್
ಸ್ಟೇ ಇದ್ರೆ
ಎರಡು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಏನಾದ್ರು ಗವರ್ಮೆಂಟ್ ಗವರ್ಮೆಂಟ್ 7
They are likely to file charge sheet tomorrow.
ವೆರಿ ಗುಡ್. ತಗೊಳ್ಳಿ. Yes. 7 ಆದ್ರೆ ತಗೊಳ್ಳಿ, ಬಿಕಾಸ್ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಲಿಸ್ಟೆಡ್ ಟುಮಾರೋ.
7
ಬೇರೆ ಯಾವ್ದು ಅದ್ರ ಹೆಸರು ಮೂವ್ ಮಾಡಬೇಡಿ.
for tomorrow.
ನೀವು ಯಾವ್ದು ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಏನು? ಕಾಲ್ ದಿ ಕೇಸ್. A1 to A7.
CW 1 to 4 are eyewitness.
ಎಲ್ಲ ಇದೆ. You should file discharge 2022. ಈಗೇನ್ ಮಾಡೋದು?
HBC ಇದೆ.
Yes. ಫೈಲ್ ಆಗಿದೆಯಾ ಡಿಸ್ಚಾರ್ಜ್?
HBC ಇದೆ ಈಗ.
HBC ತಾನೆ, ಡಿಸ್ಚಾರ್ಜ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ? ಮಾಡಿ. ಎಸ್, ಅದರ್ವೈಸ್ ನೋ ಇಂಟರ್ಫಿರೆನ್ಸ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಡಿಸ್ಚಾರ್ಜ್ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಆರ್ಡರ್ ಇದೆ, ಗೊತ್ತಾಗುತ್ತಾ? ಹೇಳಿ. ಡಿಸ್ಚಾರ್ಜ್ ಲಿಬರ್ಟಿ ಕೊಟ್ಟರು ಡಿಸ್ಚಾರ್ಜ್ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಆರ್ಡರ್, ಅದೇ ತರ ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿರಿ, ಗೊತ್ತಾಗುತ್ತೆ.
Acquitted.
Acquittal. Learned counsel for the petitioner submits that the petitioner has been acquitted of the offences. In the light of the acquittal, the present petition would not survive for further consideration. It is disposed as having become infructuous. ಏನ್ ಹಾಕಿದ್ದಾರೆ? ಅದೇ ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೊ ಮಾಡ್ಬಿಡಿ, ಮೆಮೊ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. ಎಸ್. ಎಲ್ಲಿ ಇವರು ಅಕ್ವಿಟಲ್ ಇನ್ ಪ್ರಿಡಿಕೇಟ್ ಅಫೆನ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾರು ಇರಲಿಲ್ಲ. ಪಾಸ್ ಓವರ್.
Charge framed in.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರೆ ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ. ಪ್ಲೀಸ್ ಡೋಂಟ್ ಆರ್ಗ್ಯೂ ದಿ ಮ್ಯಾಟರ್ ಇವನ್. ಅಂಡ್ ಆಲ್ ಅಫೆನ್ಸಸ್ ಆರ್ ಫೌಂಡ್. ಕಮ್ ಟು ಪೇಜ್ 39. ಎಲ್ಲ ಆಲ್ ಅಫೆನ್ಸಸ್ ಫೌಂಡ್. ಸೊ ವಾಟ್? ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಸರ್. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಲ್ಲ ಈಗ. ಎಸ್, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್. Somebody will laugh at the court. Charge frame ಆದ್ಮೇಲೆ ಯಾವ ಡಿಸ್ಚಾರ್ಜ್? You urge all the contentions in the before the concerned court. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಇದು 1 ನಿಮಿಷ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಯಾವತ್ತು ಜಗದೀಶ್? ಹಾಕಿರೋದು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಯಾವತ್ತು?
Don't have the exact date, man.
But even then all offences are found. I have no. Learned additional SPP to secure instructions of the date of framing of the charges, lest the matter on 20th.
I have got petitions in this matter, my lord. Before diving into the facts and merits of the matter,
You want to delve into something else? Yes, sir.
hearing of the
Advocate, yes.
Yeah, first.
Yes, my lord.
Yes, sir.
The petition number 2 is a young advocate practicing before the trial court.
Who is the complainant, sir?
Complainant is the court, register.
High court.
Judicial register.
High court, sir.
High court.
Yes, sir.
I'll explain. This petition number 1 is mother-in-law. Petition number 2 is the practicing advocate son-in-law. And this matter arising. out of-
File discharge, sir.
My lord,
File discharge application before the concerned court. If I give any finding on this,
hearing before charge is on 9th.
no problem, sir. Before that, you can file discharge. I'll give you liberty.
But I have a merit, my lord.
No,
because I'm
sir,
practicing
not
This-
at all.
nothing
The
but-
complaint came to be
How
lodged,
am I
my lord.
advocate against the.
No problem, sir. I will not interfere in this.
This court has directed, my lord, initiation of complaint, my lord. At
Sir,
page 42.
There is an order passed by the court to register a complaint against you. You think this court will interfere against the order of the coordinate bench?
My-
Please.
my lord,
Then-
because- But I am having a merit, my lord, because I'm not.
You may
involved
have
in the-
100% merit, sir. The coordinate bench has directed registration of complaint against you. That is why High Court has registered the complaint for forgery.
Yes, my lord.
Yes, sir.
I do agree. my
Yes,
lord.
sir.
But I am having merit. I'm not involved in any way.
No
because
problem,
I
sir.
am already a advocate against this other.
No
accused-
problem, sir.
other
Yes.
accused, my lord.
You take your chance before the court for discharge. Otherwise, I am not going to interfere in this. Yes, sir. Discharge order.
Please,
Yes.
grateful.
Acquitted, madam.
Acquitted.
311 application, but acquitted.
The learned additional SPP on instructions would submit that the petitioner has been acquitted of the offences. What is called in question is an application, a rejection of an application under section 311 of the CRPC. The order is dated 3/3/2023. In the light of the acquittal, the present petition is rendered infructuous and is disposed as having become infructuous. How much money you have taken, sir? Why, sir?
The gold was given to for wearing. To the
Gold, ah?
wife. Oh,
Ade,
Previous wife's gold is alleged to have been taken.
give it back, sir.
Restitution of conjugal right is pending, my lord.
ಅದಕ್ಕೆ ಗೋಲ್ಡ್ಗೂ ಏನ್ ಸಂಬಂಧ?
She wants to.
We want the wife along with the gold.
Wife is, wife, daughter and daughter's fiancé are before.
One additional SPP, 2 emergent notice. ನೀವಿಲ್ವಾ? ಇದೆ. Family problem. Mean, emergent notice returnable by the 4th of September 2024. In the meantime, ಗೊತ್ತಾಗುತ್ತಾ madam? In the meantime, there shall be an interim order of stay of further proceedings.
Both
Where the
money
pet-
and,
Huh?
both money and property also wanted to.
ಅದ್
take
ಬರ್ಲಿ ಅವರು, let the respondents come. ಇದು ಸೆಟ್ಲೇ ಆಗದು ಬನ್ನಿ. So and so. In the meantime, there shall be an interim order of stay of further proceedings. ಅದು ಎಲ್ಲೆಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ madam, before court so and so. Quay the petitioners.
Right.
Next.
Sir. Lords, objections are ready, my lords.
It
I'll
should
file
be
it today.
Shriki connection. I will not interfere in this. You are a DYSP.
Two
Yes.
complaints were filed.
No problem.
Not, no complaints from any other. The same complaint files, 2 complaints.
We'll see.
Same.
We'll see.
Crimes, where.
Justice Krishna Kumar ಒಂದು ಆರ್ಡರ್ ಕ್ವಾಶ್ ಮಾಡಿದಾರಲ್ಲ ಅದು ಯಾವ್ದು?
Coca,
Coca.
Coca.
ಅದು ಕೋಕಾ ಇತ್ತು ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇ.
Coca ಹಾಕಿದ್ರು against CK.
Again Shriki ಗೊತ್ತು. This also Shriki connection.
Connection, he registered case against CK.
No problem, sir. ಆಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ಮೇಲೆ ಏನೇನಾಗಿದೆ ತುಂಬಾ ಇದೆ ಸರ್.
The only thing is, there are 2 FIRs, running, on. the
We'll
same
see. We'll let him file his objections.
I'll file it.
Yes. Heard the learned senior counsel Arun Sham appearing for the petitioner. The learned counsel P. Prasanna
Prasanna.
P. Prasanna Kumar appearing for the respondent seeks 2 weeks' time to file statement of objections.
Get the your signature, my lord.
I am
I'll
not
file it in the
ready,
registry.
To 10 days' time to file statement of objections. Objections, if any, by the 21st of August, list on 21st in the fresh matters list. ಇದೆಯಾ? ಮತ್ತೆ ಯಾಕೆ ಅಷ್ಟೊಂದು ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದೀರಾ?
Only, there is one
That
word,
they-
that is, bothering. Tendency, no precipitate
No, my lord.
and coercive action,
ಓ ಇದು 23 ಇಂದಾನು ಇದೆ.
Incriminating material ಅಂತ ಒಂದು word ಇದೆ.
ಈ ಒಳ್ಳೇದು.
ಅದಾದ್ಮೇಲೆ ಸಿಡಾಕ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಬಂದಿದೆ sir. No,
ತೊಂದ್ರೆ.
my lord, there is simple material.
Same will continue. Of course, interim order if any subsisting as on today shall continue till the next date of hearing.
Please.
ಇದು these connections ಎಲ್ಲ ಸ್ವಲ್ಪ ಇದಾಗ್ತದೆ. ಮೇಡಮ್ ಕಾಲ್ ಲಿಸ್ಟ್ ಹೋಯ್ತಾ? ಕಾಲ್ ಲಿಸ್ಟ್ ಹೋಯ್ತು.
406, 408, 420.
406, 408, 420. CC of 2016, what stage? What stage ಅಲ್ಲಿ ಇದೆ proceeding?
A1 is already passed to the
Page
page number 220.
2. Page fast. ಎಲ್ಲ ನೋಡ್ಕೊಂಬರ್ಬೇಕು. 220
169.
220 ಇಲ್ವೇ ಇಲ್ವಲ್ಲ? ವಕಾಲತ್ತು ದಾಟ್ಬಿಡುತ್ತೆ.
No, it doesn't help in this case. There, that coordinate bench, my lord, says that there is material against these persons.
Yes. this
Page
was-
169, para 2, my lord.
Yeah.
Your accused number 2 to 6, huh?
Is 4 and 5 and 6, my lord.
Anyway, look into it.
Like, the coordinate bench said that there is material against these people.
Acquittal,
Coordinate bench. said-
material against these.
Yes, this, yes.
Page,
Page 168 and 169, my lord. The order dated 23rd September 2019. Annexure E.
Yeah.
Para 2, my lord, these allegations squarely attract the ingredients of offense so and so insofar as accused number 2 to 6 are concerned. Therefore, accused number 1 was
one ನಿಮಿಷ. Or transferring proceeds of DD personal account of accused number 2.
By some other stuff.
Wait, sir. Come to page 169. As such, I do not find any justifiable reason to accept the argument of the learned counsel that accused number 2 to 6 have been falsely implicated in the alleged offences.
Some.
No problem, sir.
Never.
That's all right. Hmm.
The amount, the CW 2 to 17 were the chief members in Margaret chief fund.
No problems.
They were, well, they withdrawn. the
Conspiracy and
Malad-
circumstances. Yes, look into it.
Amount
One additional SPP,
notice may be- notice
Two-
to the respondent.
2 emergent notice. Yes. Pendency of this petition will not come in the way of the further proceedings before the concerned court. Yes, next.
Petitioner purchased the property.
Produce the entire charge sheet material, sir.
charge frame.
Charge framed.
The date of filing the
Charge framed.
charge frame.
Then I will not interfere.
The case is that.
No, sir.
Purchased the property.
Even otherwise, see page 26. All offences found, charges correctly framed.
For charging of the, for charge, that page I tried the petition, but there was some office objections after comparing this matter has come up before today. Madam, I have-
9/11/2023 you have filed charge frame ಆಗಿರೋದು ಯಾವ date.
7/12/2023.
Yes, sir.
The matter is not. Complaint is. given-
Charges are framed. I'm not going to interfere, sir.
On the submission, it is any, the petitioner has purchased the property on Siddhagowda. After purchase the property, his name was minted in the municipal record. There, at that time, there was the manual, author was being issued. Later, his wife and children have also given confirmation deed. But subsequently, after
No,
digital.
if you want me to give a finding, I will give a finding. All offences are found here.
After the introduction of the computerized scheme in the municipality, the computerized Kava was also issued to the petitioner.
All right,
The,
yes.
President of the municipal council, Chikmagalur, she is no way concerned with this matter. She gives a complaint there, so SP, alleging that.
ಈಗ discharge ಹಾಕೊಂತೀರಾ? Charge ಆಗಿದೆ.
Charge.
Yes.
Petitioner and.
I will submit all this before the concerned courts.
They have complaint copy, that is.
Charges framed, I will not interfere. Yes.
I have verified, whether, sorry, charge is framed.
Ah.
Charge is filed.
Charge frame ಆಗಿದೆ ಸರ್, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿರೋದಲ್ಲ.
Petition was filed. Now I will verify whether it is.
ಆಯ್ತು, ವೆರಿಫೈ ಮಾಡಿ.
Charges are the.
Next week ಅದನ್ನ ಕ್ಲೋಸ್ ಮಾಡೋಣ. The learned counsel appearing for learned additional SPP submits charges have been framed. Therefore, the petition in the form that it is present today would not be entertainable. Learned counsel appearing for the petitioner seeks a week's time to verify and make his submissions. List the matter on 13th in the fresh matters list. It is made clear if the charges are framed, the court this court would not entertain the petition. Yes, next. We'll pass over relaxation of bail. Yes. Madam, in the meantime, andre gottagutta? In the meantime, andre gottagutta? In the meantime, andre format tagoli. Additional SPP accepts notice for the first respondent, emergent notice to the second respondent. In the meantime, there shall be an interim order of stay of further proceedings, so on, so on, so. ಯಾವ court ಅಲ್ಲಿ? I'm bari in the meantime ಅಂತೀನಿ. You will know it. Yes, in the meantime. State, sir. Yes. 25 lakhs. ಕೊಟ್ಬಿಡಿ. 55 lakhs. Give it.
Allegation is that taken for 55 lakhs. Produce a memo, my lord, which is that the respondent number 2, which is Suresh Jain, he is the main accused in the main case, number 48 of 2023. It is he who has,
Yes, sir.
I have for respondent, the documents what I have relayed before the lower court, before referring the matter. I am
ಹಾಕಿಲ್ವಾರು?
placing,
List on
sir,
20th in the fresh matters.
I will file it in the counter.
File it in the. Yes.
Sir.
ಇಲ್ಲೇ ಕೊಡ್ತೀರಾ? ಇಲ್ಲೇ ಕೊಡ್ತೀರಾ?
Good, sir. Yours.
Number 1.
Crime of 2020, charge sheet is not filed?
Under investigation.
What?
Under investigation.
Now investigation. ಯಾಕೆ ಇದ್ರಲ್ಲಿ ಏನಾಗಿಲ್ವಾ?
They are the victims.
ಏನು offense ಏನು?
363, what is that?
363.
ಅಲ್ಲ, 363 ಹಾಕಿದ್ದಾರೆ, but it's a major 363 ಹಾಕಿದ್ದಾರೆ.
1 minute, sir. Accused number 1 was having the extramarital relationship with the daughter of the respondent number 2, my lord. Thereafter, my lord, the respondent number 2 filed the missing complaint, my lord. After the missing complaint, my lord, in fact, the accused number 1 was not present in any proceeding, my lord. The petitioners also approached the police to and filing missing complaint. Kindly come to the, my lord, page number 24, annexure E.
363 ಅಲ್ಲಿ ಸ್ಟೇ ಮಾಡ್ತೀವ ಸರ್.
Only allegation against the accused number 1, my lord. There is no allegation against.
We'll see. Let the investigation
Not a
papers
minor.
come.
She's not a minor, major,
Major, my lord.
major
She is estranged wife, my lord.
ಮತ್ತೆ 363 ಯಾಕೆ?
ಹಾಕಿದ್ದಾರೆ.
Estranged wife for having extramarital relationship. The accused number 1, my lord.
You are accused number 2 to?
My lord, family, my lord, mother, neighbors, relatives.
How can you draw 363 against the major, sir?
You can't.
That's the major offense
That's the major,
and the investigation is still on.
because even we are not able to trace the victim.
No, no, my lord. Daughter of the respondent number 2 is here in this village, my lord. But in fact, accused number 1 is not there, my lord.
No, no, victim is also not been traced. That is the case.
The crime is registered in the year 2022 in crime number 111 of 2022. The learned additional SPP, the learned counsel for the petitioner submits that crime or the offense punishable under section 363 is deliberately laid against the petitioners as on the date of the missing of the victim, she was not 18 years, but more than 18 years, not less than 18 years, but more than 18 years. Therefore, the projection of the glorified offense of section 363 would tumble down. The other offenses alleged are against accused number 1. If the victim and the accused number 1 had a relationship between the two, it is ununderstandable as to why all the family members are dragged into the web of crime. Therefore, there shall be an interim order of stay of further investigation against these petitioners only till the next date of hearing.
Clarify, my lord, that the investigation continue with respect to others.
It is made clear that the investigation shall continue against any other accused in the crime. Yes, next. Which is the complaint registered by you?
That is the wife of the first petitioner registered a complaint.
Where page? Should be fast, sir.
Yes.
Flag ಹಾಕೊಂಡ್ ಬರ್ಬೇಕು page ಗೆ. Page number. Iller will adjourn it by 4 weeks. List after 4 weeks.
16?
List after 4 weeks. No, sir. If you counsels are not quick, I can't go on with the cases here. Yes, pass over, nodkom bani. Pass over. Come. Yes.
16?
Venkatesh Arbatti.
Petitioner.
16 and 17 same. One additional SPP, two emergent notice, 16, 17. In the meantime, purely civil case, sir.
Eyewitnesses.
Huh?
Eyewitnesses.
How eyewitness? Yes.
118 of
Agले stay agide bererದು.
ಹೌದು.
Tag this petition along with
118 of 2023.
ಬರ್ಕೊಂಡ್ರ ಮೇಡಮ್ 13 ಬರ್ಕೊಡಿ. Yes. Next. Eighteen.
18.
Petitioners are mother-in-law and father-in-law of the second respondent.
ಎಲ್ಲ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Top Panchayat.
Huh?
Top Panchayat, because the married to intercaste marriage. And she's been subjected to harassment.
Who has been subjected to? ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಯಾವುದು?
My complaint is document number 7, your last.
Get the respondent, we'll see.
Second respondent has filed this complaint.
One additional SPP, two emergent notice returnable by the 21st of August, list on 21st in the fresh matters list. Yes.
19.
78-3.
Charge framed.
78-3. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ 2024 file a petition. As I will not interfere in both the cases. There are two cases of the same petitioner today, both 78-3. Charges framed ಯಾವಾಗ ಆಗಿದೆ ಜಗದೀಶ್?
Charge frame my lord at page number 12, my lord, on 6/3/2019.
6/3/2019.
I'm sorry, my lord.
18 case ಇದು.
These are covered matters.
Huh? Maybe sir, charges are framed. What were you doing till now? See, it is not that when the client comes to you, there emerges urgency. 2018 case, 2024 ಹಾಕಿದ್ದೀರಾ petition. Petition ಹಾಕಿರೋದೇ 24. Sir, switch off that light. ನಿಮ್ phone ಅಲ್ಲಿ. Yes.
6/3/2019.
Charge frame ಆಗಿದೆ madam, I am not going to interfere. Whatever madam, charge is framed, you will get acquitted, no problem. Charge is framed long ago, 19 itself. You can't file petition after 5 years. Both, there are two cases of yours today, same. Whatever it is, charge is framed, I am not, I have to interfere, I would accept everybody's petition then, yes. The learned additional SPP on instructions would submit that the charges are framed against the petitioner in the case at hand. The learned counsel for the petitioner submits that an excellent case on merits is projected before the court, be that as it may. Once the charges are framed, entertainment of a petition under section 482 of the CRPC would not be warranted in the light of the judgment of the apex court in the case of Meenakshi Bala versus so and so, 1994 2 SCC.
Please record it.
That is 78-3 alva.
Please record.
Yes. Yes, sir.
Please record it. On 6/3/2019.
Anyway, then same thing. Cognizable offense geno idukku adella onde. It is non-cognizable, I know, 78-3. 78-3. Yes.
That is not covered under that.
Plea has been recorded.
That's all right.
2019.
Yes. One additional SPP, two emergent notice. There shall be an interim order of stay of further proceedings before the concerned court. Yes, next. ಅದೆಲ್ಲ ತೆಗೆದ್ಬಿಡಿ ಮೇಡಮ್.
36 also same.
ಅವ್ರಿಗಾದ್ರೂ ಇರಕ್ ಬಿಡಿ. If you have some work, please go. Let him be there.
20.
Will let it come, madam. ನನ್ಗೂ ಗೊತ್ತು 2 ಕೇಸ್ ಇದೆ ಅಂತ. One minute, sir. For an incident that happens on 12/12/2020, a crime comes to be registered on 9/1/2021 without any explanation for the delay in registration of the crime for 27 days. Apart from the fact that the parties to the lists are in a squabble before the civil court in OS.
65 of.
Fast.
Yes, 65 of. YS 85 of 20 Harrier Apple.
OS 85 of 20. In that light, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Yes.
21,
Yes, Madhu. Huh?
Kindly pass.
Pass. 307. Bari notice ಅಷ್ಟೇ. ಏನು? You are A5, I know. You are A5.
Not against.
ಎಲ್ಲ A1 to A5 ಒಟ್ಟಿಗೆ ಮಾಡಿರೋದು ಅಂತಾನೆ ಇರೋದು. Entire charge sheet is that.
Complaint had given a restatement.
No problem. Yes. You want pass over or you want notice? I'll pass over.
22,
A1 husband, we will not stall. A2 paramour, definitely.
Complaint, there is no allegation.
So,
or demand of-
husband having a paramour enough.
Charge sheet also, there is no any allegation.
ಏನ್ ಪರವಾಗಿಲ್ಲ. ಇದೇನ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲಲ್ಲ?
Not.
The petitioners accused 1 and 2 are before this court calling in question proceedings in CC. ಎಲ್ಲಿ CC ಯಾಕೆ ಹಾಕಿಲ್ಲ? In CC 1899 of 2023 registered for offence punishable under so and so. The allegation is for the offence punishable under section 498A inter alia. The second petitioner, accused number 2, is said to be the paramour of the husband, accused number 1. Therefore, there shall be an interim order of stay only qua accused number 2. And it is made clear further proceedings against the husband shall continue. Yes.
One commission.
One additional SPP to emergent notice.
Also, there is no single allegation in the complaint.
No problems.
Charge sheet.
ಸಾಕು. Accused number 2 ಇದಾರಲ್ಲ ಜೊತೆಗೆ ಅಷ್ಟು ಸಾಕು.
Colleague of the petition number 1.
ಅದೇ ಸರ್ ಕಲೀಗ್. ಎಸ್.
ಇಲ್ಲೂ ಕಲಿಗೆ ಬಂದಿದ್ದಾರೆ.
ಹಾ?
ಇಲ್ಲೂ ಜೊತೆಲೇ ಬಂದಿದ್ದಾರೆ.
ಇಲ್ಲೂ
ಅಲ್ಲೂ-
ಮತ್ತೆ ಅಲ್ಲ ನೀವು ಆಫೀಸಲ್ಲಿ ಜೊತೆಗಿರೋದು ಪ್ರಾಬ್ಲಮ್ ವೈಫ್ಗೆ, ಇಲ್ಲೂ ಜೊತೆಗೆ ಬಂದಿದ್ದೀರಲ್ಲ. ಅಕ್ಯೂಸ್ 1 and 2 ಟುಗೆದರ್. ಎಸ್.
23,
15 years, 11 months.
Huh?
15 years, 11 months. Most.
Lord, according page number 58.
I will not say.
For the one good reason that, my lord, at the time of incident, the victim was 16 years, 6 months.
I will not settle this. You will get acquitted, no problem. Face trial.
The interest of the child and also the victim, my lord. It's not an allegation that she was subjected to sexual assault before the marriage. And also it is not an allegation that.
Before the marriage, and when did you get married?
That when she was minor.
Who got you married?
The victim and the petition number 1.
Who got you married?
Got married in 164, they got themselves married and they held. At
You
page,
eloped and got married,
eloped and married. At 59, my lord.
but 15 years, 11 months, no. Sir.
Well, 16 years, 6 months. my lord. At the
Even
time-
then, sir. Even then, ಏನು ಬಾರಿ 16 years, 6 months ಅಂತ ಹೇಳ್ತಾರೆ.
This honorable court, the border bench has passed such a matter. my lord.
ಎಷ್ಟು ವರ್ಷ ಅದ್ರಲ್ಲಿ?
16 years. Even in Karun Vaishnava, the state of Rajasthan, the same came challenged by the challenge before Supreme Court. and
What happened to that?
Supreme Court dismissed it.
ಕೊಡಿ ಅದೆಲ್ಲ. ಇವಾಗ how old is the victim now?
17 years, 5 months.
Still not 18. And you are in custody.
No, my lord, I'm indulged.
You are on bail.
Yes.
ನೀತಿ ತೊಂದರೆ ಇಲ್ಲ. Yes. ಅದು ಯಾವತ್ತು ಹಾಕಿದೀವಿ? 9th? 9th ಹಾಕೊಂಡು ಜಾಸ್ತಿ ಇದೆಯಾ? 9th.
Age is, my lord, for framing of charges.
So what? Yes.
Copy to the judge.
9th. Settlement can undo that also, sir. Yes. Division bench ಇರೋದೇ doubt. Yes, sir. ಏನ್ ಬೇಕು?
24,
No stay, sir. Yes.
Recovery of a security deposit by the complainant from the petitioner. It says, agreement,
nine.
there is a page number 24 lease agreement which contains the arbitration.
We have to hear the complainants.
And the second one, my lord, there is a ex parte civil degree also been obtained by the party. It's purely a civil dispute.
No problems. 1 additional SPP, 2 emergent notice, 28th in the fresh matters, letter number by 28th in the fresh matters list. Yes,
Five.
Petition. Pursuant to the Office of Elections, I filed a memo to delete R1 and 3 to 6.
R1, 3 to 6. The respondent is, notice not R2 here. We have to hear the respondent.
And the petition.
I know. You're a builder.
Yes.
Home buyers are the complainants. Then,
The Axis Bank is the complainant. Home buyers are the Axis 1 and 2. They have taken the loan.
no, you have taken money of the home buyers.
No, ma'am.
Then what?
The A1 and A2 have taken loan from the complainant,
Hmm.
and under the tri-party agreement, the amount was.
Yes, that is true. It was supposed to be fulfilled by you. It's a tripartite agreement.
They have defaulted the loan. and
Who has
they have been-
defaulted? Who has defaulted?
A1 and A2, they were supposed to pay the loan amount.
You are not a party to the tripartite agreement?
But
Anything else? Sir?
there are three connected.
Codis.
Yes.
Yes. Tag this petition along with so and so. List them all on 28th.
R1 and 3 to 6 maybe.
The Land Council for the petitioner, a memo has been filed to delete R1 and 3 to R6. The memo is accepted, so and so deleted at the risk of the petitioner. Petitioner to amend the cost title accordingly. 26 in the meantime. Next matter. 25 ಆಗಿದ್ದೀಗ. Next matter 26 in the meantime.
57.
Two FIRs on the same.
Yes.
The husband is the complainant lord in this and wife is the complainant in this and husband. Annexure E is the first FIR, page 57.
Heard the learned counsel appearing for the petitioner. Idu 27, madam. The learned counsel Sridhar Prabhu takes this court through an order passed in writ petition 3481 of 2022, staying further proceedings in CC 14666 of 2021, which is registered by the wife,
Which is registered by husband.
which is registered by the husband. Then comes the impugned FIR by the wife for the very same allegations. In that light, there shall be an interim order of stay of further investigation. CC ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Further proceedings in CC 27961 of 2023 till the next date of hearing. 1 additional SPP, 2 emergent notice.
28.
MMRD.
Admittedly, there is license in the name of wife, my lordship, and they have not found anything to seize the.
Locations
Location. ಅದು ಇವ್ರದ್ದು.
ಅಲ್ಲ. Government ಜಾಗದಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ.
Entire, it is 51 survey number is entirely government
No,
land.
no, let him see. Learned additional SPP is directed to accept notice for the respondents.
Already direction.
Huh?
Already direction.
Already directed.
ಹೌದು.
List the matter in the fresh matters list. ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ.
Yeah.
Oh,
24,
long back
4
ಆಗಿದೆ.
lakh.
ಹೌದು.
ಇದ್ಯಾಕ್ fresh matter ಬಂತು ಮತ್ತೆ?
ಮೊನ್ನೆ reach ಆಗಿರ್ಲಿ.
Yes, government. We'll post it for admission.
Lordship, there is charge ಇದೆ. Because there is no lordship with
Yes,
seizure.
government.
The government land ಅಲ್ಲಿ ಮಾಡಿ.
ಕೊಡಿ.
License ಇದೆ sir. The
Yes.
license.
List on 20th in the fresh
Kindly
matters.
see,
list.
lordship, page number 31.
ಇದಿರ್ಲಿ, list on 20th in the fresh matters. list. Yes. ಯಾವುದು? ಇಲ್ವಾ? ಎಲ್ಲೋದ್ರು? ಎಲ್ಲ ಬರೀರಿ. In the meantime ಅಂತ ಬಿಟ್ಬಿಡಿ. ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂದ್ರೆ.
29.
ಮೇಡಮ್, 27 ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಲ್ಲ? ಚೆಕ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ. ನೋಡಿ. Yes, sir.
Lord, this is the petitioner who is accused number 2 before the FIR, my lord.
Stay is already there in it.
ಹಾ?
There is stay in this case.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
Stay ಇದೆ sir.
15th.
It was issued.
ಮತ್ತೆ ಯಾಕೆ ಬಂತು? List the matter for admission on 29th.
Interim order may kindly be.
Interim order subsisting shall continue to the next date of hearing. Next.
30.
The petitioner is accused number 4. The issue concerns waiver of loan, which the accused number 4 in terms of law has waived the loan. That has now become an offense punishable under section 409 inter alia against the petitioner. In the light of in that light, there shall be an interim order of stay of further proceedings only against accused number 4 till the next date of hearing. 1 additional SPP, 2 emergent notice.
31,
Next. ಇದೆಯಾ? ಇಲ್ಲ. ಶ್ರೀಧರ್ ಪ್ರಭು ಹೇಳ್ಬೇಕಂತ. ಹಾ. Very good. Yes.
198, the petitioner is accused number 3.
A3,
Friend of you, not a family member.
yes, in the meantime,
32,
BVK ಗೊತ್ತಾಗುತ್ತಲ್ಲ, in the meantime ಅಂತ. ಪಂಚನಾಮ FIR ನೋಡಿದ್ರ?
ಇಲ್ಲ ಇದೆ ಪಂಚನಾಮ.
ಕೊಡಿ. ಅಲ್ಲಲ್ಲ, ವೆದರ್ crime can be registered on a ಪಂಚನಾಮ. Justice ರಾಚಾರ್ಯ ಒಂದು ಜಡ್ಮೆಂಟ್ ಇದೆ, ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ.
In that matter, that is on the issue of conviction. We are looking at.
Conviction is set aside on that ground.
That's correct, my lord, but I must say, my lord, that the 2 judgments of Supreme Court have not been followed.
ಕೊಡಿ.
I'll put it.
Yes. We'll list it on 20th in the fresh matters list. Till the additional SPP would secure instructions, there shall be an interim order of stay for the proceedings by the petitioner.
Yes.
33,
ಅವತ್ತು ಮುಗಿಸ್ಬಿಡೋಣ. If it is contrary to Supreme Court, which I am also 100% sure it's contrary to Supreme Court.
The only difference.
100% sure it is contrary to.
The only difference, my lord, there should be information cognizable regarding cognizable offense. Otherwise, my lord, it can be registered.
We'll see. Yes. 30.
33,
At the learned senior counsel GK Bhatt appearing for the petitioner. 1 additional SPP, 2 emergent notice. The issue in the list pertains to an offense under section 309 of the IPC, which is an attempt to commit suicide.
306, ma'am.
306 ಆಗಿದೆಯಾ? 309 ಮಾತ್ರ ಇದೆ?
Hospital, they have shown his name even after his death. And perhaps.
Where is the charge sheet filed?
Page 42, ma'am.
ಬರೀ 309 ಆದ್ರೆ ಬರಲ್ಲ, 306 ಅಂದ್ರೆ ಕಷ್ಟ. You are the.
He died in the hospital. He himself is the complainant. And perhaps as the registry instructed, insisted, he shown as respond number 2 also in the petition. Should be
Who has
deleted.
instigated?
That is, the case is that he says that he comes to the wife's place, pours the petrol on himself.
ಅದೇ ಅದು ಗೊತ್ತು. It was the attempt to commit suicide.
ಮಗನ್ ನೋಡಕ್ ಬಿಡ್ಲಿಲ್ಲ, ಮಗನ್ ನೋಡಕ್ ಬಿಡ್ಲಿಲ್ಲ.
He
Wife
says
ಬಿಡ್ಲಿಲ್ಲ.
it's not your son. There is absolutely no material liability. And he is MBA, MA and wife is MBA, such a qualified people.
ಅಲ್ಲ, ಅದು qualified people are all crimes are now registered against them only because inflated egos.
And the
ಅಷ್ಟೇ,
marriage takes
ಬೇರೆ
place
ಏನಿಲ್ಲ.
when he was in a rented house between
All educated, highly educated. Like egos are also king size.
For the present, may lords may please to canter it.
But if it is 306, then difficult, sir.
They have made it.
I thought it is 309.
And even though his name is not deleted, he is cited as CW1.
Page 42, ma'am.
42.
Column 17 of charge.
Page?
42.
ಏನಿದೆ?
This speaks about the role of A1, A2 and A3. ನನ್ನ ಮಗಳ ನೋಡಲು ಬಂದಿದ್ದು
Before the-
ತೋರಿಸಲು
before-
ಕೇಳಿದ್ದಕ್ಕೆ A1,
A1
A2.
is not before the honorable wife is not here. Mother and
Why, what would mother and
brother-in-law.
husband ನೋಡ್ಕೊಳ್ಳಿ? Vice. The petitioners are accused 2 and 3 ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಅದು ಹೊಡೆದಾಕ್ಬಿಡಿ. Initially, a crime comes to be registered for offense punishable under section 309 of the IPC, which is an attempt to commit suicide. It transpires that the husband of accused number 1 commits suicide in the house of the wife on the score that he was not let to see the child, as there was a dispute between them. In the crossfire, the mother-in-law and the other family member is drawn into the web of proceedings for offense punishable under section 306 of the IPC as the husband of accused number 1 dies. Therefore, there shall be an interim order of stay. At best, the offense should be answered by the accused number 1, the wife who did not let the husband to see the child, which has led to commission of suicide. The petitioners accused number 2 and 3 cannot be proceedings against accused number 2 and 3 cannot be permitted to be continued. Therefore, there shall be an interim order of stay of further proceedings qua this petitioner till the next date of hearing. These petitioners, 2 and 3, emergent, 1 additional SPP, 2 emergent notice.
Be permitted to be deleted from the.
Yarna?
A2, that is respond number 2. He died even before, my friend has filed the petition. Perhaps the
But
office
who is the
desisted.
complainant? But complaint continued ಅಲ್ಲ.
ಅವನು ಇಲ್ಲಿ some ಮುಂದೆ.
ಅವ್ರ ಮುಂದೆ ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ ಮಾಡ್ಬಿಟ್ಟು who is the de facto now, who becomes the de facto complainant?
We'll have to see if any other.
The state
legal-
will have to
State.
delete ಮಾಡಿ. Learned counsel for the petitioner seeks leave of this court to delete the second respondent complainant as the complainant is no more. Yes. Since the charge sheet is filed, the state will have to defend the action. Yes, next. So emergent notice, second respondent ಬೇಡ. Additional SPP 1 ಅಷ್ಟೇ. ಆಮೇಲೆ ಇದು ಬರೆದ್ಬಿಡಿ. Yes, next.
34. Petitioner, my lord. I'm filing memo with liberty to file discharge application.
Charge frame ಆಗಿಲ್ವಾ?
No, my lord.
Counsel for the petitioner files a memo seeking to withdraw the petition.
With liberty to file
Yeah.
discharge application.
ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಹಂಗೆ? In terms of the memo, petitions stands disposed as withdrawn.
5.
Lord, this matter, my lord. Release of funds.
31 lakhs.
In this case, not my.
31 lakhs has come to your account.
Not to my, it
Huh?
has not come to my account. In this case, I have sought for broad case against the fraudster. There's a freeze account, freeze in my favor. The trial court may not.
Yes, look,
without-
He's the one who lost the money. The notice has to go.
I have lost the money, when a notice has to be ordered.
You also lost the money?
Please, my lord, what has happened, your lordship will see the order at page number 56. Translated copy I have produced.
Then we'll issue notice,
Please,
emergent notice to the respondents returnable by 28th.
pledge, please.
Next. 1 ನೀವು ತಗೊಂತೀರಲ್ವಾ?
Yes.
Oh, sorry, 1 additional SPP, 2 and 3 emergent notice returnable by so and so date.
Pledge, please.
36,
36.
same as, which is that serial number?
36.
Which is the earlier one? Huh?
19.
Same as 19, tag the 2. 19 lane ಬರೆದ್ರೆ ಅದೇ ಬರೆದ್ರೆ. Yes.
37.
For petitioner in this case, my lordship. As that certain direction has been issued to the respondents, my lordship. Offense is of the year 2016. Complaint is filed in the year 2021 for the cheating, my lordship. Tampering of the sub-registrar records, my lordship.
ಇದರಲ್ಲಿ
No official have been.
No, I have said
CC
3 years.
number.
ಏನ್ ಮಾಡಿದೀರಾ ಇಷ್ಟು ವರ್ಷ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಸ್ಕ್ರೂಟಿನಿಗೆ ಹೋಗಿದೆ. CC number charge sheet has gone to scrutiny.
How many years you have taken? 4 years.
They have some records which requires to be.
What records? Tampering of records ಅಲ್ಲಿ ನಿಮ್ಗೇನು ಇಷ್ಟು 3 ವರ್ಷ ಬೇಕಾ? ಅಲ್ಲ ಬೇಕಾದ್ರಲ್ಲೂ 15 ದಿವಸದಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಿರಲ್ಲ. ಯಾಕೆ 24 hours ಅಲ್ಲಿ ಹಾಕಿದೀರಾ? hours ಅಲ್ಲಿ ಹಾಕಿದೀರಾ?
ಹಾಕ್ತಾರೆ.
ಮತ್ತೆ?
Sought for interim order, my lordship,
Yes.
because.
Produce all the records. The learned additional SPP to
Secure
secure
the records.
the records and
Secure
place
the
it
record.
for a perusal of the court. Give it.
Now the
Yes.
charge.
List the matter on 21st till such time further
It is
investigation.
gone for scrutiny. Charge sheet is already.
Till such time further proceedings, further investigation shall remain stayed. Next date, no.
Please.
Yes, list on 21st in the fresh matters list.
I'll place this material.
Kudi. The original records are placed for perusal of the court. The same is taken into the file. ಅದ್ ಬರ್ದ್ಬಿಟ್ಟು ಆಮೇಲೆ
38.
In this case, my lord.
ರೀಫಂಡ್ 15 ಲಕ್ಷ.
Please.
ಯಾವಾಗ?
I filed an application to the.
No, 451, 457. ಬಟ್ ಅದು ಬೇರೆ ಕ್ಲೇಮೆಂಟ್ಸ್ ಇದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಬೇರೆ ಬಟ್ 45 ಲಕ್ಷ ಇದೆ ಅದರಲ್ಲಿ. ಫೀಸ್ 45 ಲಕ್ಷ ಆಗಿದೆ.
ಅಲ್ಲ ಟೋಟಲಿ
And there is
ಎಷ್ಟು?
no application
ಜಗದೀಶ್ ಅವರೇ,
for-
you should look into it and tell me.
Notice has.
ಟೋಟಲಿ ಎಷ್ಟಿದೆ?
Notice has.
ಟೋಟಲ್ 45 lakhs ಇದೆ. ಅವರು ಜಯನಗರದಲ್ಲಿ ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ನೋಟಿಸ್ ನೀವು ಒಬ್ಬರೇ ಇರೋದು.
ಅಲ್ಲ, they have not made a bank as a party. And
Bank party ಮಾಡಿ.
tomorrow bank will come and say that.
Petitioner to implead. Which bank is it?
IDBI.
IDBI Bank as a party respondent to these proceedings. ಈಗಲೇ amend ಮಾಡಿ.
Please.
The emergent notice to the second respondent. Next.
39,
So it's a matter pertaining to the Unishare housing scam. Unishare housing scam.
I am
ಅದು ಬೇರೆ matters ಎಲ್ಲ ಇದೆಯಲ್ಲ.
ಎಷ್ಟಾಗಿದೆ? 780 gets rest of the batch matters are coming.
Numbers ಕೊಡಿ.
5922 of 2025.
Not, A1 they need to come this cap.
We'll see, sir.
I am a bona fide, in the connected matter, you will lordship.
You're a purchase, ಇದ್ರಲ್ಲಿ stay ಕೊಟ್ಟಿದ್ದೀವಿ connected
ಹೌದು,
matter.
stay ಕೊಟ್ಟಿದೆ.
ಕೊಡಿ.
Yes.
Tag this petition along with so and so. There shall be an interim order of stay in the light of the interim order subsisting in the companion petition. The learned counsel with the second respondent submits that all identical matters are listed on
7th of this month.
list
7/8.
list on 7/8 along with WP, a current
Criminal petition 5922.
criminal petition 5922 of 2024.
Which is my name may be shown for
Registry
file
to-
vakalat.
Registry to print the name of
Ayappa KG.
Ayappa.
KG.
Ayappa KG is appearing for
R2
the
and R3.
second respondents 2 and 3.
The
Yes,
petition will be
next.
directed to serve a copy of the petition.
Petitioner to serve set of papers upon the aforesaid council. Yes, next.
Grateful.
Idu type.
40,
Compliance of office objection, my lord, the copy of PCR is. Yeah, state.
Can dismiss for non-prosecution. ಯಾವ stage ಅಲ್ಲಿ?
Complaint evidence.
So ಇನ್ನು accused had not appeared.
Here that appeared, my lord, NPW was issued. Thereafter,
Accused appear ಆಗಿದೆ, then we'll have to issue notice.
notices.
Yes. Emergent notice to the respondent returnable by 28th.
So objection.
Office objections. ಏನದು?
PCR copy ಬೇಕು, constantly ಬೇಕು.
ಇದನ್ನು registry file ಮಾಡಿ. Learned counsel submits in the course of the day. Office objections would be complied with. The submission is placed on record. Yes, next.
Plus.
ಅದು ವಾಪಸ್
45.
ಕೊಟ್ಬಿಡಿ.
For the petitioner, my lord. Yes, your lordship had directed the state to
80 to 80. Sub-registrar.
Yes. Paper. sir.
ನೀವು sub-registrar ಅಲ್ಲ.
No, I am the complaint is filed against me, my lord.
Ah,
Second-
correct.
Second respondent is the sub-registrar.
Complainant is a sub-registrar.
Complaint.
Yes, sir.
ಖರಾಬ್ ಜಾಗನ ಸೇಲ್ ಮಾಡಿದೆ.
Now, my lord.
Look into the records and tell me.
Cut, sir.
Learned additional SPP to, ತಗೊಳ್ಳಿ, ನಾನೇ ನೋಡಿದ್ದೀನಿ record. Take it. Place the matter for admission. The additional SPP to secure instructions and make submissions on the next date. List on 27th in the fresh matters list. Yes.
42,
Explosives.
Explosives, your lordship. He was not there, your lordship, because he was out of country, your lordship.
Who was out of country? Land nimde?
Land, your lordship, it's granted by the KDB.
No, no, no.
And I was given the contract to.
You
someone-
may have been elsewhere. That's a different thing. ಯಾರಿಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Persons were taken the blast, your lordship, it's a construction work I have given to them. ಪಾಯ ಹಾಕೋದಕ್ಕೆ ಕೆಲಸ ಕೊಟ್ಟಿದ್ವಿ ನಾವು. KDB has been granted the land.
Yes.
ಪಾಯ.
Sir, but he is the owner of the property.
ಅಲ್ಲ, other than being the owner, what else?
Elaborate, just check me now what trans.
Additional SPP is directed to accept notice for the respondents. The petitioner submits that he is the owner of the property who was in the United States of America at the time when the
UAE.
UAE, United Arab Emirates, at the time when the incident takes place. It is a submission that he had issued a contract in favor of the other accused who have indulged in the offense that would become the ingredients of the ones punishable under the Explosives Act. Based on the said submission, in the light of the said submission, there shall be an interim order of stay, quay accused number 1 only, till the next date of hearing. CC ಆಗಿದೆಯಾ? ಆಗಿರುತ್ತೆ.
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಆದ ತಕ್ಷಣ ಆಗುತ್ತಲ್ಲಿ. So it is made clear that further proceedings against the other accused shall continue.
43,
I am appear for petitioner in this case, my lord. Punishable offence under section 306.
306, mother-in-law,
Charge frame.
charge frame ಆಗಿದೆ. ಯಾವತ್ತು?
12/7/2020.
Last date of.
12/7?
2024.
Last date of hearing,
Last date?
last date of hearing, before filing.
4th June 24. But as on today, charge is framed.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಏನು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ ಇದ್ರ ಬಗ್ಗೆ. ಆಮೇಲೆ ನನ್ನ ಮಗ ಲವ್ ಮಾಡಿದ್ದಾನೆ ಅನ್ನೋ ಒಂದೇ ಉದ್ದೇಶಕ್ಕೋಸ್ಕರ
But
ಅಷ್ಟೇ ಇದ್ರಲ್ಲಿ.
ಏನು travesty ಆಗ್ಬಿಟ್ಟು.
ಅಲಿಗೇಷನ್ಸ್ ಇಲ್ಲ, ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ.
Direction may be issued to dispose of early.
No, we should make some distinction. See, if file ಆದ್ಮೇಲೆ charge frame ಮಾಡಿದ್ರೆ something has to be done. Petition is filed on 4th June
Yes.
because there is no allegation against the mother-in-law or whoever the petitioner is.
A2.
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 A1 ಲವ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಡಿಸೀಸ್ಡ್.
A1 is different. A2 is the mother of A1.
ಅಲ್ಲ ಅಲ್ಲ,
ಮತ್ತೆ?
ಡಿಸೀಸ್ಡ್ ಮಗಳನ್ನ ಲವ್ ಮಾಡ್ತಾ ಇರೋ ಮಗ.
ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು. A1 ಯಾರು?
A1 ಡಿಸೀಸ್ಡ್ ಲವ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ.
ಅದನ್ನೇ his mother ಅಲ್ವಾ ಅದು? Yes, comment.
They're not mother and son.
Just look into it. In petitions that are already filed and not posted before the court. For that reason, if charges are framed, ಇವತ್ತು ಯಾವ ತರ ಆ ಥರದ್ದಿತ್ತ ನೋಡಿ. Tomorrow in the fresh matters list. Yes. ನೋಡೋಣ.
54.
Lord, 138 complaint has been dismissed for.
ಅಲ್ಲಿ ಯಾವ stage ಅಲ್ಲಿ?
Lord, at the stage of evidence, my lord, evidence was commenced.
Then
Your cross-examined.
the respondent should be heard.
Lord, he has remained absent, my lord, throughout.
What to do, sir? It's stage of evidence and ಏನ್ ಮಾಡಕ್ಕ? Without hearing you can't.
You will not be available.
What to do? We'll see, one chance ತಗೊಳ್ಳೇಬೇಕಲ್ಲ. Emergent notice to the respondent returnable by the 3rd of September in the list on 3rd of September in the fresh matters. ಅವತ್ತು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ we'll see. Yes.
45.
Petitioner is accused number 4.
Yes, your lord.
A perusal at the charge sheet ಆಗಿದೆಯಲ್ಲ?
Charge sheet ಆಗಿದೆ, your lord. Yes,
At
ಆಗಿದೆ.
perusal at the summary of the charge sheet would not indicate any offence, much less the ingredients of the offences under section 498A inter alia against the accused number 4. Therefore, there shall be an interim order of stay away accused number 4 till the next date of hearing. One additional SPP to emergent notice.
Much okay.
46.
In the meantime,
47.
For the petitioner, kindly pass on.
advocate,
Please, ma'am. Senior is engaged.
ಬರಲ್ಲ ಬರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Difficult to interfere. We should not entertain such things, sir.
On that, there are some factors.
No,
Member of
Yes.
family. Anil sir,
it's a matter of trials.
please.
Yes. It will, the institution is in danger if such things are permitted, it's not stayed. Not correct. Senior, I think, should not encourage such things.
Facts are different. Otherwise, the senior would have not.
No problem, I will
not
answer.
that appeared,
Yes.
well. He instructed me. you can-
I will answer it, no issues.
Good.
48 minutes. May I request this on Thursday,
48.
please?
Family tree problem.
Please.
Why did you give up?
Minutes.
Family tree ಅವ್ರದನ್ನ ತೆಗೆದ್ಬಿಟ್ರೆ ಹೆಸರು. You don't consider the respondent as family.
ಇಲ್ಲ, ಆಗಲ್ಲ sir. Because of the change in the procedure, my lords, the dead persons could not have been included. 2017 family tree, my lords, is also included. There we have shown. Previously, we have entered into a partition deed. He was also there. That is his father. Let it be on Thursday, minutes. Let it be.
List on 14th.
I'm obliged.
August.
49.
ಇಲ್ಲ ಇಲ್ಲ, 14th August. Yes.
Serial number 49 minutes. The advocate on record is not well minutes. Kindly minutes.
Interim order ಇದೆ.
Yes, minutes. Interim order. 164 all. It's a relationship for 8 years, minutes.
Even 164 ಅಲ್ಲಿ?
Other issues then.
What other issues, sir?
But you can see that.
ಆಧಾರ್ ಕಾರ್ಡ್ ತರ್ತೀನಿ ಅಂತ ಓಡೋದು ಅಂತ ಇರೋದಲ್ಲಿ.
ಅಲ್ಲ. Amount also.
ಅಮೌಂಟ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಾ?
Don't have instruction, my lords.
ಅದ್
Advocate.
ಬಂದ ತಕ್ಷಣ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ವಿಲ್ ವೆಕೇಟ್ ದಿ interim order, will get all the instructions.
Kindly, my lords, tomorrow also, my lords.
ಟ್ರ್ಯಾಕ್ಟರ್ ಟೇಲರ್ಗೆ ಅಂತೇಳಿ 1,50,000.
ಎಷ್ಟ್ ಟೈಲರ್ಗೆ?
ಹಾ.
ಆಮೇಲೆ
ಟ್ರ್ಯಾಕ್ಟರ್ ಟ್ರೈಲರ್ಗೆ.
ಹಾ.
ಆಮೇಲೆ ಮತ್ತೆ 30,000.
ಬಟ್ಟೆ 30,000. ಆಮೇಲೆ?
ಟ್ರ್ಯಾಕ್ಟರ್ಗೆ 1,50,000.
ಯಾವ್ದಕ್ಕೆ?
ಟ್ರ್ಯಾಕ್ಟರ್.
ಟ್ರ್ಯಾಕ್ಟರ್ ಯಾಕೆ? ಟ್ರ್ಯಾಕ್ಟರ್ ಕೇಳಿದ್ರ? ಆಮೇಲೆ ಎಸ್
ಮತ್ತೆ 30,000, ಮತ್ತೆ 20,000, ಮತ್ತೆ 1,00,000.
ಹ್ಮ್.
ಮತ್ತೆ 1,50,000.
ಟೋಟಲ್ ಎಷ್ಟಿದೆ?
4,500,000.
4.5 ಲಕ್ಷ. ಅದು ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
But kindly tomorrow, my lords, advocate on record.
ನೀವಲ್ವಾ?
No, my lords, I am not.
Tomorrow in the fresh matters.
Thanks.
If you don't return to 4.5 lakhs, I will permit trial.
Interim order may kindly be extended.
Interim order subsisting will continue till the next date of hearing.
Great.
Relationship ಎಲ್ಲ ಇಟ್ಕೊಳ್ಳಿ. 376 will set it aside. 420 I will hold you. Yes,
Great.
next.
The petitioner, Your Honor. Offences are punishable under section 138.
Serve ಮಾಡ್ಲಿಲ್ವಾ?
It is served.
List on 22nd, 28th in the fresh matters list. Till such time further proceedings before the concerned court shall remain stayed. Next.
P1,
Proceedings, my lords, husband, my lords. Lords, in-laws, my lords, have got stayed, my lords.
In-laws have got stay.
Please.
Correct, sir.
That may, this matter may be connected with that matter.
In-laws matter.
Please.
Husband is independent. Sir.
Please.
Let him be independent. Yes. On additional SPP, HCGP, 2 emergent notice.
Connected with my lords, criminal.
ಬೇಡ ಅದನ್ನ it is made clear pendency of the proceedings against the husband shall not hamper investigation or proceedings against him. Yes. ಅದ್ ಯಾಕೆ ಅಂತ ಕೇಳ್ತಿದ್ದೀರಾ ಅಂತ ಗೊತ್ತು. ಅದು ಸ್ಟೇ ಆಗಿದೆ, ಅದ್ರ ಜೊತೆಗೆ ಇದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಕೇಳೋಣ. ಅವೆಲ್ಲ ಬೇಡ. ಎಸ್
13 plus 52.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
Charge frame ಇಲ್ಲ, but charge
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ಅದ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
1/8, my lord, a charge sheet is submitted to the.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಯಾರನ್ನೋ ಎಂಗೇಜ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಈ ತರ ಪೀಸ್ ಮಿಲ್ ಅಲ್ಲಿ ಪರ್ಮಿಟ್ ಮಾಡಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ರೆ
ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ, ನಂಬರ್ ತಗೊಳ್ಳಿ ಅವ್ರ ಹತ್ರ. ಪಾಸ್ ಓವರ್.
1/8 submit.
53,
1/8 submit.
Petitioner 1 ಗೆ party in person, 2 and 3 ಗೆ advocate. Yes, what's all this?
53.
Number ಆಗಿಲ್ಲ.
The petitioner read in accused number 2.
ಹಾ,
He is not a party to the any financial transaction.
ಯೂನಿಶೇರ್ ಫ್ರಾಡ್ ಸರ್ ಇದನ್ನು.
ಯೂನಿಶೇರ್ ಇದ್ದಾರೆ, ಇವರು ಬ್ರದರ್ ಆಗಿರೋದಕ್ಕೆ ಇವರು ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಯಾವ್ದು ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಇಲ್ಲ. He is not a signatory to the agreement. He is not a director of the company.
My lord, even
Let's see.
in this matter, my lord, charge sheet is ready, my lord. Today or tomorrow, my instructions are they will submit.
Now you get the investigation papers, look into the role of this
Please,
petitioner.
my lord.
Whether all these tripartite agreement you are not a party?
ಇಲ್ಲ.
No, we'll see. At 7th, list on 7th.
54,
For the petitioner, my lordship.
Praveen, CC of 2018 ಏನಾಗಿದೆ ಸ್ಟೇಜ್?
My lord, charge
Now is in charge sheet state, my lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಟೇಜ್.
Yes, my lordship.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
frame ಆಗಿದೆ.
Frame ಆಗಿದೆ.
Charges frame.
We have just received the summons for it now.
ಯಾವತ್ತಾಗಿದೆ? If it is after the filing of the petition,
My lord,
check.
charges were framed on 29/7/24, my lord.
After filing of the present petition, my lordship.
29/7/24.
Yes, my lord.
Correct, ah?
29/7/24. Correct.
Yes. In the meantime, yes,
Right.
we'll make a distinction. Charge, file ಆದ್ಮೇಲೆ charge frame ಆಗಿದ್ರೆ we'll entertain. Sridhar Prabhu ಅವರೇ,
Extremely sorry, my
Ah.
lord. I'll file it right now, my lord, at 2:30.
what is this?
Extremely sorry. So sorry.
ಅದನ್ನೇ ಮರ್ತು ಬಿಟ್ರೆ ಹೆಂಗೆ ನೀವು?
So sorry. 2:30, your lordships may have. I'll just have it signed, but I can't.
Cricket match without the bat.
I
Yes.
apologize.
Yes, sir.
55,
ಬೆಳಗ್ಗೆಯಿಂದ ಅದು ಜಗದೀಶ್ ಅವರೇ, ಬೆಳಗ್ಗೆ ಕೆಲವು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಆಫ್ಟರ್ ದಿ ಫೈಲಿಂಗ್ ಆಫ್ ದಿ ಪೆಟಿಷನ್ ಯಾವುದೋ ಒಂದೆರಡು ಇದೆ. ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ ನೋಡ್ತೀನಿ ನಾನು. If that is the case, then I will grant stay in those. If they are entertainable, otherwise.
Challenge is only for the quantum, 20,000 has been awarded.
125 proceedings. Husband, ಎಷ್ಟಿದೆ arrears?
Cleared 50% of the due, my lord.
ಎಷ್ಟಿದೆ? ಮಿಕ್ಕಿದ 50%.
I'll deposit.
How much?
Around 75,000 have to. 80,000.
The emergent notice to the respondent, interim order. There shall be an interim order of stay of the impugned order, subject to the condition that the petitioner would deposit 50,000 rupees before this court in the next 2 weeks.
3 weeks.
In the next 3 weeks, list the matter on 29th in the fresh matters list.
Much obliged.
Yes, next. Well, 28th.
56,
Lord, Forest Act, my lord, section,
ಅದಾಯ್ತು 1991.
due to the wrong address has been mentioned.
What wrong address?
The
No, sir. ಈಗ ಗೊತ್ತಾಗಿದೆಯಲ್ಲ right address, finish trial and come.
And one humble submission, Lord. In this case, the 62C is a mandatory provision, my lord. When they have. to
I
issue
will
the
not
certificate-
entertain this plea after 30 years. 30 ವರ್ಷ ಏನ್ ಮಾಡ್ತಿದ್ದೀರಾ sir?
He was absconding, my lord. Was a pending case. He was not here.
ಇದು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ಬೇಕು ತಾನೆ. 30 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಇವ್ರು ಟ್ರಯಲ್ ಮಾಡೋದು ನೀವು? 1998 is the charge sheet.
91.
91 is the 91, sorry.
My lord, where the.
ಅಲ್ಲ absconding ಅಂದ್ರೆ
available, my
ಇಷ್ಟು
lord.
ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿರ್ತೀರಾ? Now.
That.
ಏನ್ allegation? Then we will have to hear all his arguments on merits because of your delay.
My lord, in this case, my lord,
So, you
it was
know,
kept pending, my lord, as a.
What
long
is kept pending,
case.
sir?
He was not available, my lord.
For 30 years he was not available?
NBW issue ಮಾಡಿ.
ಅಲ್ಲ 30 ವರ್ಷ available ಇರ್ಲಿಲ್ವಾ?
No, my lord.
How did he meet you now?
Lord, the thing is, the court is in Mangalore and the person is, the residence is not in the same jurisdiction. He is in Puttur Taluk, Upinangadi.
ಪುತ್ತೂರ್ಲ.
Puttur Taluk, Upinangadi.
Hmm.
And the address given in the address entered by the prosecution in the charge sheet is in wrong address, my lord. And therefore, my lord, the summons and
Information
warrant has
issued,
not been.
NBW issued, my
No
lord.
problem, yes. One, they learned, HCGP is directed to accept notice for the respondents. The charge sheet is of the year 1991. And the state wants to try this petitioner for offences under the Forest Act after 33 years of registration of the charge sheet, filing of the charge sheet. The learned counsel submits that the address mentioned in the charge sheet for communication by the state was erroneous, and therefore he has not received any notice till date. And when the first notice is NBW now, and when the NBW now is sought to be executed, has rushed to this court. Therefore, the reason for delay of 33 years in completing the proceedings would inure to the benefit of the petitioner. There shall be an interim order of stay of all further proceedings in CC 225 of 1991 till the next date of hearing. List after 4 weeks, no date, yes. ಇಲ್ಲೊಂದಷ್ಟು ವರ್ಷ ಇರ್ಲಿ.
57,
Lord. Section 125 proceedings, my lord.
Emergent notice to the respondent, there shall be an interim order of stay till the appearance of the respondent. List on 28th in the fresh matters list.
58,
Excise Act,
Excise Act.
same ground. ಅದು ಯಾವತ್ತಿದೆ ಮೇಡಮ್?
88, my lord.
8.
88.
List on 8th. ಅವತ್ ಮಾಡು.
Please,
Yes. Learned HCGP is directed to accept notice for respondent, list on 8.
59,
For petition. This is from Prajakumari Brahmakumari institution.
Huh?
Prajakumari Brahmakumari institution.
ಬ್ರಹ್ಮಕುಮಾರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
ಹೌದು.
ಏನ್ ಬ್ರಹ್ಮಕುಮಾರಿ
Actually,
ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್?
fund misuse ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ they have filed a complaint before
Correct.
the magistrate. The magistrate has referred to the police investigation. They have filed a charge sheet, filed the B report of Menarship. After the B report.
It is rejected, cognizance is taken on 27/2/2020. 4 years ಆಗಿದೆ. What were you doing till now?
Protest petition has been filed, Menarship. There has been allowed.
Protest petition ಆದ್ಮೇಲೆ cognizance ತಗೊಂಡ್ರು, ರಿಜೆಕ್ಟ್ ಮಾಡಿ B report.
There is no misuse, my lordship. They only transfer the only
Oh,
branch to Chitraduga branch, my lord.
That's a matter of trials.
They,
ಏನೋ ಹೇಳ್ತೀರಿ ಕೇಳಿ.
revision petition withdraw.
ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತೀರಾ?
There is civil dispute, my lordship.
Why, no,
There-
sir.
there is
Misuse
no
of funds, civil
The
dispute
peti-
act.
yeah, no, my lordship, complaint has transferred to the other branch, my lordship, due to the transfer of, they have filed a complaint against the.
Even otherwise, 4 years ago, cognizance is taken. Today, I will not interfere.
There is no frame of case.
No,
my
no,
lordship.
prima facie case, detailed order of cognizance.
The only for joint account, there is no misuse. The amount is transferred to the Chittorgarh branch, my lordship. There is no misuse, my lordship. All are members of the institution, my lordship.
Yes, sir.
This is only for joint account, joint order, my lordship.
Joint.
Joint account open.
Complainant yaru?
Complainant, one of the member of the.
Brahma Kumari.
Yes, my lordship.
Brahma Kumari Aishwarya Vishwa Vidyalaya.
Yes, my lord. She is transferred to other branch. The amount is only transferred to other account of the same institution, my lord. There is no misuse of the funds. my lord.
One HCGP, 2 emergent notes.
Stay, my lord.
No, 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವೆಲ್ಲ ಮಾಡಿ.
Next date appearing, my lord. So,
No, sir. Yes, next. Notice ಮಾಡಿದ್ದೆ ಹೆಚ್ಚು.
any date may be fixed.
List on
Next.
4th September. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
I represent the petitioner.
Petitioner is accused number 4, finding no allegation that would, no ingredient that would touch upon the offences against the accused number 4. There shall be an interim
Another
order of
matter
stay.
corrected,
So
madam.
accused number 1 to 3 na adu.
Accused number 2 and 3. madam.
Adu kodi, adu tag along with so on.
51,
399, 402, let's split up.
Split charge sheet, Friday.
Please.
List on Friday in the fresh matters list.
62,
Complete the order passed by sampling court, 10% I paid,
20%.
10%.
Stay ಮಾಡಿದೆಯಲ್ಲ?
Stay agreed. Interim order will continue.
List after 2 weeks, interim order subsisting shall continue to the next date of hearing.
63,
24 hours, we report.
Appearing for the petitioner.
You want time. It's 24 hours.
Yes, ma'am.
Yes, sir. Explanation ನಿಮಗೆ 24 hours ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹೆಂಗ ಹಾಕಿದ್ರಿ?
My lord, charge sheet is filed, ma'am.
Sorry,
24 hours.
charge sheet is filed in 24 hours. ಈಗ I told you ಅಲ್ಲ, charge sheet is not filed for 3 years, 4 years. 24 hours you file a charge sheet. ಯಾವ್ದ್ರಲ್ಲಿ ಬೇಕೋ ಅದ್ರಲ್ಲಿ charge sheet. ಯಾವ್ದ್ರಲ್ಲಿ ಬೇಕೋ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ. What consideration do you deal with? 24 hours you filed a charge sheet here. ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ರಿ 24 hours charge sheet file ಮಾಡಿ?
My lord, this is only for the offense 399, 402, my lord.
399, 402, sir, it is preparation
Only
for
6
dacoity.
witnesses, my lord. The 4 are the
No,
official
no.
witnesses.
Preparation for dacoity. 24 hours ಅಲ್ಲಿ you filed charge sheet. What is the investigation that the investigating officer did? It is rather shocking that there's so many cases, 2 years, 3 years, they have to approach this court saying expedite investigation. It only 24 hours. What explanation you have, sir? This is the problem. People lose confidence on police. ಎಲ್ಲಿ charge sheet ಕೊಡಿ.
My lord, against the accused number 4, my lord, in criminal petition 971522 is quashed, my lord. Is
ಆ ground
accused number
ಮೇಲೆ.
3.
ಆ ground
ಆ
ಮೇಲೆ.
ground ಅಲ್ಲ, only on the co-accused statement ಮೇಲೆ.
No, that's all right, but charge sheet file ಮಾಡಕ್ಕೆ investigation ಅಂತ ಬೇಡವಾ? Sorry,
Only 6 witnesses, my lord.
ನಾನು ಇದ್ದೆ, ಅವರು ಇದ್ರು. ಆಯ್ತು, ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಾ?
Yes, my lord.
ಇವ್ 24 hours ಅಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬಿಟ್ರೆ?
My lord, accused number 1 and 2 statement.
ಒಂದು ಯಾವ್ದು ಚೀಟಿಂಗ್ 454, 406, 420 ಇಲ್ಲಿ 3 years. Investigation is on and on and on. Yes, tomorrow in the fresh matters. We'll quash it tomorrow.
We'll produce the other copy, my lord. where
My lord,
accused
interim
number
order.
4 he also.
Interim order.
Continue ಆಗುತ್ತೆ, sir. Yes. Interim order subsisting will continue till the next date of hearing.
64, 64,
Yes.
charge sheet is filed, my lord. Summons are received, not served on the petitioner. My lord. And offense under section 379 IPC. My lord. I am the absolute owner of the property, my lord.
In the meantime, yes.
55.
The petitioners are accused number 2 and 3 in an offense alleged for, in an allegation for offenses punishable under section 498A of the IPC. Finding no allegation against these petitioners who are Mill and Phil, there shall be an interim order of stay of further proceedings. Quay these petitioners till the next date of hearing.
One submission. my lord.
Bedwa.
ಅದ್ರ ಜೊತೆಗೆ
ಹಾ.
matter is already settled before the mediation center.
ಈಗ ಸದ್ಯಕ್ಕೆ
And
ಸ್ಟೇ ಆಗಿರ್ಲಿ, ಎಲ್ಲಿ ಕರ್ಕೊಂಬನ್ನಿ ಅವ್ರನ್ನ.
ಅಲ್ಲ ಅದು matter is listed for 9/9 ಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಹ್ಮ್.
ಅವತ್ತು it is for full and final settlement is rupees 20 lakhs.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಆನ್ 9/9.
No, maybe on 25th of September, my lord.
ಆಯ್ತು, 25/9.
ಅದಾದ್ಮೇಲೆ we will.
List on 26th September.
26th September, and your lordship kindly consider
Emergent
for
one,
petition
CGP
number
to
1 as
emergent
well.
notice. Huh?
Kindly consider for petition number 1 as well, granting of.
Husband, settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ,
ಆಯ್ತು.
report sign
Against the
ಆಗಿದೆ.
petitioners ಅಂತ. The learned, ಹಿಂಗ್ ಮಾಡಿ. The learned counsel at this juncture would submit that the parties are before the family court, before the mediation and are in talks of settlement. In the light of the said submission, husband is before the court?
Yes, he is the.
Accused number
petitioner.
1.
Yes,
Either nodi. Therefore, there shall be an interim order of stay against the husband as well. Yes, list on 26/9.
66.
Petitioner is accused number 5,
Yes, ma'am.
finding no allegation that would touch upon the, finding no ingredient that would touch upon, finding no allegation that would touch upon the ingredients of the offences punishable under 447 and 34 of the IPC. There shall be an interim order of stay of further proceedings. Quay the petitioner to the next date of hearing.
Great, much obliged.
Let's appear for the petition, my lords. The fiancé of the petitioner has filed a case after when she herself has called off the marriage, my lords.
Herself,
She herself has called off the marriage. After that,
herself what?
Lord, she has cancelled the marriage.
What did you say earlier? Herself?
Herself has called off the marriage,
Scroll down.
called off, cancelled the marriage,
So what is scroll down?
cancelled, that's what.
All right.
Cancelled the marriage. my lords. Afterwards, there were some gifts has been exchanged that we requested to return. It was not returned. To that extent, we filed case against her before Jevada. After knowing to the case, facts of that case, after a lapse of 6 months without any explanations, she had filed the present case.
No problem. Return everything. Whatever was taken, you return.
Notice the second respondent has to return.
We'll see.
My lords, also, my lords, may kindly see the page.
One
number-
HCGP, 2 emergent notice. Returnable by the 4th of September.
In fresh matters, this my lord.
No, fresh matters, yes. List in the fresh matters, 5th September.
58.
Wish to appear for the petitioner, my lords.
Transfer petition, my lord.
Huh?
This has to go before quotal number 9. Transfer
Total
petition.
number?
Quotal number 9. This has to go before quotal number 9. Transfer.
407.
Transfer petition.
The registry is directed to place the matter before the bench having roster.
Please.
As the issue is transfer of the case from a court to another. Next.
59.
498A, my lord.
One illa, others yes.
Please.
But
Yes.
this charges are framed on
Charge-
26/7/20.
1 minute.
The
ಯಾವ
charge frame
petition
ಆಗಿದೆ.
ಹಾಕದ್ಮೇಲೆ ಹೆಂಗೆ?
Charge frame ಆಗಿಲ್ಲ.
1 ನಿಮಿಷ. Date.
My lord, after the filing of this petition, 26/7 charges framed. my lord.
Yes. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ಗಳು ಕಷ್ಟ ಬರೋದು. ಅಷ್ಟರಲ್ಲಿ ನೀವು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಇದೆಲ್ಲ ಆಗೋದು. And against the husband, no stay. The proceeding shall continue. Against others, there shall be an interim order of stay for further proceedings. Yes.
70.
Ashkan Kaushara.
For the petitioner in this case, my lord, ಇನ್ನೊಂದು connected matter ಇದೆ 7729 ಅಂತ ಹೇಳಿ.
ಎಲ್ಲ ಒಂದೇ ಸರಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. 2016 CC.
ಹೌದು sir.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ. ಸೇಮ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೇ ಸೇಮ್ ಅಫೆನ್ಸ್.
No. ಯಾವತ್ ಫ್ರೇಮ್ ಆಗಿದೆ?
ಒಂದು 20
February 2018 ಒಂದು 20th April 2018 ಅಲ್ಲಿ ಒಂದು ಮತ್ತೆ ಇನ್ನೊಂದು 27 September 2018 also.
Thank you, sir. But ಎಲ್ಲ 24 lakh ಇರೋ petition ಇದು. Will not. ಕೊಡಿ ಅದು ನಂಬರ್ ಕೊಡಿ, ನಾಳೆ ಎಲ್ಲ ಮುಗಿಸೋಣ. Tag this petition along with so and so, list them all tomorrow in the fresh matters list.
71.
Yes, sir. Nepal.
Milords, I'm filing an affidavit, Milords,
For what, sir?
to submit that the daughter is with the wife, Milords, with the mother.
The respondent is the complainant. She was granted custody of the child born from the wedlock between the petitioner and the second respondent. It transpires that the petitioner husband, contrary to the orders of the concerned court at France, flew to Nepal with the child. The learned counsel for the petitioner submits that his father was ailing and therefore he had to rush to Nepal.
He was in Nepal, he got the message that his father is unwell, because of which he came to India.
Oh, sorry. He had, madam, had, his father was ailing, therefore he flies from Nepal to India. The allegation is that he has violated the order of the concerned court of Paris, at Paris, as he had taken the child contrary to the court's order to Nepal and then to India. The learned counsel files an affidavit that the affidavit of the husband that the child is now with the wife. In that light, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. 1 HCGP, 2 emergent notice. The affidavit is taken on record anta ಮಾಡಿ. Yes, next. ಇದು 407, post before this bench having appropriate roster. Then 4 ಅಂದ ತಕ್ಷಣ ಎಲ್ಲ ಇಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. Yes.
53.
Accused, the petition is the accused number
Accused
8.
number 8.
8, my lord. There is no such allegation against the petitioner, my lord. The only allegation is that
No such.
his mobile number has been linked with the account of the complainant. That is the only
Comment.
allegation.
Please, my lord, the entire amount, my lord, has by virtue of the number been tagged with that account, my lord, the amount has gone to his account, my lord.
How much amount?
No. Account has not.
ಎಷ್ಟು ಬಂದಿದೆ ಸರ್ ನಿಮ್ಮ?
No, account has not been my account. The only my mobile number has been linked with our account.
ದುಡ್ಡು ಏನು ಬಂದಿಲ್ವಾ?
ಏನು ಬಂದಿಲ್ಲ. I have not received a single rupee.
Where is the investigation?
I had to secure, my lord, first time it is.
Secure.
Certain.
The learned
Day after
HCGP
tomorrow.
is directed to secure the investigation papers. The learned counsel for the petitioner submits that the petitioner, accused number 8, is not alleged of any offense as is alleged against other accused. The only instance is that his mobile number was linked to a particular account in which fraud has happened, alleged fraud has happened. Therefore, on that submission, there shall be an interim order of stay of further proceedings, further investigation, qua the petitioner till the next date of hearing. Gautam,
54.
page 37, same order. Yes,
With regard
tag
to
Madi,
the-
same. Yes, next.
75.
In the petitioner is accused number 2. Finding the allegations too trivial and frivolous for any further proceeding to continue, there shall be an interim order of stay of further proceedings, qua the petitioner till the next date of hearing. 1 HCGP, 2 emergent notice.
Post along with it, 6244.
Tag along with
Two.
swords. No date. Yes, next.
76.
Appear for petitioner. He is
Boxers,
accused number 3, my lord.
so words.
Against him, there is no allegations. Only, my lord, after lapse of 10 months, her statement was recorded against him in page number 73, my lord. Page number 73. In the second line, my lord, ದರ್ಶನಕ್ಕೆ ಹೋದಾಗ ಆತನ ತಾಯಿ ಮತ್ತು ಆತನ ಮಾವ ಅಲ್ಲಿ ಇದ್ದರು.
1 HCGP, 2 emergent notice.
My lord, the allegation is against the present
I'm not
petitioner.
saying, sir.
Please.
Yes. 2 emergent notice
A1 is still absconding, my lord.
returnable by the 11th of September.
Against him, there is no allegation, my lord.
No?
Sister.
Yes.
27.
504, 506 in the meantime. Next.
78,
My lord, after the intervention of the Human Rights Commission, my lord, in illegal custody of the petitioner from the respondent number one police, 2 crime has been registered by the respondent police, my lord. One case under the Prohibition of Charging Exorbitant Interest Act and another crime, my lord, for 380, my lord. My lord, in that case, my lord, your lordship, please to grant interim order, my lord.
ಇದು accused number?
Same accused, same respondent, my lord.
ಒಂದು crime ನಡೀಲಿ ಬಿಡಿ.
My lord, the allegation,
ನಡೀಲಿ.
the allegation against petitioner itself, my lord, the petitioner and respondent number 2 are business partners, my lord.
Tag this petition along with so and so. In the light of the interim order subsisting in the companion petition, there shall be an interim order in the case at hand as well. List on 11th in the fresh matters list. Yes, 1 HCGP, 2 emergent notice, same.
Not the case and counter case.
Counter blast.
Mine is first complaint, they registered. Yes, it's a counter.
Yes.
And there is a civil dispute between the parties. And there was an injunction in my favor. And Lord, the petition,
ಅವರು ಬರ್ಲಿ ಬಿಡಿ. Yes.
first petition is practicing advocate.
1 HCGP, 2 emergent notice returnable by the 10th of September, list on 10th September in the fresh matters list till such time. Yes. ಅದು ಬಂದ್ರೆ 2 ಕಾಸ್ಟ್ ಮಾಡ್ತೀವಿ.
Petition. But on 6-1, my lord, BDA demolished my compound. I filed complaint. On 11-1, they come and say that somebody has I have trespassed into the. Once the
Wait.
compound was constructed, my lord, the Argavati layout, several petitions were pending.
We'll have to hear the respondent.
And insofar as
1
petition number,
HCGP, 2 emergent notice. Accused number 2 first ಹಾಕಿ 1 ಯಾಕೆ ಕೆಳಗೆ ಹಾಕಿದ್ದೀರಾ? ಏಜ್ ಪ್ರಕಾರನಾ? Yes.
2 is consent. I make note. The 2 was, my lord, they had already relinquished her share.
We'll see. Yes.
In favor of the. So,
Emergent
as
notice
against-
returnable by. ಅಲ್ಲ ಯಾ ಸ್ಟೇಟ್ ಅನ್ನ ಎರಡೂನು
ಇಲ್ಲ ಇಲ್ಲ. we are
BD ಇರ್ಬೇಕಲ್ಲ.
BDA note is not.
Emergent notice to the second respondent returnable by the 4th September. Yes.
81,
OS ಹಾಕಿರೋದು ಯಾರು?
Now myself has been filed against the complaint
OS number.
himself and suit has been decreed.
Number.
Internal page 23, annexure D, your worship.
Number
OS
ಹೇಳಿದ್ರೆ
number
internal page 23 ಅಂತ.
831.
The petitioners are plaintiffs in OS 8231 of 2010, which is said to have been decreed. The offense in the case at hand is the one punishable under section 447 and 427. If the petitioners pursuant to the decree have been in possession of the property, it is ununderstandable as to how there can be a criminal trespass against their own property. Therefore, there shall be an interim order of stay of further proceedings square the petitioners till the next date of hearing. 1 HCGP, 2 emergent notice.
Much obliged.
82,
Cognizance order 13/2/2020, sir.
Please.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಪ್ರೇಮ ಆಗಿಲ್ಲ.
Anyway, 1 HCGP, 2 emergent notice returnable by 5th September.
Till stay. Till then stay.
No, sir.
3,
Yeah, in this case, my lord.
That's all right.
A1
4 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಬಂದ ತಕ್ಷಣ ಮಾಡಲ್ಲ
No,
ಸರ್.
no, A1,
That's all right. Cognizance order that is challenged is 13/2/2020. 4 years ಏನ್ ಮಾಡ್ತಾ ಇದ್ವಿ? Yes.
83,
ನಿಮ್ಮ ಹತ್ರ ಬಂದ ತಕ್ಷಣ ಅರ್ಜೆನ್ಸಿ ಆಗಲ್ಲ, ಕೇಸ್ ಹುಟ್ಟಲ್ಲ. 504, 506 in the meantime. Next.
84,
276B. ಸ್ಟೇ ಇತ್ತಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಯಾವ್ದದು? ಅದ್ ಬಂದಿಲ್ವಾ?
ಇದೆ ಇವತ್ತು ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ವಾ?
ಅಲ್ಲ ಇವತ್ತು ಬಂದಿಲ್ಲ ಅದು.
Tag this petition along with so and so 84, 85 same.
Yes.
Tag this petition and list them both, list them all on 21st September, 21st August in the fresh matters list.
ಅದು 28th
20th ಇದೆಯಾ? 20th August. Yes. Next.
Your Lordship, may kindly see there. 13th, there is a case in the trial.
ಪರವಾಗಿಲ್ಲ ಸರ್, ಎಸ್. ನೆಕ್ಸ್ಟ್
Other the case
20th
stay ಆಗಿದೆ,
ಅಲ್ಲಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ. ಎಸ್.
92 my lord, 82 and 20th. Started,
ಯಾವತ್ತಿಗೆ ಹಾಕ್ತೆ ನಾನು?
6th September.
20th, ಆಲ್ ರೈಟ್ 20.
Yes.
ಅಷ್ಟ್ರಲ್ಲಿ ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ಲ, ಸರ್ವ್ ಆಗಿರಲ್ಲ. ನೀವೇ ಮಾಡಿಸ್ತೀರಾ? ಮಾಡಿಸಿ.
86.
Ashkan. Next, you are A2. Accused number
Accused number
2.
2, ma'am. 490.
ಏನಿಲ್ಲ, ಸುಮ್ನೆ, yes.
Please.
States, yes, next.
87.
CCF 2016,
Charges
Your
framed, my lord, on
when?
5/11/22, my lord.
Yes, sir.
Your Lordship,
I will not interfere.
Your Lordship, an irregularity is that.
Maybe,
that
sir.
The trial court, without taking cognizance, has issued NBW against the said petitioner. Your
No
Lordship.
problems. What were you doing till now? Yes.
Your Lordship, also this entire dispute is essentially a
No,
civil
no,
dispute in nature.
Charge framed, Meenakshi Bala, all arguments you are there. And if petition ಹಾಕಿದ್ಮೇಲೆ charge frame ಆಗಿದ್ರೆ will entertain. Yes.
Please do.
Next.
88.
ಕಾವ್ಯ ಗೊತ್ತಲ್ಲ, ಮೀನಾಕ್ಷಿ Bala.
498.
80. Petitioner is mother-in-law, accused number 2, finding no so and so, Kashkan. Next. Same 18, A2 and A3, oh Kashkan, next.
90.
Oh, 89 ತಾನೆ, VP Kulkarni ಇದೆ. 90,
Minutes, for the petitioner minutes.
yes sir.
Minutes, the offense is under 354 of IPC minutes.
See page 39, sir, all offences are met. You are not audible, sir, please appear. List on 20th in the fresh matters list.
Minutes,
Next.
minutes. I'm a nursing student minutes.
Correct, sir.
I'm not a cleaner. That the allegation, there is no allegation against me minutes.
Yes. Page 39, sir.
Minutes, page 39 is Aadhaar card minutes.
Huh?
Aadhaar card minutes.
At 29, sorry. Summary ಯಾವ್ದ್ರಲ್ಲಿದೆ sir? ನಿಮ್ಮ
29.
ಪ್ರಾಬ್ಲಮ್ ಪೇಜ್ 4 ಪೇಜ್ ಹಾಕಿದ್ದೀರಾ ಒಂದೊಂದು ಪೇಜ್ಗೆ. ನಂಬರ್ 4 ನಂಬರ್. And CC of 2019 will not
But
interfere in
minutes,
this.
summons is served to me now minutes.
No problem. 1 HCGP 2 emergent notice list after 4 weeks.
No,
Pendency
stay
of
may
this
be given.
petition. Pendency of this petition will not come in the way of further proceedings before the concerned court.
Minutes, stay may be given.
No, sir, not a case for stay.
Minutes, no allegation minutes. I'm nursing student minutes. Also, there is no bus number stated in the complaint minutes.
Yes. List on 4 weeks, bada. List on 28th in the fresh matters list. Next.
91.
In the meantime,
92.
notice NDPS.
DPS
are based on the confession.
Huh?
Just frame,
Yes,
my
That
lord.
will see charge frame ಆಗಿ ಯಾವತ್ತು
24 to 24, that is.
petition file ಆಗಿರೋದು ಯಾವತ್ತು?
That is framed on A1 and A2. my lord.
Second,
A3 was abstaining,
charges are framed now.
but not on A3. my lord.
You are A3.
A3.
A3 ಮೇಲೆ ಏನಾಗಿದೆ?
A3 is.
The charges framed against all the 3
Ah,
accused.
yes, sir. You appear. You are absconding. You are absconding, is it? Why should I entertain? Yes. Charge framed. You want Latif to come?
Yes, my lord.
I
A
will
date-
pass over.
93.
Petitioner. Serial number 90.
ಏನ್ ರಿಪೋರ್ಟರ್ 4 ಕೇಸ್ ಇದೆ ಇವತ್ತೇನದು?
ಇದು 93, 95 and 111
ಹಾ, ಎಲ್ಲ ಸೇಮ್.
similar and one more matter have to have come. ಅದ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
93 numbers ಕೊಡಿ.
95,
ಆಮೇಲೆ
111.
tag all these petitions so and so. There shall be an interim order of 1 HCGP 2 emergent note. State illala?
State ಇಲ್ಲ.
500. Emergent notice to the respondent, there shall be an interim order of stay of further proceedings before the concerned court quay these petitioners till the next date of hearing.
That petition number I will.
Kodi. Tag this petition along with so and so. Next.
Much obliged.
94.
Listener, 494, my lord.
Out, sir.
Please, my lord. Here, my lord, complainant petitioner is lodged a complaint against the second.
No problems. A1 is the husband.
A1 is the husband.
Yes, sir.
350
Anything else, sir?
350, my lord. Second petitioner is practicing advocate. my lord.
Second petition will stay.
Even though after obtaining divorce, my lord,
One
engagement
tagoli
ceremony
ಸಾಕಿಲ್ಲ.
was,
Husband bigamy, I will never stay.
no, my lord.
No
Here,
problems.
my lord, here petitioner is the wife.
Which petitioner?
Here, my lord, petitioner is the, she is a doctor. She lodged a complaint against the second respondent. Second respondent
Who
is
is
the
the,
husband.
who is the husband?
Husband is second respondent, my lord. He lodged a private complaint against this petitioner is, my lord. She lodged a complaint in page number 26, my lord, against the husband and in-laws.
ಅದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ನಂಬರ್ ಕೊಡಿ.
Please, my lord. Criminal petition number, my lord. Challenged and obtain entry model in criminal WP number
ಕೊಡಿ ಕೊಡಿ.
16670.
Tag this petition along with so and so.
There is
List
a
them
entry
both
model.
on 28. There shall be an interim order of stay of further proceedings. Square these petitioners in the light of the interim order subsisting in the companion petition. Next.
Please.
95, adjourn 96.
Manjunath, page 25.
Yes,
ಎಲ್ಲ ಇದೆ.
There is a case and counter case, my lord. In the counter case, my lord, this honorable court has granted stay.
ಕೊಡಿ.
Lord, I have annexed the
Page,
orders at page number 83, my lord.
coordinate bench.
Please, my lord. Case and counter case. Dead relatives,
Can you-
property dispute.
Yes. Tag this petition along with page 83. Kavya, 83, same order. Next.
97.
In the
Yes,
meantime,
Please, publish.
98.
legal metrology. One HCGP.
ಇದರಲ್ಲಿ 78
ಗೊತ್ತಾಯ್ತು ಒಂದ್ ನಿಮಿಷ.
ಸಾರಿ ಅಲ್ಲ ಏನಾದ್ರು ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿ ಸ್ಟೇ
ಹಾ?
ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ನೊಂದು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ಅದರ ಕಾಪಿ
ಗೊತ್ತು, ಎಸ್.
ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ.
ನಂಬರ್ ಕೊಡಿ. Tag this petition along with so and so. One
6110/24
ನಿಮಿಷ ಸರ್.
ಕಾಪಿ ಕೊಡ್ತೀನಿ.
One HCGP. In the light of, tag this petition along with so and so, in the light of so and so. Next.
ಎಂಟ್ರಿ ಮಾಡಿ
ಸೇಮ್ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿದೆ.
ಇದ್ರೆ ಬರುತ್ತೆ. ಕೊಡಿ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಆಗೋಯ್ತು ನಮಗೆ ಅಂತ ಅಷ್ಟೇ.
ಈಗ ಬೇಡವಾ?
ಅಲ್ಲಿ ಬೇಕು ಅಂತ
ಮತ್ ಕೊಡಿ.
ಪಬ್ಲಿಷ್
ಹಾ.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಸ್.
59.
For the petitioner, my lords, he is a US citizen. Offense, my lords, under section 109, 324, 384, 448 and 506 and read with section 34, my lords.
108 and 110, two orders are there.
There are other, against accused number 1 and
That's
5.
what, madam. Page 108
Yes, my lords.
and page 110.
Yes.
Same tag, same order. Yes. In the meantime,
101.
one 138 ಹಾಕಿದಾರಾ? 101.
101.
ಇದು 420.
420.
138 proceeding ಹಾಕಿದಾರಾ?
Charge sheet is filed. Going to withdraw the petition.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಲಿಬರ್ಟಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. 138 ಹಾಕಿದ್ರೆ ಇದು ಬರಲ್ಲ ಅದಕ್ಕೆ. ಎಸ್. ಅದು ತಗೊಳ್ಳಿ. ಮೆಮೊ.
102.
Lord, kindly pass over the matter.
Pass over. Note. You tell him page 326, all the 326 is the offense, page 26. ನೋಡಿದ್ದೀರಾ?
Senior.
ಫೈಲ್ ಅಲ್ಲಿ ಸೀನಿಯರ್ ಹತ್ರ ಇದೆಯಾ?
Discharge application is also pending for hearing on discharge.
Yes. List day after tomorrow in the fresh matters list. Yes.
103.
I represent the petitioner in this case, my lords.
Hmm.
I'm the owner, I'm working for the owner of the stocks. I have been arraigned as A1 and the theft has taken place by the lorry driver and another person. Against whom FIR is registered.
ನಿಮ್ದಲ್ಲ ಸರ್ ಕೇಸು.
Sorry.
ಇದು 376 ಪೋಕ್ಸೋ ಅಲ್ಲಿ ಥೆಫ್ಟ್ ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನನಗೆ. ಐ ವಾಸ್ ಶಾಕ್. ಎಸ್.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಏನ್ ಸರ್?
17 years. At the time of incident, 17 years. He's 20 years.
20 years. ಎಸ್. ಎಲ್ಲಿ ಜಗದೀಶ್ ಹೋದ್ರ? 9th ಹಾಕಿದ್. List on
25th ಮಳೆ ಬರ್ತೇವೆ 25th ಗೆ ಮೇಲೆ
ಮಳೆನಾ?
presence of the parties.
ಎಲ್ಲಿದೆ ಬೇರೆ?
Mangalore.
Presence of party ಬೇಡ. First ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ. Learned HCGP is directed to accept notice for the respondent. List on 9th. ಆಮೇಲೆ party's presence will see. Next.
104,
Petitioner.
In the meantime, yes, next.
105,
354.
Yes.
No allegations.
Okay.
354A ಇದೆ.
Correct.
That is there.
Yes.
My submission is, my lords, the FIR is on 30th of May. 23rd of May, my lords, she has been issued a show cause notice. By, my lord, by me. But that is, my lords, may kindly find at page 47. 9 o'clock is the reporting time, my lords. Consistently beyond 9:30, even
We'll
up
see.
9:57. my lords. Second, my lords.
One
in fact,
HCGP, two emergent notice. 354 years.
For this reason, my lords. In fact, earlier also, there was another attempt made, my lords, to remove him from service. There was a KT order, page 54.
ಆಯ್ತು ನೋಡೋಣ, we'll see.
Could I kindly submit this, my lords? If the reports be covered, the investigation record
That
may
I will
kindly be
see.
called.
Learned HCGP to secure the investigation papers and place it for perusal of the court to the next date of hearing. List on 21st in the fresh, ಅಷ್ಟ್ರಲ್ಲಿ serve ಮಾಡ್ತೀರಾ?
We will do that.
Yes, emergent notice returnable by 21st. 21st, the fresh matters list, yes.
106,
For the petitioner, my lords. Lords, the petitioners have sold the property to the respondent in the year 2015. After lapse of 8
Heard
years.
the learned counsel appearing for the petitioner. A sale deed that is executed in the year 2015 is sought to be complained in the year 2023 without a speck of explanation of delay. In the issue which is purely civil in nature, the criminal law is set into motion after 8 years of registration of the sale deed. Therefore, there shall be an interim order of stay of further proceedings till the disposal of the petition. One HCGP, two emergent notice. Interim order stay of investigation. Next.
107,
Charge sheet ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, charge sheet ಆಗಿದೆ.
107,
For the petitioner, your lordship,
2 crores,
44 lakhs.
2 crores 44 lakhs.
Accused number 4 is arrayed in, sorry, your lordship, the petitioner is arrayed as accused number 4 in crime number 21.
What have you done?
Lordship,
What is your role?
I have just been advised to collect the money on behalf of complainant.
Why do you give unsolicited advices? That's
I
the
was
problem.
Asked to collect it as a friendly request, your lord. And that
Yes,
is all with my role
Government.
in the entire transaction, your lordship. I have not been made a party in the FIR.
One friend says, at the request of the other accused, she has only collected. It's a matter of trial, my lord.
Your lordship, I've been made a party in the
Heard the
charge
learned
sheet, not
counsel
in the.
appearing for the petitioner. The petitioner is accused number 4. The dispute is between the complainant and accused number 1 to 3, who have transactions to an amount of rupees 2 crore and 42 lakhs. The learned counsel for the petitioner, on the strength of the documents appended to the petition, would seek to demonstrate that the role of the petitioner, accused number 4, is only advising the complainant to collect the money. That, in the considered view of this court at this juncture, would not become an offense of 406 or 420 or any other that is laid against accused number 1 to 3. Therefore, till the appearance of the respondent, there shall be an interim order of stay of further proceedings. 1 HCGP, 2 emergent notice returnable by the 10th of September, list on 10th September in the fresh matters list. Yes, next.
108,
CC of 2018, Latif, ಏನಾಗಿದೆ?
Please attach
Huh?
proclamation order is
Proclamation,
passed. Lord, I
why,
am ready to appear before the court. Lord.
appear and come. Next date in.
Date, I'll inform the court.
Date and. ಇನ್ನೊಂದರಲ್ಲಿ your colleague had appeared. Charge frame ಆಗಿದೆ.
ಅಲ್ಲ, ನಮ್ಮ ಮೇಲೆ ಆಗಿಲ್ಲ. There's charge
See,
sheet
why you
itself.
were absconding? ಅದಕ್ಕೆ charge frame ಆಗಿಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ.
My name was not there.
Why no? Why should I entertain a petition of an absconder who is, that too after charges are framed? Anyway, pass over ಆಗಿದೆಯಾ?
Yes, my lord.
I'll surrender.
ಅದ್ರಲ್ಲ.
ಹೌದು.
ನಾವು ಸರೆಂಡರ್ ಆಗಿ.
Till then, Lord, petition may be deferred.
Lord, if it is trial is, if it continued, that the Lordship judgment, Lord, so for 67 of the NDPS Act is concerned. They accept the confession, nothing.
Adralla.
How?
But why were you absconding till now? Let me see.
That is only on the
Day
confession.
after tomorrow in the fresh matters list. Yav the seal number? 92. Idralli. When do you appear?
Next week, one more matter was listed on 20th, Lord.
Number kudi.
I'll.
Tag this petition along with so and so. List them both on 20. ಯಾವತ್ತಿದೆ next? ಗೊತ್ತಿಲ್ಲ. ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಆಮೇಲೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ. Please, yes.
Meanwhile, Lord.
Meanwhile, first ಕೊಡಿ ಅದು.
Lord, this proclamation order is passed.
You have not absconding, why sir?
Lord, notice was not served upon, and sections 82 procedure was not followed.
That's the problem. 82 procedure will never be followed.
Therefore, Lord, I am ready to appear, but Lord, if I appear, they will take him to custody.
There shall be, the respondent, there shall be an interim order of stay of the proclamation order that is impugned in the subject petition, subject to the condition that the petitioner would appear before the concerned court on the next ensuing date. In the event the petitioner would not appear, the proclamation order that is now stayed would automatically get vanished.
Next date is on 17/8.
17, ensuing date, i.e. 17/8/2024. Yes. List on
20th.
17/8, list on 20th, fresh matters list, yes.
109.
I'm for the petition.
Carlsberg beer,
Yes, my lord. I am the employee of Carlsberg Beer. My stocks have been stolen and I lodged a complaint. Now the police registers a case against me as accused number 1.
ನಿಮ್ಗೂ ಬೇಕಾಗಿತ್ತ?
ಅಲ್ಲ ಅದು ಬೇರೆನೇ ಇತ್ತು.
One HCGP 2 emergent notice. There shall be an interim order of stay of further proceedings quay the petitioner, further investigation quay the petitioner till the next date of hearing. List on 4th September. Yes. ಇದೇನಾ ನೀವು ಆವಾಗ್ಲೇ ಹೇಳಿದ್ದು?
Yes, yes.
Because it was concerning beer. Yes.
110.
Respondent in this. Pass over, will pass orders, please.
111 adjourned. 112.
They appear for the petition.
Husband.
Petition with number 1 is husband, madam.
ಏನಾಗಿದೆ?
The 498A.
Who are all? Who are they?
They are the petition number 2, 3 and.
Why have you got them? Settle ಆಗಿದೆಯಾ?
No, they are not.
Then why have you got them?
No, they are.
Huh?
No, they have come by volunteer. The volunteer have come, madam.
Voluntarily? Or you called them just see?
No. ನಾನು ಕರ್ದಿಲ್ಲ.
Yes. Husband has not come?
Yeah, husband.
Ask him to be there.
Yes, there, my lord.
Yes, yes. Yes, no husband.
Please.
All else. Kashkan, yes.
113.
I appear for the.
2016 CC, what has happened?
Without received summons, my lord. Page number 19.
NBW ಎಷ್ಟು issue ಆಗಿದೆ?
NBW. ಅಲ್ಲಿಂದ ಆಗ್ತಾನೆ ಇದೆ. ನನಗೆ ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ.
ಗೊತ್ತಾಗ್ಲೇ ಇಲ್ವಾ? NBW ಗೊತ್ತಾಗ್ಲೇ ಇಲ್ವಾ?
Not served the summons, my lord. On 25th.
Charge frame ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
Charge frame ಆಗಿದೆ.
86, 87.
Surrender ಆಗ್ತೀನಿ. Same day consider.
Proclamation.
Not followed the.
Next ಯಾವಾಗ? Date ಯಾವ್ದು next?
ಇದರಲ್ಲಿ split up ಆಗಿದೆ.
Split, acquit ಆಗಿರೋದು ಎಲ್ಲಿದೆ ಬೇರೆಯವ್ರದ್ದು?
Split up ಆಗಿಲ್ಲ.
Acquit ಅಲ್ಲಿ ಯಾರ್ದು ಆಗಿಲ್ಲ.
Acquit
ಅಲ್ಲಿ ಯಾರ್ದು?
Appear before the court. When is the next date?
Next date. Registry ಹೊಸದಾಗಿ ಇದು ಮಾಡ್ಬೇಕು.
Check ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿ. Tomorrow fresh matters. Yes. Get the date of get the next date before the court. Next.
114.
Petitioner, please.
For the third response.
Objections needed.
Please. The only ground which is sought in the
Respect to
petition.
I make one submission. Respondent number 3 is an informant, please, my lords. Respondent number 2 is the investigating authority has given me a clean sheet.
It was an expression of, my lords, it was a concern which was expressed by respondent number 3, that there is a crime which is taking place. At that juncture, respondent number 2, who is the investigating authority, calls me. All documents are provided to his satisfaction. My bank accounts which were seized has been voluntarily taken off, defreezed. But final report has not been filed, which gives me a clean sheet. That is why I am before this honorable court. If they say, respondent number 2 says, yes, a clean sheet is there.
Yes, sir.
My lord, I'll secure the investigating papers, my lord, in this.
R3 or Shanti Bhushan.
Please,
then
my lord.
Informant.
Lord, this is the, if your lordship recollect,
ROC.
this Sparrow.
Oh, it's Sparrow.
Similar. Similar. My lord, the only ground.
Account
which-
defreezing alla idu.
Please, the only ground which my learned friend has sought is that investigation is not complete. Let them complete the investigation. my
Allah, what has happened to the investigation?
I'll secure the papers.
The
After.
learned counsel Bharat Kumar submits that clean sheet yaar kotru mat nimge?
My lords, the CCB is saying, my lords, there were 8 people. They called me. After that, they
The
said, yes, they have
learned,
defrosted the account.
HCGP to secure the investigation papers and the stage of the investigation, place it before the court day after tomorrow in the fresh matters.
Great.
Yes,
My lords, Thursday, please. My lords.
Thursday, 8th, second list. Thursday.
Okay, Wednesday.
ಅಲ್ಲ Thursday ಬರ್ಲಿ ಅದೇ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ MPMLA ಡೇ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಎಸ್
115.
Muzaffar Ahmad. No representation. List on 20th in the fresh matters list.
Hundred and 16.
If you trouble the PDO, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? You can't do that.
Otherwise.
1 HCGP 2 complainant here, PDO ಅಲ್ಲ?
PDO.
2 emergent notice in the meantime. Yes, next.
Great.
117.
Madam, 2, 3, 4.
My lords,
No, one.
One, I just want to show one document. Insofar as earlier, after she left home in the month of March, in April, she given a complaint, my lords, that is page number 83, NCR, where she has taken, my lord, page number 83, my lords.
Page?
Yeah, 83. Annexure E. Where, my lord, she said only ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರಗಳಿಗೆ ತಾಯಿ ಮಾತು ಚಾಡಿ ಮಾತುಗಳನ್ನು ಕೇಳಿ ಅರ್ಜಿದಾರರಿಗೆ ಮಾನಸಿಕ ಕಿರುಕುಳ. There is no demand in this matter.
ಕಂಪ್ಲೇಂಟ್ ಯಾವಾಗ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಆಮೇಲೆ?
ಆಮೇಲೆ ಆಗಿರೋದು 11th ಗೆ 3/11/2023 PCR ಆಗಿರೋದು. And she left home in the month of March only. And one more complaint is 7/9/2023 to the DCP, my lords. Further, she made a complaint, de facto complaint, and there is no allegation.
Let
They
the-
herself shared.
Heard the learned counsel Shilpa Gogi appearing for the petitioner. The learned counsel for the petitioner takes this court through a non-cognizable report by the police on a complaint registered by the wife, which is dated 9/4/2023. The statement of the wife reads as follows, page 83 ಅಲ್ಲಿ ಇದೆ madam. Later, a private complaint is registered, which is referred to investigation and further proceedings have taken place. Even there is no allegation that would touch upon the ingredients of the offences punishable under section 498A of the IPC inter alia. Therefore, it is for the wife to appear and steer clear if there were allegations at all of demand of dowry, which I do not find prima facie. Therefore, there shall be an interim order of stay of further proceedings qua these petitioners till the appearance of the respondent. List on 4th September. Yes.
118.
Petition.
In the meantime, owner. In the meantime,
119.
owner. Yes, next.
Thank you.
Petitioner, my lords. Census, my lords, under the CST Act.
Yes, it will not stay, sir, SCST.
Yeah, my lords, if I may.
Heard the
just-
learned counsel,
My lords, if I.
Jaisham. What's your full name, sir?
Jaisham Jaisimhara.
Yes, Jaisham Jaisim. The petitioners accused 1 to 3 are before this court, calling in question proceedings in CC, a special case number 5007 of 2023, registered for offense punishable under so and so. The offense includes the offenses punishable under the Atrocities Act. The second respondent is the complainant. Disputes between the second respondent and the complainant galore as the petitioners institute OS 111 of 2019 in the year 2019, that's pending,
Pending.
which is pending adjudication before the concerned court, in which status quo has, status quo que, the suit schedule property therein is directed to be maintained. This was called in question by the respondent in miscellaneous appeal 14 of 2020, which also comes to be dismissed. Both these orders are challenged by the complainant before this court in writ petition 13510 of 2020, which also, which was allowed,
Allowed, my lords.
which was allowed, and the
An injunction
and the
was
injunction was granted not to interfere with the property. It is long after these proceedings and the pendency of those cases, the complaint comes to be registered for offenses punishable under section, offenses punishable as aforequoted on 25/6/2022. In the light of the disputes, in the light of the aforesaid dispute pending between the parties, the civil, a civil dispute is rendered a color of crime and the offense under the Atrocities Act. Therefore, there shall be an interim order of stay of further proceedings qua the petitioners till the next date of hearing. 1 HCGP 2 emergent notice. Yes, next.
120,
Kashkan, yes.
121,
The dispute is between the landlord and the tenant. It is too well settled a principle of law that a dispute between the landlord and the tenant cannot become ingredients of section 415 of the IPC for it to become an offense under section 420 of the IPC. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. 1 HCGP 2 emergent notice.
22,
Been added as an accused number 7.
122.
122.
Accused number 7.
Please, my lords.
But ಎಲ್ಲರಿಗೂ ಎನ್ಯೂರ್ ಆಗ್ಬಿಡುತ್ತೆ ರೀಸನ್ ಅದು ಕೊಟ್ರೆ ಈಗ
My lords, in the connected matter, there is already.
ಗೊತ್ತು ಕೊಡಿ. Tag this petition along with so and so. There shall be an interim order of stay in the light of the interim order subsisting in the so and so case. Yes, next.
123,
My lord, I appear for the petitioner in this case.
Yes, sir.
My lord, in this case, the petitioner is.
Accused number 4.
Accused number 4.
Yes, sir.
Your lord, there is no relation between the accused
That
number.
we'll see. We'll have to see the investigation papers.
Of course, your lord.
The learned HCGP is directed to secure the investigation papers and place it before the court list on Thursday in the fresh matters list.
Oblige, your lord.
Yes, next.
my lordship, missing paper.
ಇದೆಯಾ ಕೊಡಿ ಕೊಟ್ಟಿರಿ ಲಿಸ್ಟ್ ಆನ್ ಥರ್ಸ್ಡೇ ಇರಲಿ.
124,
ಡ್ರೈವರ್ ಸರ್.
One is contributory negligence, one is on merits and another one is technical ground. In this case, my lord, accused number 1 and 2 are made an accident. In the charge sheet, accused number 1 and accused number 2 are the opposite. It is not a
Maybe.
case of in criminal jurisprudence.
ಮೇ ಓ ಸೀರಿಯಸ್ಲಿ ಎಸ್ ಸರ್ ಹೇಳಿ.
Contributory negligence is not applicable in criminal jurisprudence.
We'll see.
So the accused should be, counter case should be filed. 2 cases should be filed. In this case, one case, accused number 1 and as well as the accused
But
number
driver
2.
of what, which vehicle, sir?
Which vehicle? It is a car. Car.
Yes, sir.
Kindly pay the page number 37.
Yes.
I am right way. The accused number 2 in the wrong way entered, that is the report is there. Kindly pay the accused.
The matter of trials.
No, no, my lord. The principle, settled principle of law, it is covered by the judgment by the Justice Panindra regarding that particularly case and counter case. Criminal law is applicable. In this case, one case witness to the other case. And other case, the accused is witness to this
Kudi.
case.
Yes.
So they have to, both have to file a separate case.
We'll see.
They are complaining each other.
Tomorrow in the fresh matters list. Yes. Other lady, madam. Yes, next.
125,
For the petitioner, my lord. My lord, the petitioner and the second respondent, they know each other since 2017, my lord. Since then, they were exchanging messages. Your
The
lordship, I ca-
petitioner is before the court calling in question the registration proceedings in CC 8236 of 2024, registered for offences punishable under section 354A2 of the IPC. A perusal at the summary of the charge sheet would indicate the friendship between the daughter of the complainant and the petitioner. The complainant and the petitioner for close to 7 years prior to the registration of the crime, and therefore have exchanged several WhatsApp chats, which has now become the ingredients of the offence under section 354A2. Prima facie, the offence alleged is in misuse of the provision of the misuse of the aforesaid provision. Therefore, there shall be an interim order of stay of further proceedings till the next date of hearing. 1 HCGP, 2 emergent notice.
Petitioners are the accused number 8,
Eight.
8, 9, and 10. There is no allegation against the 8, 9, and 10. Entire allegation is against accused number 1 to 6.
Yes, sir. That we'll see. Come to page 28. sir. ನಿಮ್ಮಲ್ಲಿ ಏನಿಲ್ಲ ಅಂದ್ರೆ
Yes, my lord. Brief of the charge sheet.
ಹಾ
Story of the charge sheet.
ಸ್ಟೋರಿ ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಅಸಲಿ ಎಂದು ಸೃಷ್ಟಿಸಿ
Against the accused number 1 and 6. We are 8 and 8 to 10.
ಎಲ್ಲ ಆಲ್ 4 to 11.
We have no involvement of
No,
the same. Entire amount was transferred in favor of the accused number 1 to 6. Even
No
the 138 proceedings are also pending against the 1, 2, and 5.
No, sir. Difficult.
There is no allegations at all. Even the amount has transferred into favors 1 to
ಡಿಸ್ಚಾರ್ಜ್
6.
ಹಾಕೊಳ್ಳಿ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಬನ್ನಿ. Otherwise, there are
In a
one way
Sumajan
to pass
accused,
orders. I'll post it to day after tomorrow in fresh matters list and pass orders.
I will file the district.
Then you can come if they don't discharge ಆಗಿಲ್ಲ. Allegation ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ನಕಲಿ led to so many proceedings because of your problem. Yes, discharge next.
127,
Petitioner.
311 ಅಲೋ ಆದ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್? ನಾನು ಅಲ್ಲೋನೆ ಮಾಡ್ತಾ ಇದ್ದೆ ಇಲ್ಲಿ ಬಂದಿದ್ರೆ.
ಅಷ್ಟೆಲ್ಲ ಆಗಿದ್ದಾರೆ.
ಏನಾಗಿದೆ?
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಲಿ ಬೇಡ. ಪೇಜ್ ನಂಬರ್ 38 ಅಲ್ಲಿ.
One opportunity is given. I will only observe that it will not be dragging the proceedings ಅಷ್ಟೇ.
ಸಿವಿಲ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ, ಕ್ರಿಮಿನಲ್ ಮಲಾಡ್.
ಏನ್ ಸಿವಿಲ್ ಅಲ್ಲಿ ಮಾಡ್ಲಿ, ಕ್ರಿಮಿನಲ್ 311 ಇರೋದು ಕೊಡ್ತಾ ಇರೋದೇ ಅದಕ್ಕೆ.
ಮಲಾಡ್, they are the hostile witnesses, ಮಲಾಡ್. Again, kindly page number 38, ಮಲಾಡ್. The court has to take in the consideration page number 38, ಮಲಾಡ್.
Nothing wrong, sir. I've seen.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪರ್ಮಿಷನ್ ಮಾಡ್ಲಿ ಸುಮ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದೆ.
ಏನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ? ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಚೀಫ್ ಮಾಡಿ ಅಂತಾರೆ. They are the already hostile witnesses. Again, further given permission to further cheap ಅಂತ. That's why ಮಲಾಡ್.
ಹಾಸ್ಟೈಲ್ ಅನ್ನು ಡಿಕ್ಲೇರ್ ಮಾಡೋದು ಎಲ್ಲಿದೆ?
Page number 38, ಮಲಾಡ್. 38.
38.
Please, ಮಲಾಡ್. ಈ ಸಮಯದಲ್ಲಿ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರು
ಪಾಟಿ ಸವಾಲು ಅನುಮತಿ ಕೋರುತ್ತಾರೆ.
ಭಾಗಶಃ ಪ್ರತಿಕೂಲ ಸಾಕ್ಷಿ ಎಂದು ಪರಿಗಣಿಸಿ ಪಾಟಿ ಸವಾಲು
Which witness is this?
2 witness, ಮಲಾಡ್.
PW 1 and 2, my lord.
1 and 2 are turned hostile.
Please, ಮಲಾಡ್.
Cross examine ಮಾಡಿ. The petitioner is right. The petitioner is before this court calling in question an order passed allowing an application under section 311 filed by the state. The state wants to examine the witnesses who have already been turned hostile and has been permitted cross-examination. Long thereafter, the application comes about for examination in chief of witnesses who have turned hostile. In the order on the face of it is erroneous. Therefore, the order shall remain stayed. It is made clear that the further proceedings before the concerned court are not stayed and they shall continue. Yes. One HCGP, 2 emergent notice. Next.
28,
The complaint filed by the second respondent is nothing but a counter blast filed by me, my lord. I have filed.
Pass over. This has to be heard. Yes, next.
Petitioner, mother-in-law and father-in-law.
A2 and A3 498 Akash Khan.
30,
138, Madam, my lord. Recall of 70 clause 2. It was filed, it was rejected.
Why you can't appear, is it?
Lordship, I kindly see the page number 51, met with a road traffic accident. His spinal cord was broken and he has underwent a surgery.
When is the next date?
Next date. I'm ready to appear through the video, VC, my lord. I don't want to protect
You're
the
an
matter.
accused, sir.
I'm an accused, but the statement also. 12-8.
12-8. Will exempt you for the next date.
No, the
Amal,
problem.
inform the court the next date, we'll see. Inform this court. The petitioner is exempted from appearance on 12-8-2024. List the matter on 21st August 2024.
He's already there is a warrant is pending, proceedings are stalled.
Stalled. Why?
Because since warrant is pending, they will not proceed, the court will not proceed with the matter.
NBW against him.
Question is, the matter can be disposed of with direction, recall the warrant, I will not protract the matter.
No, protract the matter. Allah. Your exemption is rejected.
Rejected, therefore, what I'm seeking is lordship, can you
Let's-
see the photograph? for a
We'll
moment?
dispose it
50
tomorrow then.
50.
Tomorrow, fresh matters. We'll dispose it tomorrow. Next.
131,
Hearing for the petitioner medical. She, the petitioner is the widower of the accused number 1.
Widow.
And, yeah, she is the widow of the accused number 1. and
Widower,
accused-
yes.
And she has took divorce from the accused number 1. After the divorce. and after
Emergent notice to the respondents. Why accused number 1 you have made a party?
Because they.
Madam,
they made-
bracket ಅಲ್ಲಿ diseased ಅಂತ ಹಾಕ್ಬಿಟ್ಟು party ಮಾಡ್ತಾರ ಯಾರು?
Otherwise, they will raise the objection.
What
and
is
that's
this,
in the-
madam?
We will delete.
Delete it.
Yeah, I will delete in the office. There is a stay application because.
1
the
minute, madam.
NBW is.
First you delete it, yes.
Yes.
The emergent notice to the first respondent.
Because.
1 minute, first respondent. Respondents 2 and 3 be deleted from the array of respondents forthwith. There shall be an interim order of stay of further proceedings in CC 26095 of 2023 till the next date of hearing. We'll close it on the next date, yes. Date of 4th September. Delete ಮಾಡಿ ಈಗಲೇ. ಇದರ interim order ಬರಲ್ಲ ಆಚೆಗೆ. Yes. Sir, we'll pass this over. I'll pass orders. Yes.
32,
In the mean, 132 pass over. 133 in the meantime. Next.
34,
I appeal for the petitioner.
34,
134.
Appeal for the petitioner. It is a sale of 2 acres land, page 22. She says it is executed on the basis of a forged document.
There is one more case between the same parties. 209 ಎಷ್ಟದು?
No.
No, there is, sir. You may have not read. I have seen. Wait, I'll tell you the number also. 1 minute. There is one more case between the same parties, sir, where
Maybe
petitioners here or complainants there.
Yes, my complaint is registered.
That is challenged here.
That is challenge here.
We'll take along with that. Anyway, pass over. Yes.
Miller?
Pass over, sir.
35,
Page 13, same order. Next.
36,
For the petitioners,
A2.
A2 and A3, father-in-law and the
Yes. A2. No. Father in the.
stepfather-in-law.
1 minute, sir. A2 yaru?
A2 is the stepfather-in-law.
A3 yaru?
A3 is the mother-in-law. A1 accused has passed away, husband.
Husband has passed away.
One son.
Mother-in-law appears to have tortured.
There's no allegation in the, there's only one line where she is
One line.
called out, outdated in the page number 19 minutes.
Yes.
Number 16 it is there.
Complaint, yes, next, in the meantime. 1 minute, ಅದು ಕೊಡಿ madam. Is that 306 IPC?
No minutes. 498 in.
498 ml.
Oh, next is 306, yes, yes. In the meantime,
What's up?
498 and 306.
7.
So far as both the accused are concerned, my lords, my submission would be that admittedly
Let me see the investigation.
the daughter would say that the daughter herself
Learned
would admit
HCGP
to
is directed to secure the investigation. Charge sheet ಆಗಿದೆಯಾ?
charge sheet ಆಗಿದೆ,
Then
charge
ಏನು
sheet.
ಬೇಡ. No case.
The daughter herself would admit to living separately, my lords. My submission would be this. The daughter herself would admit to living separately from the father. And even despite that, the allegations and all the material would not indicate any positive act proximate to the incident.
That will-
22 years of
Sir,
marriage.
if husband has not instigated, who else will instigate?
My lords, even the mother-in-law is also.
Oh,
the
that will
petitioner.
see, yes.
So far as the mother-in-law. at least
No,
I
nobody,
request-
sir, yes. Discharge ಹಾಕೊಳ್ಳಿ. Not in this case,
Sir, I'll file discharge.
yes. ಇಲ್ಲೇ ಬರುತ್ತೆ ಮತ್ತೆ. Discharge, yes.
38.
For the petitioner.
Okay.
Petitioner is accused number 1.
Tomorrow, fresh matters. The complaint, not pursuing the complaint, ada.
No, my lord, this
Oh,
is
ಇದು ಬೇರೆ.
bank matter. That's at
CC
serial
of
number
2016.
Please, my
What has happened now?
lord, the discharge application has been rejected, my lord. And
And the charge frame ಆಗಿರುತ್ತೆ.
no, my lord, charge is not framed.
Check, get the order sheet, yes. Learned HCGP to secure the stage of the proceedings and submit on the next date of hearing. List day after tomorrow in the fresh matters. Yes.
139.
CC of 2015. Charge frame ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಇಯರ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಇಟ್ PCR ಮೇಲೆ ನಡೀತಾ ಇದೆ ಸರ್, ನಾಟ್ ಇವನ್ ರೆಫರ್ಡ್. ಐ ಆಮ್ ಓನ್ಲಿ ಇಂಟರ್ಮೀಡಿಯೇಟರಿ ಚೆಕ್.
The Karnataka bank.
Please. Page number 1.
1 HCGP 2 emergent notice. There shall be an interim order of stay of further proceedings in CC zones only if charges are not framed as on today. In the event charges are framed, the pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
140.
For petition. Section 306 of this honorable court was pleased to quash the proceedings against accused number 1 by placing reliance on the Prabhu versus State of Karnataka. Demand of return of, I have produced as document number.
Borrowing loan,
Page number, please.
borrowed loan,
Placement. Return of, demand of return of money.
money.
Placement.
ಎಲ್ಲಿದೆ ನಮ್ ಕೊಡಿ.
Page
Page.
number 19, Mali. This, proceedings against accused number 1, Malad, was pleased to, this honorable court was pleased to quash the proceedings.
Petitioner is A3, my lord.
A1 ಹೋಗಿದೆ. Page number 19 to 30. ನೋಡ್ಬೇಕಾ? ನಾಳೆ ಹಾಕ್ಲಾ?
Yes.
Yes, list tomorrow in the fresh matters. We'll close it. Yes.
Complainant is made as a,
Complainant is
made as respond number 2.
ಅದ್ರಲ್ಲಿ appear ಆಗಿರ್ಲಿಲ್ವಾ?
Adal appear agide. Adal, she was appeared.
We'll see.
Please.
Then 1 HCGP 2 emergent notice. The learned counsel for the petitioner submits page 19. So and so quashed quay accused number 1. In that light, there shall be an interim order of stay of further proceedings quay the petitioner who is accused number 3. Till the accused number 3. 1 HCGP 2 emergent notice. Yes, next.
A request for.
Date ತಗೊಂಡ್ಬಿಡಿ ಅದಕ್ಕೂ close ಮಾಡೋಣ. 4th September. Next.
This is 340.
141.
This is 341 and.
Protest in the highway. Why did you protest?
That
Sir?
Lord, the only allegation is that Lord, the 1 to 4 accused, these petitioners have protested.
What were you protesting for?
That is against
Huh?
central agencies.
Central agencies.
Hearing before charge ಇದೆ, my lord.
And in the several other cases, my Lord, the same fact is similar. fact is-
HCGP in the meantime. Yes.
42.
Similar matter quash ಆಗಿದೆಯಾ?
Not in connected, my Lord, but other matters. Your
ಅದು
Lordship
ಗೊತ್ತು,
only-
yes. Next.
Petition.
In the meantime, yes.
43.
States there. Civil proceedings given a color of crime. ನಿಮ್ದಲ್ಲ ಸರ್, ಅವ್ರು ಸಿದ್ಧಾರ್ಥ್ ಹೇಳಿದ್ರು. ನಿಮ್ 7A ಎಲ್ಲಿಂದ ಸಿವಿಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸರ್? ಪ್ಯೂರ್ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್. Yes, Jadhav sir. Nimde 7B.
Yes, sir.
Not the offense under the Prevention of Corruption Act.
Yes, sir.
Not there is no demand, no acceptance, no recovery, no test.
7B is on a different footings.
No.
Allegation is 7A ಅಲ್ಲ 7B.
7B ಮಾಡಿದ್ದಾರೆ, but not in fact, but it is a case of not under section 7A.
We'll see.
No.
Yes.
No investigation under 7B.
Madam 7th, other 8th, 7A. List on 8th, heard the learned senior counsel CH Jadhav appearing for the petitioner. Counsel Shri B.B. Patil is directed to accept notice for the respondent. Petitioner to serve set of papers upon the said counsel. List on 8th.
Interim order, please.
ಅವತ್ತೆ interim order ಯಾವ್ದು?
If once more interim order is not granted in the beginning, but no interim order for thereafter.
ಇಲ್ಲ ಅದು ಇದಕ್ಕಲ್ಲ, because ಎಲ್ಲ ಅವತ್ತು will case to case we will see that day. Let him come.
144.
Petition number 1 is husband, my lord. 2 is the mother-in-law.
All else, no husband.
Yes.
Madam, husband illa, all others.
145.
Excise Act, list on 8, there shall, learned HCGP is directed to accept notice for the respondent. There shall be an interim order of stay of further proceedings, qua the petitioner, till the next date of hearing.
Please.
Yes.
46.
B84 and 85.
A2,
A2.
A1, all allegation against A1.
Lordship, you can see the entire complaint does not disclose when the offense was taken.
All right. A1 is before the court.
No, A2. He's an advocate.
A2 ಕೊಡೋಣ.
A2.
Heard the learned senior counsel Sadashiv Reddy appearing for the petitioner. A perusal at the complaint so registered by the second respondent would indicate all the offences against the accused number 1 and not even sprinkling few against the accused number 2. In that light, there shall be an interim order of stay of further proceedings till the appearance, further investigation, till the appearance of the second respondent complainant. 1 HCGP 2 emergent notice 10th September in the fresh matters list. Returnable by 10th September. Next.
147.
In the meantime, next.
48. 140.
147. Yes, madam.
My lord, the petitioner is the CEO of a company. who is
Correct. Let him continue. Yes. Stayed, madam. Next. 17,624 is one. Yes, Manjunath. 17,624 crime. Get the investigation papers.
No, madam.
Idea? No.
FIR registered on recently.
FIR, yeah, 140?
148.
Correct.
17,624 FIR was.
Yes, sir. Telling me I'm wrong.
624.
Correct, sir. Let the investigation papers come. The learned HCGP is directed to secure the papers of investigation and place it before the court. List the matter on Thursday in the fresh matters list. Yes, next.
149.
There is no allegation with respect to petitioner number 2 to 4, your lordships. All allegations are in respect to accused number 1 and 2. So.
But you are 2 to 7.
Your lordships.
Petitioners are 2 to 7.
Yeah, I'm waiving my relief with respect to petitioner number 1.
1 ilve illa illi.
Petitioner number 1 is accused number 2. Accused number 2.
Yes.
So far as accused number 3, 5 and 7 are
Page
concerned.
31, sir.
Your lordships.
Page 31.
ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ
ಓದ್ಬೇಡಿ, ನಿಮ್ದು ಅಲಿಗೇಷನ್ ಇದೆ ನೋಡಿ ಸರ್ ಎಲ್ಲ. ಇಲ್ಲ
ಅಲಿಗೇಷನ್
ಅಂತ ಹೇಳಿ ಸರ್.
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಬ್ರಿಂಗ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸರ್ಟನ್ ಕಂಪ್ಲೇಂಟ್. ಅನೆಕ್ಷರ್ ಬಿ. ಅಲ್ಲಿಯೇ ಇದ್ದ ನಿಜಲಿಂಗಪ್ಪ, ರವಿಕುಮಾರ, ಪುಟ್ಟಸ್ವಾಮಿ, ಶಿವಕುಮಾರ, ರಮೇಶ ಹಾಗೂ ವಿಶ್ವನಾಥರವರು ಏಕಾಏಕಿ ನನ್ನ ಹತ್ತಿರ ಬಂದು ಏನೋ ಸೋ ಅಂಡ್ ಸೋ ಮಗನೇ
ಸೋ ಅಂಡ್ ಸೋ ಬೇಡ, ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ನಿಂದ್ಯಾಕೋ ಜಾಸ್ತಿ ಆಯ್ತು. ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಎಲ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್.
Page 40, sir. Wound certificate.
There is deep abrasion.
The wound is a wound, sir.
With respect to accused number, there's specific allegation with respect to accused number 2 saying that he brought the stone and he used the stone against him. That's what they say, your lordship. As far as accused number 3, 5 and 7 are concerned, there's nothing at all. Even in the complaint.
Accused number 3.
Accused number 3, accused number 5 and 7.
Come to page 31. ಆರೋಪಿ ಮೂರವರು ಕೈಯಿಂದ ಸಾಕ್ಷಿ ಎರಡು ಕಪಾಳಕ್ಕೆ ಹೊಡೆದು ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯ. ಥಪ್ಪಡ್.
Lordship, even the person
Why?
involved there is an advocate. And it was made only to incriminate these people, your Lordship.
Yes, others we will grant.
Stay with respect.
No, 2, 3, 5, 6, 7 will grant.
Only 5 and 7 are before your Lordships. 3, 5 and 7.
3, 5 and 7.
That's your Lordship.
Accused number 3 ಕೊಡಲ್ಲ sir.
Only slap, that's all they say.
Only slap. Sir, you can't, sir. ಥಪ್ಪಡ್ भी नहीं मार सकते.
That was done
No
only with an
slap
intention to
also.
incriminate them. And
No,
none of them
no,
were
no.
even present on that day, your Lordship.
That
They
we'll
all-
see, that's a matter of trial. 2 and 3 I'm not granting. 5, 7 I'm granting. The petitioners accused 2, 3, 5 and 7 are before this court, calling in question proceedings in CC 2022 of 2022 for the following offences. A perusal at the summary of the charge sheet would not indicate any offense, any overt act performed by petitioners, accused 5 and 7, petitioners 3 and 4, while accused number 2 and 3 are alleged of overt acts which would prima facie become the ingredients of the offences so alleged. Therefore, there shall be an interim order of stay of further proceedings only against accused number 5 and 7, petitioners 3 and 4. It is made clear proceedings against accused number 2 and 3 shall continue. Yes.
One 150.
Produce the entire charge sheet material, sir, CC of 2019. ಇವತ್ತೇನಾಗಿದೆ stage, just check.
Evidence
Application.
statement.
Evidence.
Evidence stage ಅಲ್ಲಿ. But application, I'm
ಏನ್
not
application?
challenging the charge sheet.
What are you challenging?
Not application produced by the prosecution to
5,
produce
12,
document.
22 is the application, sir.
Please.
2 ವರ್ಷ ಅದು 1.5 ವರ್ಷ
It
ಆಗಿದೆ.
is at the.
Oh,
time,
I want,
Last week,
get the
let's see.
stage.
The photograph not the prosecution wants to produce. Which is not supported
Sir,
with.
ಆ ಸ್ಟೇಜ್ ಆಗೋಗಿ ಟ್ರಯಲ್ ಆಗೋಗಿರುತ್ತೆ.
ಇಲ್ಲ ಆಗೋಗಿಲ್ಲ ಇನ್ನು
No,
ಅದೇ ಸ್ಟೇಜ್
let
ಇದೆ.
learned-
ಅದೇ ಸ್ಟೇಜ್ ಇದೆ.
Learned, what is called in question is an order dated 5/12/2022. Learned HCGP to secure instructions with regard to the stage of the proceedings after the passage of the impugned order. List on 14th. Yes.
151.
In the meantime,
Private complaint.
petitioner is accused number 6, finding no ingredients of the allegations so alleged against, so alleged. There shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing.
52.
With petitions 1 to 14. Under the exclusive act, my lord. So far as the only open concern, it is covered by your lordship
Your
judgment.
Lordship, in this case, additional 50 will appear.
Third, there is no causing of explosives. So similar section 3 and 4 will not be attracted. And so far as only section which is attracted is covered by your lordship judgment.
We'll see. N27,
Alla, ಇದು
9B, 9B covered.
covered.
Hmm.
But 3, 4, there is no explosion at all. My lord, only thing is we have stored it. Stored ಅಂತ ಹೇಳ್ತಾನೆ. My lord, kindly look at section.
Let the additional SPP come. Learned additional SPP is directed to accept notice for the respondent list on Friday in the fresh matters list.
153.
CC of 2018 is no representation, list after 2 weeks.
54.
Petitioners, my lord. Petitioners are members of Almond Tree Resident Welfare Association. My lord, petitioner number 1 is president, petitioner number 2 is secretary.
The petitioners are office bearers of the, what
Almond Tree-
association?
Almond Tree Welfare Association.
Almond Tree Row Houses and Villaments Welfare Association. The second respondent is a resident of the said Villament. Crime is registered on the score that the petitioners are not entitled to collect the
Maintenance.
maintenance charges being the office bearers of the association, as they are not entitled under the Karnataka ownership flats, FIR Madam 12. Setting the criminal law into motion into this issue cannot be countenanced, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings, further investigation in so and so till the next date of hearing. 1 HCGP 2 emergent notice.
55.
For petition. 498, 504, 506. Offense.
A2, A1, A2, A7. ಮೂರ್ಗೂ ಕೊಡಲ್ಲ. ಮೂರರ ಮೇಲೂ ಇದೆ allegation. Third one. Petitioners are before this court. There shall be an interim order of stay. The interim order of stay against accused number 1, 2, and 7 stands rejected. There shall be an interim order of stay of further investigation, qua all other accused. Finding allegations, finding the ingredients that would meet the offenses against the accused 8(1), 8(2), and A7.
Appeal for the petition in this case.
Then we ಎಲ್ಲದರಲ್ಲೂ PDO complainant why?
In fact, they have filed.
ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Alla, they have filed a suit for declaration against.
Yes, so and so in the meantime.
Correct.
1 HCGP 2 emergent notice.
157.
Hearing for the petitioner, my lord. Where a civil nature has been converted.
Commercial transaction.
Commercial transactions.
Oh, yes, sir. So what?
Where a OS suit came to be filed, injunctive relief were granted.
In the meantime.
Thereafter,
State, sir.
please, oblige me.
Date of marriage is
Husband.
27/6/2.
Accused number 1 is the husband.
27/6/2012 is the date of marriage.
And so what?
My lord, after 3 months, she leaves the
No
matrimonial.
problem. You are the husband.
True, my lord. She goes away and files the case only after 5 years thereafter. She was never with me after 3.5 months.
We'll see. 1 HCGP 2, 5 years ಆದ್ಮೇಲೆ.
Also, complaint is dated 7/1/2017.
Where is the complaint?
Your lordship may kindly turn to page 51. Down below, my lord. I and my husband stayed together in Bangalore only for a period of 3.5 months. During this period, my husband harassed me. Only
Which period is that?
That is only 3 months.
2012.
2012. ಅದಕ್ಕೋಸ್ಕರ it's barred by limitation. 5 ವರ್ಷ ಆದ್ಮೇಲೆ ಕೇಸ್.
ಗೊತ್ತಾಯ್ತು. ಅಲ್ಲ ಕೇಸ್ ಹಾಕಿರೋದು ಯಾವಾಗ?
ಹೌದು ಸ್ವಾಮಿ. Date of complaint is 7/1/2017.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ?
ಈಗ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ.
ಆಗಿದ್ರೆ it would not.
ಇಲ್ಲ ಆಗಿಲ್ಲ. I am sure.
The petitioner is before this court seeking, calling in question proceedings in CC 60740 of 2017. A perusal at the complaint would indicate that the complainant wife stayed with the husband for 3.5 months from 27/6/2012 and has registered the complaint in the year 2017, alleging demand of dowry of certain amount while the marriage took place 5 years prior to the registration of the complaint. All other allegations are the offshoot of the said allegation. Though it is the husband who is before the court, in the light of the aforesaid circumstance, there shall be an interim order of stay of further proceedings qua the petitioner only if the charges are not framed by the concerned court as on today. In the event charges are framed, the charges are framed prior to the filing of the present writ petition on 5th July 2024, the interim order would not inure to the benefit of the petitioner. Yes.
Sorry, 159.
My lords, counsel for the petitioners, my lords.
ಎಷ್ಟು ಮ್ಯಾಂಗೋ ಕದ್ರಿ?
My lords, I'll tell you the dispute, my lords.
ಏನ್ dispute? ಎಷ್ಟು ಮ್ಯಾಂಗೋ ಕದ್ರಿ?
My lords, I did not. It was some, no, I will tell you, my lords.
Mangoes.
There was survey number 189. Next to that adjacent, that is the land which belongs to me. That is come under a grant certificate, my lords. There's no dispute pertaining to that. Now coming to the land which was adjacent, that is the R2's land, that was survey number 44/10.
What mangoes are grown there?
My lords, there was mangoes which were grown in mine and his. So now what had happened, I had pressed for a proceeding before the Tahsildar. This dispute has been going on from 2022, my lords. I have given representations. There's an ADLR pending. There are so many cases which is pending. There is even a civil suit which is pending. But what happens is, now on that particular day when I was planning my lands, this particular gentleman makes it to his convenience and this case has been filed. It is highly colluded. My lords, if you look at it, my lords, the main allegations in the complaint are against accused number 4. Conveniently, he's been moved out of the charge sheet A4. And what is the reasons for him to drop his name in the
One
charge sheet?
HCGP 2 emergent notice returnable by the 4th of September 2024. List the matter in the fresh matters list on the 4th of September 2024. Till such time, further proceedings in CC 7676 of 2023 shall remain stayed against the petitioners.
Obliged balance.
What mangoes you did not tell?
But it was just raw mangoes, man.
Raw mangoes. But the case is ripe.
No, my lords, it will go
Yes.
away, trust me.
Yes.
Obliged.
60,
I am appealing for
Kashkan.
61,
sister-in-law.
ಏ ಆಯ್ತು
Please.
ನೀವು ಅದೆಲ್ಲ ಏನು ಹೇಳಲೇಬೇಕಾಗಿಲ್ಲ.
Obliged.
Yes.
But the 420 entire
Agreement. What agreement?
Lord, agreement was with the accused number 1. The entire family has been roped into this web of crime, Lord.
Evidence stage ಅಲ್ಲಿ ಇದೆ, my lordship. PW1 has been examined. 6/7/24
ಯಾವ number?
6-7 ಅಲ್ಲ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಯಾವತ್ತು? ಮೇಡಮ್ ಯಾವ್ದು ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಇದಿನ್ನು 2024 ಮೇಡಮ್.
24.
61, my lordship.
160?
1.
2023 FIR ಆಗ್ಲೇ ಇದಕ್ಕೆ ಹೋಗೋತಾ?
ಇಲ್ಲ, cognizance was taken.
CC of 2024 ಮೊನ್ನೆ ಕಾಗ್ನಿಸೆನ್ಸ್ ಬಂದಿದೆ.
ಇಲ್ಲ.
2 months ಬ್ಯಾಕ್ ತಗೊಂಡಿರೋದು ಕಾಗ್ನಿಸೆನ್ಸ್.
Wrong.
Online ಅಲ್ಲಿ check ಮಾಡಿ.
Till 9/7/24 is
ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಇಸ್ ಡೇಟೆಡ್.
Lord, cognizance order 8/5/24.
Charge frame is in the meantime only if charges are not framed as on today.
Not.
Yes.
162,
Petitioners.
Husband.
Husband, father-in-law, mother-in-law, husband, tangi, ಮತ್ತೆ for relative.
Or relative. Why for relative? One illa, madam. Husband illa.
Respect to one, my lord. One submission.
Let the wife come.
Lord, only one submission. Lord, in the complaint, there's the allegation that on 26/3/2024, ಮನೆಯಲ್ಲಿ ಒಡವೆ ವಸ್ತ್ರ ಎಲ್ಲಾನು ಇಟ್ಬಿಟ್ಟು ಹೋಗು ಅಂತ ಹೇಳಿ pushed her out of the home ಅಂತ ಹೇಳಿ there's allegation in the complaint. Lords, may kindly see page number 50, the WhatsApp conversation between the petition number 1 husband and wife.
That's a matter of trial. I'll permit trial then. Yes. One illa, others, yes.
Just for the petitioner,
53,
landlord tenant dispute given criminal contours here. Page number 83 also. Proceedings against the A3 and A4 are already still. The allegation is the
Page-
same. Yeah, page number 83, sir. Annexure
83 same order, madam. Tag same order.
6456 of 2020.
83 ಇದೆ ತಾನೆ?
ಇದೆ.
Same
Good.
order.
164,
Manjunath. The offense is, the petitioner is before this court calling in question proceedings in crime number 64 of 2024. The incident that has taken place on 5/1/2022 is complained of on 18/1/2024 for the aforesaid offenses without an explanation for the delay in registering the crime. The registration, the complaint itself is absolutely bald, absolutely vague. Therefore, there shall be an interim order of stay of further investigation, quay the petitioner till the next date of hearing.
165,
A2 ಮಾತ್ರ.
Petitioners are.
ಅಲ್ಲ, husband ಇಲ್ಲ.
Husband ಇಲ್ಲ. A2 and A3.
ಅದೇ, A3 ನೂ ಇಲ್ಲ.
A3 is the mother.
Come to page 21. (21 and 22). Petitioners here,
A2 and A3, my lordship.
A2 and A3 is a.
A2,
direct
not-
in-
only A2.
that
Yes.
A3 is the,
A3 ಎಲ್ಲಿದ್ದಾರೆ?
either
A2 and A3, father-in-law and
father and mother of the A1. In page number.
Yes, Kashkan. Next. ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. 160? ಲತೀಫ್ ಇಲ್ಲ ಇದ್ರ ಯಾಕೆ
166.
ನಿಮ್ದಲ್ವಾ?
Mine.
What were you thinking then? Yes, petitioner to serve set of papers upon the counsel who represents the respondent in the trial proceedings and file an acknowledgement list on 22nd August in the fresh matters list till such time further proceedings shall remain stayed before the concerned court shall remain stayed.
67,
In the meantime,
168,
504, 506.
68. 168.
Yes, sir.
Often the allegation is allegation of theft of customer data by the company official
Hmm.
and using that customer data and they caused the loss to the company is what the allegation means. This charge sheet is filed for the offense 381 408.
Correct, page 18.
Yes, madam.
Yes.
And but the cognizance is taken only for IT offenses. The fact remains is the accused before this the petitioners are they were working as a relationship manager with the Muthoot Finance and consequent upon the
Muthoot is the complainant.
yes, madam. Consequent upon the registration of crime,
One
they have been
HCGP, 2 emergent notice in the meantime. Next,
please.
Latif,
169,
324.
Please.
Wound certificate indicates blood simple injuries.
But injury how? No, 323, no 24 later, but there is an own certificate. 1 HCGP, 2 emergent notice.
Please.
170,
I'm for the petitioner, my lord.
Husband.
Husband, charge sheet is filed, my lord.
Correct.
20 years of marriage, 7 years of separation.
7
Wife is
years
a-
of separation.
Yes, my lord. 2017, she has gone to France to do MBA and she settled.
Then
in
what
the-
is the separation?
She has gone for higher studies without the consent of the husband.
Hmm.
And this complaint was filed in 2023 through an email.
Hmm.
Police have filed a charge sheet in June 2024.
How do you demonstrate separation?
My lord, she is already there in France, my lord. She is not, husband is in India.
ಆರೋಪಿಯು ಮನೆಗೆ ಲೇಟ್ ಆಗಿ ಬರ್ತಾ ಇದ್ರು.
My lord, that is 2004 is the marriage, my lord. 2017 they were together. They have a daughter.
The petitioner is before this court calling in question proceedings in CC 19269 of 2024 registered for offences punishable under so and so. The petitioner is the husband. The complaint itself narrates the wife separating from the husband in the year 2013 of a marriage that takes place in the year 2004. And the crime is registered in the year
2024, my lord.
in the year 2024, alleging incidents that have taken place between 2004 to 2013. If further proceeding against the husband is permitted to continue in the case at hand, which is on the face of it an abuse of the process of the law, it would run foul of the judgment of the apex court in the case of Achin Gupta versus so and so 2024 SSC online SC page 759. Therefore, there shall be an interim order of stay for the proceedings.
Much.
Next.
171,
79 and 80 of the KP Act, my lord, in this matter. I may not have one technical ground before your lordship. Page number takes.
Permission ತಗೊಂಡಿಲ್ವಾ ತಗೊಂಡಿದ್ದಾರಾ?
Permission ತಗೊಂಡಿದ್ದಾರೆ. Your lordship is in page 65. For a moment. In Kannada, my lord, is handed in 230, they take permission on 29/8. But at page number 44, your lordship will see.
1 HCGP, 2 ಇಬ್ರಿಗೂ HCGP.
It is a HCG.
List on 12th September. There shall be an interim order of stay of further proceedings till the next date of hearing. Next.
172,
Page 124 is a sale deed where consideration is received
to check and remand draft, which is suppressed, not in the complaint. Your lordship will find page 130, my lord. I'll just print it. By the complainant himself, page 130, my lord. This is of the year
Heard
2000.
the learned counsel P. Prasanna Kumar appearing for the petitioner. 1 HCGP 2 emergent. The issue which is seemingly civil in nature is dressed with a color of crime and the criminal.
Is a,
To state is not a.
is a private complaint.
Emergent notice to the respondent. Dressed with a color of crime and the criminal law is set into motion. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date. Next,
73.
311 application.
311 application.
Number 2, man.
Huh.
Same matter was challenged before district court, man. It's
Revision
still
petition is
pending.
also-
Pending ಇದೆಯಾ?
Please, man.
I have
ಅಲ್ಲೇ
disclosed.
ಮಾಡ್ಕೊಳ್ಳಿ.
Somebody disclosed ಮಾಡಿದೀನಿ in a fact ಕೂಡ. But the revision court has not filed any order, my lord.
I will direct the revisional court to pass appropriate orders immediately.
Please.
The petitioners in both these cases have called in question an order passed by the concerned court rejecting an application under section 311 of the CRPC. The learned counsel appearing for the complainant, respondent, would submit that the very orders are called in question before the court of session in criminal revision petition 27 of 2024 and
28. my lord.
28 of 2024. It is the submission that the concerned court, the revisional court has not passed any order. In that light, and the challenge being to the application under section 311 of the CRPC, the concerned court is directed to pass necessary orders within 15 days from the date of receipt of the copy of this order, if not earlier, bearing in mind the law with regard to a grant or rejection of an application under section 311 of the CRPC. Yes.
174.
304A, please. Petitioners as accused number 3 and 4.
Charge frame ಆಗಿದೆ.
Charge ಆಗಿಲ್ಲ. ಆಗಿಲ್ಲ.
ಆಯ್ತು ಹೇಳಿ.
Blood against Millard annexure E. Accused number 125, they've approached this court and there's already be a stay granted, please, Millard.
Your accused number?
Accused number 3 and 4.
ಕೊಡಿ ಅದು ಯಾವುದು?
Annexure E, page
ಅಲ್ಲ,
161.
this, 161 ನಾ?
Page 161.
What cadre are you in?
Millard, the assistant executive engineer and.
You are who?
AEE and AE.
AEE and AE.
E.
What
of
happened?
Kaveri Neeravari Nigam.
Correct. What happened?
Millard, what has happened, please, Millard, the complainant, the deceased, father of the deceased Millard, they gave a complaint that the roads were not properly maintained by Jilla Panchayat, chief, the Panchayat Raj
Who
department.
died?
Millard, 2 persons who were traveling in the motorcycle. Millard, page 160.
There was no signboard, nothing.
Page number 121, please, Millard. It was not, Millard, the renovation or the work is not carried out by the Department of Kaveri Neeravari Nigam. Page
Who was
120
carrying out, sir?
Millard, it was through, Millard, page 122. I would like to point out, please.
Who was carrying out the works?
Millard, the executive engineer of our department made a clarification to the jurisdictional police. Millard, may I read the relevant para?
Page.
Dinanka, page 122. ದಿನಾಂಕ 10/8/2019 ರಾಮನಾಥ್ಪುರ ಪಟ್ಟಾಭಿರಾಮ ಶಾಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಪ್ರವಾಹ ಪರಿಹಾರ ಕಾಮಗಾರಿಗಳ ಸಭೆಯಲ್ಲಿ ಸ್ಥಳೀಯ ಶಾಸಕರು ಮಾತಾಡಿ ಸದರಿ ಸೇತುವೆ ಪುನರ್ ನಿರ್ಮಾಣ ಹಾಗೂ ಬದಲಿ ರಸ್ತೆ ಕಾಮಗಾರಿಯನ್ನು ಪಂಚಾಯತ್ ರಾಜ್ ವಿಭಾಗ ಅರ್ಕೂಲ್ಗುಡ್ ಅವರಿಗೆ
ನೀರಾವರಿ ನಿಗಮ್.
I am ನೀರಾವರಿ ನಿಗಮ್.
The learned counsel for the petitioner submits que accused number 1 to 5. A coordinate bench of this court has granted an interim order of stay. Tag
Millard, 1 and 2, if I'm sorry.
1 and 2.
1 and 2.
The coordinate bench has granted an interim order of stay. Tag this petition along with so and so. 1 HCGP 2 emergent notice. Return ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅದು ಮಾಡಿ madam. List them both on 19th September, 18th September in the fresh matters list.
Please.
Next.
175.
Petitioner.
A47.
Yes, but I'm a chartered accountant. I incorporate 2 companies, my lord. Thereafter, these companies go on to disperse loans for which I am sought to be indicted.
only on the ground that I have not taken the declarations properly and that I have not visited the office premises. If that be the case, my lord, it makes a case for a disciplinary proceedings, not for the acts of the companies that are said to have been incorporated by me at a later
Let's see.
stage.
ಯಾರು CCB HCGP learned HCGP huh?
State is not a CCB.
ಯಾವ್ದು?
State
But
is state.
economic offense wing, my lord. Economic offense wing.
That is Government of India?
Yes, statements.
State, ನೀವೇ ತಗೊಳ್ಳಿ. Learned HCGP is directed to accept notice for the respondent.
My lord,
Go through the petition. Look at the role of the petitioner and make submissions on the next date. List on 20th in the fresh matters list. Yes.
176.
Final report not filed, notice. Final report not filed, same criminal state,
Final report not filed. 5 ವರ್ಷ ಆದ್ರು.
same register.
See the contrast, 24 hours al final report, 5 years al no final report.
Same case.
Could you tag this petition along with so and so? List them both together, list them both on 4th September. Next. Same order, the interim order, the interim.
177.
It's an incident that took place during the election day. 2 complaints given by the sympathizers of BJP, 2 complaints given by the sympathizers of Congress for the same incident. The first of which, my lord, should get at page 47. This is a complaint given by one Parvati, my lords, page 47, against Gangadhar, who is now R2. As a counterblast to
What
this,
happened to that?
my lords, it's pending. This matter is pending. Kindly
ಇಲ್ಲ,
notice.
that is criminal petition ಹಾಕಿದಾರ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಅವ್ರು ಹಾಕಿಲ್ಲ. Kindly notice, my lords, ಇದಕ್ಕೆ counter blast we get at page 55, crime number 82.
307.
ಅಲ್ಲ 307, 323, my lords.
Records are there.
Virtually 323.
It's
My
all
lords, if my lords would kindly notice page
Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. Page
investigation ಕೊಡಿ.
55 ಅಲ್ಲಿ 82.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. Let me see, Friday, fresh matters. Investigation papers, let me see.
Please.
Yes.
So, my lords, crime number 81 to 84, all the 4 crime numbers,
ಎಲ್ಲ
that
ಇದೆ.
gives a sequence, my lords.
ಇದೆಯಾ madam ಎಲ್ಲ? Yes.
Complete ಆಗಿಲ್ಲ, ಎರಡಿದೆ ಮೇಡಮ್.
81 to 84. Get everything, ಇದಿರ್ಲಿ, get the remaining.
Because, my lords, probably the one that is given is a complaint given by the Congress sympathizer. We
Let's
need
see.
both the complaints, my lords, then it becomes easier.
That's
4
why-
complaints.
No sympathy for any sympathizer.
And that's why it looks like that,
Friday.
my lords. Election day ಆಗಿದ್ದ.
Friday, you're not well,
Throat, my lords, slightly.
so the case. Yes.
For the petition.
In the meantime, yes. Next.
29.
4
Pray
lakhs
for
fine,
Passover.
why?
I pray for Passover, my lord. There are 6
ಎಲ್ಲಿ
matters.
ದಿಲೀಪ್ ಕುಮಾರ್?
ಮಧ್ಯಾಹ್ನ.
ಇದು ತುಂಬಾ ಕೇಸ್ ಇದೆ, 8 10 ಇದೆ.
Eight-
Why
6
4
matters.
lakhs fine is imposed?
Matter was settled, my lord, and appeal was preferred. ಅದರಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ರು.
ಹಾ.
ಆಮೇಲೆ 421 ಅಂಡರ್ ಮೂವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ, ನೀವು accused.
ಐ ಆಮ್ ಅಕ್ಯೂಸ್ಡ್.
You did not adhere to the settlement?
ಇಟ್ ವಾಸ್ ಚಾಲೆಂಜ್, my lord.
Where?
ಸೆಷನ್ಸ್ ಕೋರ್ಟ್.
Settlement challenge ಮಾಡಿದ್ರಾ?
ಜಾಯಿಂಟ್ ಮೆಮೋ.
Joint memo
Joint-
ಎಲ್ಲಿ ಮಾಡಿದ್?
ಜಾಯಿಂಟ್ ಮೆಮೋ ಮೇಲೆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ.
Passover. All your, there are 8 matters.
6 matters.
6, yes.
185 or
182 ಕರೀರಿ, ಅದೊಂದೇ different. Srinivasan. Who is in possession?
Advocate, 182, an advocate.
448.
448, 353, 448.
353 ಯಾಕೆ?
ಅದರಲ್ಲಿ ಏನಂತಂದ್ರೆ ಅವರು ಅವತ್ತು ಅಕ್ಯೂಸ್ ನ ಅವರ ಪಿಟಿಷನರ್ಸ್ ಕ್ಲೈಂಟ್ ಅನ್ನ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮನೆಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ.
1 HCGP, 2 emergent notice in the meantime. Yes. States.
186.
Satish. Pokso.
Please,
Settlement.
there is no way allegation against this petition. Absolutely, the ingredients of the summary of the charge sheet, nor in the 164 statement and medical report is not permitted to examine. Kindly see, my lord, page number 164, page number 43.
You are accused number 2, sir.
Please, I am accused number 2.
ಏನಿದೆ?
The
ಏನಿಲ್ಲ?
entire allegation goes to accused number 1. Is only allegation to instigation to the accused number 1. It is only allegation.
Let's
Page number 43, kindly see. Only
Yes.
instigation.
Look at it, madam.
A2 is absconding, my lordship. The charge sheet only it is there.
ಎಲ್ಲಿದ್ದಾರೆ ಈಗ?
I don't know, my lord. I will.
Then how did he sign wakalat?
I will assert.
Huh?
Let us refer.
How did he sign wakalat?
Let advocate has referred the matter, my lord. Is
I asked your advocate, referred advocate, that where is the petitioner? List on 20th in the fresh matters list. Yes.
187.
I'm for the petitioner, my lord.
Respondent ಇದಾರಲ್ಲ. Ready?
ಇಲ್ಲ sir, I have to file objections.
Without making him a party, ಎಲ್ಲ ಆಗೋಗಿದೆ.
Now we have made a party regarding the.
ಈಗೇನಾಗಿದೆ? What is the stage today?
My lord, as per the order of this honorable court, the gold has been released. Whatever there is seized from their custody, it has given to him back. So whatever was seized from somewhere else, that was given to me.
Let him file his objections then.
Much better.
Yes. Learned Counsel case Venkatramana 6, 10 days time to file statement of objections. List on 21st in the fresh matters list. Next,
188.
For the petitioner.
tomorrow. ಇದು ಅದು.
Please,
Yes.
victims.
ನಾಳೆ ತಗೊಂತೆ. Yes. List tomorrow.
89.
Post immediately after service of notice upon the respondent.
Lords, I'll just want to illustrate why a stay is necessary in this matter.
Not necessary at all.
Yeah, Lords, you just see the attitude of the.
Attitude of the wife?
Yes, your Lords.
No problem.
She has the entire property as well as the money. Your Lords, just see the page number 71, your Lords.
Let the wife come, sir. So what?
Your Lords, until we garner the attention of the petitioner, they are also appearing in the other matter in MFA, but they are not appearing here.
Yes.
Lords,
List
Short
the-
interim say, Lord.
List the matter on 20th in the fresh matters list. Yes.
At least on 8th, your Lords, the other matter is listed on 8th.
Which one?
The MFA, she has challenged the divorce.
MFA before this court?
Not yet.
Sense. Yes, list on 20th.
Right.
Yes, of your.
Heard the learned counsel appearing for the petitioner. The petitioner is before this court so and so. On an agreement that was entered into in the year on 10/2/2016, a complaint comes to be registered in the year 2023. In that light, there shall be an interim order of stay of, without any speck of explanation for the delay. In that light, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing. Next.
91.
Petitioner, my lord. The representation and the C report is filed.
C report.
C report.
ನೀವೆಲ್ಲ ಎಬ್ಸ್ಕೊಂಡಾಗಿದ್ದೀರಾ?
Not like that, my lord. I have filed complaint,
Ah.
theft of jewelry. So.
Yes, the learned HCGP is directed to accept notice for the respondent.
Please.
ಅಷ್ಟೇ notice ಅಷ್ಟೇ ತಾನೆ? Yes.
92.
Mohanlal, reserved.
I need.
ಇನ್ನ arguments ಇದೆಯಾ? Pass over. Yes.
ಇವತ್ತು ಲೀಸ್ಟ್ ದೊಡ್ಡದಿದೆ ಬೇಕಾದ್ರೆ ನಾಳೆ ನಾನು.
ಆಯ್ತು, tomorrow fresh matters list. Yes.
I will not take more than 10 minutes. I have
All
prepared.
right, tomorrow you can take, not today.
Yes.
193.
Pass over.
94.
The petitioners in this case, madam.
ಆಯ್ತು, we'll continue.
Okay.
Sir, serial number 153. 153. Dilra Sequere. First list 153. Sir? Dilra Jalra, sir?
ನಂತರ ಆಮೇಲೆ ಬ್ರಾಂಚಲ್ ಮಾಡ್ಬೇಕು.
Madam?
ಬ್ರಾಂಚಲ್ ಮಾಡ್ಬೇಕು.
Serial number.
ಏನದು? ಐವತ್ತು ಪ್ರೆಸೆಂಟ್ ಇರ್ಲಿ ತಡಿ ತೊಂದ್ರೆ ಬರಲಿ ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Mila, serial number 3, withdrawal, Your Honor.
Serial number 3.
Yes, Your Honor. Parties are acquitted. Petitioners
Serial
are
number 3
acquitted.
you are withdrawing. Are you sure?
Yes, Your Honor.
It's PMLA offense.
Yes, they are acquitted, Your Honor. That's it.
Give the memo. In terms of the memo. $94 ಅಲ್ಲ?
Petitioners in this case, my lord.
Yes, sir.
My lord, the allegation is that accused number 1 has forged the signature of accused number 5 and 6, my lord.
I asked for the investigation papers. Huh? Day after tomorrow. Day after tomorrow in the fresh matters list.
My lord, petitioner is 75 years old, my lord. He is resident of Harpanalli.
He'll become 75 years and 2 days for day after tomorrow. Yes. Adlen urgency.
My lord, harassment, my lord.
Yes. Harassment.
Yes, ma'am.
Police harassment. That's a common thing. Yes.
Public.
Next.
This matter.
Who's in possession?
So we are in position. I mean, it's a road, Your Lordship. It's a public road.
Public road.
It's a public road.
Dispute with regard to the road.
Please.
447 ಹೆಂಗಾಗತ್ತೆ? You are accused number 3.
I'm accused number 1, Your Lordship.
You are?
Accused number 1.
Seriously?
Yes. Accused number 3. Sorry, I'm actually.
ನಾನು ತಪ್ಪು ಓದ್ಬಿಟ್ಟಿದ್ದೀನಿ
ಗೋಪಾಲ್
ನನಗೆ.
No, Your Lordship, in
Gopal Shetty, ಯಾರು
please,
sir?
page 20, Your Lordship, accused number 1.
Accused number?
1.
Why have you described him as accused number 3?
In charge sheet, what happened, Your Lordship, they have mentioned as accused number 3.
Accused number
Charge
three,
sheet.
sir.
Kindly, your
Correct.
lordship, page 20, your lordship, for a moment.
Then we will grant stay quay accused number one. All right.
Because the FIR
No
is.
problem. I don't
kind-
know. You are saying is accused number one. I'll grant stay only for accused number one.
Your lordship, kindly go through, for a moment, your lordship, page 20, your lordship.
Sir.
Niruti Gopal.
Kali Gopala. Adyaru? Kali
This is
Gopal.
The Niruti is the village name.
Where is the charge sheet? Okay, mic on madillo, madam. You had lunch?
Yes, ma'am.
28.
My lordship.
Please, you.
Correct. Gopal Shetty. Now I'll grant stay because you said he's accused number one. I'll grant stay for
In
accused.
FIR, accused number 1. In charge sheet, accused number.
So what should I take? The petitioner is accused number 3, alleged of offences punishable under section 447 and 427 of the IPC. The learned counsel for the petitioner submits that the petitioners are in possession of the property. If the petitioners are in possession of the property, it is ununderstandable as to how there can be an offence of criminal trespass against their own property. Therefore, there shall be an interim order of stay of further proceedings where the petitioner accused number 3 till the next date of hearing. 1 HCGP, 2 emergent notice.
Right.
Yes. By next date, you decide 1 or 3. Yes.
Petition, please, my lord. Regarding the.
ಒಂದರಲ್ಲಿ interim order ಇದೆ 107 ಅಲ್ಲಿ. ಇನ್ನೊಂದು
ಅದೇ ಇದರಲ್ಲಿ ಎಂಡಾಸ್ಮೆಂಟ್
ಅದೇ
SC/ST ಆಕ್ಟ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅಫೆನ್ಸಸ್
ಬರಲ್ಲ ರಾಮಚಂದ್ರ ಅವ್ರೆ. ನೀವೇ ನೋಡಿ ಏನಾರು ಒಂದು ಅಕ್ಷರ ಇದ್ರೆ
the person who have been sustaining injuries.
ಟ್ರೂ ಸರ್ ಅಲ್ಲ ಇಂಜುರೀಸ್ ಸಸ್ಟೈನ್ ಆಗಿರೋದೆಲ್ಲ ಬೇರೆ ಬಟ್ ಎಲ್ಲಾದ್ರೂ there is any abuse on the name of the caste then yes.
ಅದು ಬರೋದು that will attract only for R&S ಮಾತ್ರನೇ within public view ಬಂದಿದೆ.
All right, just you are abused. There is you are assaulted rather. You are assaulted. There are allegations made and charges are framed. Now, if you say that Atrocities Act should be included only because the person assaulted is an SC.
No, ಈ ZDNL ಕೂಡ who have been obstructing for their ಇದು ಅಂತ ZDNL.
No, sir, it's not. May not be a case for that. Anyway, list on.
Ingredient, last time your lordship heard this matter and then.
I know.
There is no ingredients at all.
It's all right. We'll see. We'll answer it. List on Friday in the fresh matters list. Interim order subsisting in any of these cases shall continue till the next date of hearing. ಒಂದರಲ್ಲಿದೆ ಅದಕ್ಕೆ.
Second one dispose ಮಾಡಬಹುದು ಯಾಕಂತಂದ್ರೆ ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ಅಡ್ವೊಕೇಟ್
ಅವತ್ತು ಮಾಡ್ತೀನಿ 107 ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ
ಕೊಟ್ಟಿದೆ
ಅವತ್ತು ಮಾಡ್ತೀನಿ.
97.
Lordship appearing for the petitioner. Lordship, the petitioner in seeking a life partner through a matrimonial website has been accosted by a person who does this on a regular basis, Your Lordship.
Regular basis.
She files malicious complaints. We have Lordship submitted at page number 157, Lordship.
Shadi.com.
Shadi.com. Same complaint, same allegation in 2019 as well as in 2021. Other than that, the petitioner has also found evidence on her phone of accosting men with such.
What research?
With such allegations, saying that I am going to proceed against you under.
Against whom?
Against other suitors that the complainant has. To the matrimonial website.
Yes, madam. Offenses clearly found. Allah?
Promise of marriage.
Promise of marriage. Initially, the sections were 376, 417.
Amal bari 417, 420.
417, 420, Swami. Even the police, respondent police, we had submitted these details a lot at that point of time.
The petitioner is before this court calling in question proceedings in CC 3875 of 2023 registered for offences punishable under section 417 and 420 of the IPC. The second respondent is the complainant. The petitioner meets the complainant on a matrimonial website, shadi.com. Then begins the relationship between the two. The petitioner then later during the petitioner later, after the relationship had matured to a certain extent, discovers the fact that the complainant is in the habit of soliciting men on shadi.com website or any other matrimonial website, and later would register crime against them for offences punishable under section 376 or cheating, as the case would be. One such crime registered in crime number 55 of 2022 is projected as an identical crime against another person.
Crime number 114, Lord. Crime number 114 of 2019, Lord.
Crime 114 of 2019, which is verbatim, madam. Crime number 114 of 2019, which is verbatim similar to the crime that is registered against the petitioner in crime number 55 of 2022. The police, after investigation, have fortunately given up offense under section 376 of the IPC, but have retained the offense under section 417 and 420 of the IPC, which on the score that the petitioner has indulged in physical relationship with the complainant on the score of promise of marriage. If further proceeding is permitted to continue against this petitioner, it would become an abuse of the process of the law, albeit prima facie, apart from putting a premium on the activities of the complainant. 1 HCGP, 2 emergent notice, there shall be an interim order of stay of further proceedings to aid the petitioner till the next date of hearing.
98.
Petition is a.
A10.
A-leave.
A10.
A-leave.
A8. Accused number 10.
10. A10.
Yes.
A-leave. The charge sheet and also.
Page number 101, my lordship. Allegations against accused number 10 is he has colluded.
1 HCGP, 2 emergent notice. Date koduva sir. 4th September. List on 4th September. Interim order avat noda sir.
Half an hour they are summoning him.
No, you have to, sir. As you sow, so you reap. You have to go. Yes.
Date.
Date 4th September.
199.
In the meantime, oh sorry, you are Gotilla. The HCGP's direct petitioner, madam. Petitioner is before this court antala bariri. I learned HCGP is directed. Nimdala sir, nimda next matter. The petitioner is before this court calling in question so and so. HCGP is directed to accept notice for the first respondent. Second respondent, complaint.
Second respondent.
Emergent notice to the second respondent, returnable by the 11th of September. In the meantime, there shall be an interim order of stay of further proceedings, square the petitioner till the next date of hearing.
Great.
Interim order ideyala?
Second respondent.
Post immediately after service of notice upon the second respondent, interim order subsisting shall continue till the next date of hearing.
Please.
Yes. Last time yaru irlilla. No representation on 29th. Even then it's PMLA. Without hearing, I will not. Heard the learned senior counsel M.B. Sheshachala appearing for the petitioner. Learned counsel Madhukar Deshpande. PMLA Prasanna Kumar idira? You're there?
Last time, connected matter, lordship had already issued notice to Mr. Deshpande.
Madhukar Deshpande. I notice madidine. Counsel Shri Madhukar Deshpande is directed to accept notice for the respondent enforcement directorate petitioner to serve set of papers upon the aforesaid counsel. Adi yavat hakide sir.
7th is it.
List on 7th along with that. Same crime, huh?
Same.
Tag the petition along with so and so. A number thodi, madam. List on 7th. Yes. 7, 8.
202.
The petitions, my lord. This is matter, my lord, where surface
Whom
proceeding.
did you sell?
Not, I've not sold it. Now, my lord, the property has been auctioned by the bank and someone they have issued sale certificate.
You are the borrower.
Yeah, I'm the borrower. They
The
have-
allegation is that during the subsistence of the mortgage, you have sold it.
Prior, my lord, they say prior to that, I've entered into a.
Give
agreement
auction
of-
ಆಗಿದ್ಯಾ?
ಈಗ auction ಆಗ್ಬಿಟ್ಟಿದೆ.
One HCGP, two emergent notice in the meantime. ಗೊತ್ತಾಗುತ್ತಾ madam? ಏನ್ ಹೇಳಿ? Last time ಹೇಳಿದ್ನಲ್ಲ. So and so and so.
Oblige, please.
Yes, next.
103.
Time demand.
Owner and contractor. 203 na. 304A. Settlement. 304A settlement ಹೆಂಗೆ sir?
Terms of settlement are 10 lakhs have been paid.
On that you can't sir. You come on merits. Yes, Jagdish. 304A settlement money ದುಡ್ಡು ಕಷ್ಟ.
The case of electrocution, my lords.
Huh?
Now, case of electrocution, complaint as against the owner and the contractor, my lord.
Yes, sir. Contractor, how can he escape the liability?
Come in contact with an iron rod, hence because of that electrocution has happened.
Maybe.
Hence, there's no negligence on the
On whose part?
petitioner's part.
Accused number one, owner is fine. No problem. He was elsewhere. But accused number two is the contractor. He cannot be left off the hook.
Or came in contact with the live wire, my lords. It was spontaneous.
Live wire at who was responsible for that?
Lords, they were the masons at that building. They were
No, who was
working,
responsible for the live wire to be hanging?
and he was the contractor was supervising.
I'm asking
everything.
who was responsible for the live wire hanging?
Contractor was.
Yes. We will not let off the contract. You pay compensation. Sir, payment of compensation is wholly apart from the allegation of negligence. The life is lost. So casually 10 lakhs, life is assessed at 10 lakhs and closed. Somebody should face the music, sir. These executive engineers, assistant executive engineer, who are all responsible for all the care that should take, that so that the citizens would not die casually like this, will not be left off the hook.
Like a private property. There were masons who were doing work at that place.
Take the mic. Mic, sir. Take the mic.
They were working at a private property. So they were masons who were working at that property, my lords.
Sir, you are the
One person has
you
been
are the
injured.
contractor, you are responsible. Accused number one, I will not, because he is the owner of the property, he had entrusted the contract to you.
Please.
Settlement and money. Compensation kodi.
Please.
That doesn't mean you will get off the crime.
My lords,
Have
may I
they
fix
not
the
claimed
date?
compensation by filing other cases?
No, ma'am.
ಏನು ಮಾಡಿಲ್ವಾ?
Verify, my lord, because they need
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ
an-
ನಂಗೆ.
Yes.
Yes. Friday. List on
Yes.
Friday in the fresh matters list.
204.
And life is assessed at 10 lakhs?
I
Yes.
understand, my lords.
Not. 204, 8th DA.
Please.
List on 8th. 8th or 7th?
seventh.
7th, list on 7th along with the
I'll take notice.
identical matters and ಅಷ್ಟೇ ಮಾಡಿ.
I'll take
Learned,
notice to BBA.
learned counsel, see BB Patil is directed to accept notice for the respondent Lokayukta. List on 8th. Copy
Yes.
sir ಮಾಡ್ಬಿಡಿ.
I'll serve it. Eighth, so I'm sorry,
8th,
seventh.
7th. Sorry, 7th.
205.
Accused number 3, my lord, as against accused number 1 and 2, my lord, you all.
ಕೊಡಿ. Tag this petition along with so and so. The learned counsel appearing for the petitioner submits quay accused number 1 and 2. This court has granted an interim order of stay. In that light, there shall be an interim order of stay in the case at hand as well. List them both on 4th September.
Acha.
Yes.
206.
It's PMLA, my lord, section 3 and 4. This should be connected with writ petition 10806 of 2023, my lords. Our petitioner is A1. In that other case, it was A4, my lords. Stay has been granted in that case.
In that number ಕೊಡಿ sir.
Yes, my lords.
Who was issued notice in that? Notice ಯಾರಿಗೆ issue ಮಾಡಿದ್ದು?
I'm unaware of that, my lords.
Not aware. Yes. Tag the petition along with so and so. Thursday, fresh matters list.
Beautiful.
Next.
107.
Five cases,
SIT has filed a charge sheet.
all cases ಅಲ್ಲಿ there is an interim order not to pronounce the judgment. Trial to go on.
They are unquoted.
Last page number
ಕೊಡಿ ಇಲ್ಲಿ.
412.
412.
Last page,
412.
page numbers. ಅದರಲ್ಲಿ entry order copy ಹಾಕಿದೆ.
412.
Annexure H.
Till 2, volume 2 ಇದೆಯಾ?
ಇಲ್ಲ ಒಂದೇ volume.
Volume 2 ಇದೆ sir. Not my orders.
No, no.
Yes. Because not to pronounce judgment generally.
The order which says the.
We'll see. Tag this petition along with writ petition 10841 of 2021. In the light of the interim order, the coordinate bench has granted an interim order of stay in the said petition, which reads as follows, page 412. In the light of the interim order subsisting in the said case, there shall be an interim order of stay of the kind that is granted in the companion petition in the case at hand as well. List them all on 11th September.
For respond number 1, my lord.
Leave us, sir.
Special public prosecutor that has been interested to appear in this matter.
Which one, sir?
In this,
PMLA na idu?
ಇಲ್ಲ PMLA ಅಲ್ಲ.
ಮತ್ತೆ?
ಲೋಕಾಯುಕ್ತ ಮ್ಯಾಟರ್. ಇದೇನೋ SLP pending ಇದೆ.
this is a special case.
Senate Council so and so undertakes to enter appearance for the respondent, first respondent, registry to print the name of so and so as appearing for the first respondent. Beda. List on variant tag beda. List on so and so.
Petitioner may be directed to. furnish the-
ಅದೆಲ್ಲ ಅವ್ರಿಗೆ
Professional
ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ,
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಡ್ತಾರೆ. Yes.
Madam.
Without obtaining sanction, the charge sheet has been filed.
Sanction ಯಾಕೆ ಬೇಕು ಸರ್ ಇದಕ್ಕೆ?
The identical
ಬೇರೆ
matters,
ಬೇರೆ ಗ್ರೌಂಡ್ ಇದ್ರೆ ಹೇಳಿ, ಕೊಡಿ ಐಡೆಂಟಿಕಲ್.
there is an interim order.
Give it, sir.
That is number 71 and 72 have obtained.
Copy these interim orders granted in this petitions. There shall be an interim order of stay as is obtaining in the companion petitions. List on date code, list on 18th September. Yes, but sanction ಬೇಕಾಗಿಲ್ಲ.
4 o'clock.
209 and 235.
237.
237. We'll hear it at 4 o'clock.
Yes. Or you want tomorrow or day after I'll reply. I will.
Or Madly, first,
Yeah,
let them
let
make
them
out the
start,
case.
please.
Yes. Password.
210.
While the joint memo, my lord, it may be.
Joint memo.
ಹೌದು.
Settle
Settlement
ಮಾಡ್ಕೊಂಡ್ರಾ?
ಆಗೋಗಿದೆ. ಆಗೋಗಿದೆ.
ಅದಕ್ಕೆ you should not escape settlements, sir.
No, 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 it is not that deliberate thing.
No.
It was an agreement and they have also agreed.
True. ಅದು ಕೊಡ್ಬೇಕು ತಾನೆ ದುಡ್ಡು ಅಗ್ರಿ ಮಾಡಿದ್ವಿ.
ಇಲ್ಲ, agreement ಅಂದ್ರೆ
ಇಲ್ಲಿ 421 ಟೆಕ್ನಿಕಾಲಿಟಿ ಎಲ್ಲ ಪ್ರೊಜೆಕ್ಟ್ ಮಾಡಿದ್ರಿ.
Not like that. The property was to be sold and that was not happened. There was a delay.
No problem.
There was a delay.
No issues. Yes.
2-3 ದಿವಸ time ಕೊಟ್ರೆ.
Settle ಆಗ್ತಾ ಇದೆ ಮೇಡಮ್.
Yes, sir.
List
Joint
on
memo also I have served.
your
draft copy.
learned counsel so and so enters, you filed ವಕಾಲತ್
My senior has filed.
ಇದೆಯಾ?
ಹೌದು, ಹಾಕಿದೆ, ಪ್ರಭಾಕರ್ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದಾರಲ್ಲ ಸರ್, ಎಸ್. Learned counsel appearing for the parties would submit that talks of settlement between the parties are afoot AFOT. Therefore, list the matter on Friday in the fresh matters, 2:30. At 2:30 PM to report settlement,
Interim order.
comma, if any. Interim order subsisting will continue to the next date of hearing.
211.
My lord, petitioner is running a hospital. My
Correct,
lord.
sir. Where is your degree certificate, sir?
I produced it, my lord.
Provisional ಅದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದೇ producer,
ಎಲ್ಲಿದೆ?
registration produce ಮಾಡಿದ್ದೀನಿ.
Registration ಬಿಡಿ, provisional degree certificate.
ಹೌದು,
Degree
sir,
certificate ಅಲ್ಲಿ.
ಅಲ್ಲ, I have registered ಮಾಡಿದ produce.
Register even under provisional ಮಾಡ್ತಾರೆ. Where is the degree certificate?
I'll produce it, my lord.
Produce ಮಾಡಿ.
Date may be given.
Yes, sir. For production
Yes, my lord.
or securing.
No, for producing itself.
Oh, sir. list the matter on 2 weeks, 3 weeks, 4 weeks.
And the court had directed to produce investigation.
ನೀವು ಫಸ್ಟ್ ನಿಮ್ ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸರ್, ಆಮೇಲೆ ನೋಡಿ.
Friday, this Friday only I'll produce.
ಅಷ್ಟರಲ್ಲೇ ಮಾಡ್ತೀರಾ?
Yes, sir.
ಇದೆಯಾ?
We already have it, my lord.
ಈಗೇನ್ ತರದ್ ಬೇಕಾಗಿಲ್ಲ. Yes. List the matter on Friday. The learned counsel for the petitioner is directed to place on record the degree certificate that ಯಾವ್ದು ಹೋಮಿಯೋಪತಿನಾ? ಹೋಮಿಯೋಪತಿ.
Dispute, my lord, is the complainant is claiming he is also the owner, my lord. I have produced my register.
ಪರವಾಗಿಲ್ಲ, ನೀವು ಡಾಕ್ಟರ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು, ಅದಕ್ಕೆ ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Yes, my lord.
Petitioner is directed to place on record the degree
certificate.
the petitioner's degree certificate. ಗೊತ್ತಾಯ್ತು ಮೇಡಮ್? The petitioner is directed to place on record the petitioner's degree certificate. Learned counsel of the petitioner. So, yes.
Friday.
Friday. Yes.
Fresh matter.
Fresh matter. Yes. List on Friday in the fresh matters list. Yes. Trivikram.
Please, my lords, and before
You're
your
again on
lordship,
missing.
I'm sorry, my lords, I'll appear personally, my lords, next hearing, my lords.
Yes.
And before your lordships are a very short
The petitioner
question, my lords.
is before this court calling in question proceedings in crime, calling in question CC ಆಗಿದೆಯಲ್ಲ?
CC agide, please.
CC
57637.
57637 of 2019. The petitioner and the complainant have several disputes pending between them. A civil suit was filed by the petitioner in OS 26573 of 2021 na?
2018.
2018. That is pending?
It is disposed of.
That is decreed, is it?
It is dismissed, my lords.
That's filed by whom?
That was filed by the petitioner, my lords.
ಆಮೇಲೆ ಇನ್ನೊಂದು?
ಅದು ಇನ್ನೊಂದು ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು ಪೆಂಡಿಂಗ್ ಇದೆ. Second respondent has filed, which my lords would get it at page 145 onwards. Annexure E.
145.
That is pending.
ಹಿಂಗ್ ತಗೊಳ್ಳಿ. During the pendency of the civil suit between the parties, the complainant seeks to register a private complaint which is referred to investigation and has later become a crime in crime number 336 of 2018. The police, after investigation, have filed a charge sheet for the following offences. Page 9 al prayer. A perusal at the private complaint would nowhere indicate that the complainant had complied with the rigor of subsection 1 of section 154 and subsection 3 of section 154 for registering 154 of the CRPC for knocking at the doors of the learned magistrate invoking section 200 of the CRPC. Neither an affidavit to that effect is placed before the court despite the judgment of the apex court in the case of Priyanka Srivatsava versus so and so, reported in 2015 6 SCC page 287. Therefore, there shall be an interim order of stay of further proceedings in CC so and so till the next date of hearing. 1 HCGP 2 emergent notice.
Grateful.
113.
Investigation. 2 years ಆಗಿದೆ.
ಅಲ್ಲ ರೀಸೆಂಟ್ ಆಗಿ
ಒನ್ ಮಂತ್ ಆಯ್ತು ಸ್ವಾಮಿ, ಇನ್ನ ಅವ್ರು ಏನು ಹುಡುಕ್ತಾನೆ ಇಲ್ಲ.
ಏನು ನಿಮ್ಮನ್ನು ಹುಡುಕ್ತಾ ಇದಾರೆ?
ಕಿಡ್ನಾಪ್ ಆಗಿರೋದು, ಕಿಡ್ನಾಪ್ ಮೇಲೆ ಕೇಸ್ ಆಗಿಲ್ಲ. ಓನ್ಲಿ ಜೀರೋ.
You are the wife, is it?
Wife has filed the petition.
Wife has
One
filed the
ನಿಮಿಷ.
petition.
Who has filed the complaint?
Wife, my lord. Husband is kidnapped, my lord. I given a
Husband is kidnapped or missing?
kidnap complaint I have given, but yeah, they have registered as a missing complaint.
Who has kidnapped according to you?
According to one phone number is also given, my lord. One phone party is.
Or he is living peacefully somewhere else?
No, my lord.
Ilva? Are you sure?
Yes, my lord. Till date, no. Yeah, they have not at all taken any action against.
Find the husband, sir.
Similar petition, my lord, pending in court number 2. Writ petition habeas corpus ಒಂದು ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಸರ್.
Same petitioner.
ಅದು ಯಾವತ್ತು ಇದೆ ಅಂದ್ರಲ್ಲ?
Week ಇದೆ sir. 2 weeks time was granted. It was listed last week.
ಸರ್, ಇದು ಕಿಡ್ನಾಪ್ ಮಿಸ್ಸಿಂಗ್?
Kidnap, my lord.
ಕಿಡ್ನಾಪ್ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಕಷ್ಟ. ಮಿಸ್ಸಿಂಗ್ ಆದ್ರೆ ಯು ಲೀವ್ ಹಿಮ್.
ಕಿಡ್ನಾಪಿಗೆ ಇದು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ ಸರ್. Only zero.
How long are you married?
Already 14, 15 years.
Agar is missing here. Yes. Yes, anyway, list the matter. Habeas corpus yavatide.
Speak it as, just verify the date.
List the matter. When do you want, sir?
Monday, next Monday.
Next Monday.
Fresh matter.
List on 12th.
Please.
Fresh matter.
Zero FIR is registered. Yes. Next.
214.
Represent the petitioner.
What happened before RERA?
RERA pending matter.
Pending, huh? Heard the learned senior counsel Prabhuling Naudgi appearing for the petitioner.
Connected petition.
The
There's a connected petition in which
the petitioners, the complainants are home buyers, have registered a crime against the petitioner after having approached RERA for redressal of their grievance. Therefore, they have set into motion two proceedings, one before the RERA and the crime so registered. Prima facie, permitting further proceedings in the impugned crime would amount to an abuse of the process of the law, albeit prima facie bantala, process of the law. Therefore, there shall be an interim order of stay of further proceedings. So and so. Tag this petition along with 25278 ilide, Madam Thodi. Memo alide. Anything else, sir?
No.
Yes.
216.
341, 504, 506, 323.
341 ಏನಿದೆ ಇದರಲ್ಲಿ ನೋಡಿದ್ದೀರಾ?
Should seek instructions, my lord.
You seek, better seek instruction.
There is a case and counter case.
ಗೊತ್ತು.
Yeah, the
Road rage.
road rage. And I was admitted to hospital, he went to police station for a complaint. So
You went to the hospital, he went to the station. So he registered a crime earlier.
Now both are in the same locality, my lord.
ತೊಂದರೆ ಇಲ್ಲ.
Same
The
party also.
petitioner and the complainant reside in the same locality. Both of them were appeared to be on a road rage, overtaking each other. It is alleged that by the complainant that the petitioner overtook his car and has assaulted him. The story narrated in the complaint is other way. The petitioner, on being assaulted, goes to the hospital for treatment. The complainant, on such assault, goes to the police station to register a complaint before the petitioner could register. In that light, there shall be an interim order of stay of further proceeding, further investigation, quay the petitioner till the next date of hearing. You seek all instruction and come, madam.
116.
This is what I said. There is one more case.
Serial number 134.
ಅದು ನಾನು ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದೆ ಅದು.
It is not counter case.
No, whatever. There is one more case where petitioners there are complainants here. Correct? Yes.
No, her client is also not the accused or complainant. Her name is mentioned.
There is, who is the complainant in this?
Complainant is respondent number 2.
In this, my lord, respond number 3.
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಯಾವುದು? 130?
9 is 134.
134, yes. ಇದರಲ್ಲಿ ಚಂದನ್ ಆರ್, you are for ಚಂದನ್ ಆರ್? Sorry, ನಿಮ್ದು 216.
216, the complaint is one Dr. Suja Isaac.
Correct. ಅದರಲ್ಲಿ accused is Suja Isaac. ಇವ್ರದ್ರಲ್ಲಿ accused is Suja Isaac.
No. I have given a complaint against her and her husband for cheating in respect to the
Correct.
property purchase.
ಅಲ್ಲಿ the
She
petitioners,
lodged a complaint against me.
petitioners are that Suja Isaac and some other person. 136 ಕೊಡಿ. Yes, sir, come.
136, 134 is my petition.
136 ಯಾವುದು?
134.
134.
Please, my lord.
134. Who is the complainant there?
Complainant is Suja Isaac.
Suja Isaac. Yes, sir. Against whom? Santosh.
Against Santosh.
Your petitioner is Santosh.
Yes.
Now come to this petition.
Petitioner is one Manayapanda Nachaya Chettiappa.
1 minute, sir. Here the complainant is Suja Isaac.
Yes.
Same against your accused number what?
My lord, my name is not there in the FIR.
Why are you
Complaint-
before the court then?
Your lordship, because what happened is 19th June 2023, for your lordship, they lodged complaint. Thereafter, they started calling me. They started the call, called the accused number 1 also. Thereafter, they did not register when they called me, your lordship, that time there was no FIR, neither against me nor against Santosh. Then your lordship, they proceeded to register the FIR on 26th of.
Yes, where are the investigation papers, madam?
I'll accept notice and I'll.
Accept notice, get the investigation, the notice kotra investigation paper kodtara avaru? Kodi mat. Yes, day after tomorrow in the fresh matters list. Let the investigation papers come in both these cases.
Please, my lordship.
Both case illa sir, one case. I have not the complaint.
No,
Very same day,
that's all right.
my case is not registered. Then I go to the court and get a reference. 2 weeks after, none case FIR is.
Tag this. Allah, list these petitions 134 and 216 day after tomorrow in seriatim. The learned HCGP is directed to secure the investigation papers and place it before the court. Yes, sir. Day after tomorrow we'll see. Transaction of 1991
No.
land.
This transaction is 2022.
All right, we'll see. Yes, let the papers come.
Then he retired. After the retirement, your
Doesn't
lordship purchased the.
Not it. Yes. Day after tomorrow.
117.
Hearing for the petition number 3 years.
3 years, sir.
3 years delay of
Stalking.
no, my lordship.
Ah.
Since it was an ingredient for the consensual relationship of 3 years past, and she has been falsely been arrested.
Yes, Idhu has to get the papers, madam. Time is registered on 1/6.
Connected matter with stay secret.
Kodia, tag this petition along with so and so, list them both on Wednesday in the fresh matters list. A number only there. Yes.
218.
Idu 7th. Learned Counsel BB Patil is directed to accept notice for the respondent petitioner to serve set of papers upon the said council list on 7th. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ ಅವತ್ತು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ನಾನು.
219.
Offenses in the section 75 and 79 of BNS.
Of BNS, which is 354 and 509 of IPC. Yes, sir.
And 509. Offense has been registered after 6 days, my lords.
No problems. Not fatals.
So even after, my lords, they say that there is a 4 minutes, 17 seconds conversation. And they only state 4 lines, my lords.
509 is clearly met. Sorry, 79 of BNS is clearly met.
But if 79, my lords, then it should be, it's a non-cognizant.
Non-cognizable. ಆಯ್ತು ಇರ್ಲಿ. ಜೊತೆಗೆ 354 ಇದೆಯಲ್ಲ. When it's
But
an amalgam of cognizable and non-cognizable.
4 will not be made out.
That we'll see, sir. Yes. Get the papers. 1 HCGP 2 emergent notice. Returnable by 3rd September. List on 3rd September in the fresh matters.
Great.
120.
Petition number 1, my lords, had given complaint on 5/3/2024, the counter blast. They had given.
Counter blast.
Please, my lords.
What blast?
On 22/3/2024, they have registered FIR stating the incident took place on 4/1/2024.
ಅವರು ಬರ್ತಾರೆ ಬರ್ಲಿ. ಎರಡು ಸೇರ್ ಮಾಡೋಣ. 1 HCGP 2 emergent notice in the meantime.
Connected matter stay has been granted, my lord.
In the meantime, ಕೊಟ್ಟಾಯ್ತು. ಬೇಡ ಅಷ್ಟೇ. Yes, sir.
21.
Crime and FIR number 248/2024.
We'll need the papers. ನೋಡಿದ್ಮೇಲೆ ಕೊಡು.
This is a matter, then the FIR is filed for trespass, my lord. But whereas I have a registered agreement with them. And this honorable court.
Agreement was not with possession.
No, agreement is with possession. It's a lease agreement.
Let's see, Friday. Get the papers.
Please.
List the matter on Friday in the fresh matters list. Investigation papers be secured and produced on the said date.
Great.
Yes.
22.
Driver.
Driver, sole accused. There is no direct
304A,
collision.
sir.
Direct collision, there is no direct collision, my lord. I request my lords to kindly take the sketch, my lord. I will try to.
That's a matter of trials.
But my submission is that.
I am not going to interfere in a case, drivers who are rash and negligent.
My lord, if it is a case, my lord, collusion, direct collusion, my lord, I would have agreed, my lord. I
In
may be-
indirect hingog bandra.
No,
ಮತ್ತೆ?
I stationed the vehicle. And when it is stationed, it is very clear from the sketch, my lord. I request my lords to kindly take the sketch.
Sir, in 482, you want me to examine the sketch?
My lord, that is that is the law, my lord.
Kodi sir.
Ambalal Bhatt has been followed,
Kodi
my
sir.
lord.
Sketch ಎಲ್ಲ ನೋಡಿ ನಾವು ಕೊಡ್ಬೇಕು ಇಲ್ಲಿ ಅಂತ
ಅಲ್ಲ
ಕೊಡಿ
sketch
sir.
ಅಂತಲ್ಲ, that is
ಮತ್ತೆ?
that
ನೀವು ಏನೋ sketch ಆಗ್ತಾ ಇದ್ರ
ಅಲ್ಲ ನಾನ್ sketch ಆಗ್ತಿಲ್ಲ, investigation papers.
ಅಲ್ಲ ಇಲ್ಲಿ ಬೇರೆ sketch ನೋಡಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾ
No,
ಇದ್ದೀನಿ.
the sketch which is part of the investigation report, my lord, in that my vehicle was stationed, he has come and he from backside he has colluded. And my lord,
Why did you station the vehicle there?
my lord, that is the highway on the left side I have stationed it, my lord.
Huh?
If my lords take the sketch, it would be very clear, my lord.
No, sir.
And
Yes.
kindly take, my lord, the sketch is at page number.
No,
53.
anyway, you'll get acquitted. Why are you worried?
My lord, why should I face it, my lord? Because the first thing is that.
No,
my
why
lord,
should I look into the sketch,
res
sir?
ipso locutor is not the principle which has no application in the criminal liability is concerned. And that has been considered by the Supreme Court, my lord. I may be permitted to
ಕೊಡಿ sir.
place that state of Karnataka versus Satish, my lord.
ಕೊಡಿ sir.
I will just read the head note, my lord. Negligent or rash driving of truck held has to be established by the prosecution and cannot be automatically presumed on the basis of res ipso locutor. Res ipso locutor, civil liability, I understand, my lord. Because liability has to be, civil liability has to be.
They will
considered.
prove it, sir. Why are you worried?
No, from the investigation paper, it is visible, my lord. And they say that I was negligent in stopping the vehicle. That cannot be an act. ರಸ್ತೆಯಲ್ಲಿ ನಾನು ನಿಲ್ಸೋದು, it is not a rash and negligent act. ರಸ್ತೆಯಲ್ಲಿ I am entitled to stop. I am entitled to station.
No, in the lay-by, you are entitled to station,
my lord.
not in the midstream.
I have no other place. That is the reason why I request my lords to kindly take
If
the
there was
sketch.
a lay-by on the highway and then you have stationed it there,
That is the
it's a
reason
different
why-
thing.
That is the reason why I request my lords to look into the sketch which is part of the investigation report.
Edge.
My lord, the crime detail form is available at page number 53, my lord. Then my lord, sketch is available at page number 56, my lord. At the sketch, my lords would find a service road, my lord. Then above that, my lord, there is a one particular marking that is a barricade, my lord. I cannot cross to the service road and station my vehicle. And then, my lord, above that, there is a apagata nadida sthala.
ಇದೆಲ್ಲ ಅಲ್ಲಿ evidence.
My lord, my only request, I am just referring to this particular state of Karnataka versus Ratish. And I am saying that,
consider it.
and I am also Ambalal Bhatt judgment, my lord, which my lords have followed in
Umpteen number of cases.
Yes, and that is
Vishwas was a case of an architect.
he was an architect. Same principle should be made applicable for the 304A.
Sir, architect design ಮಾಡಿ ಕೊಟ್ಮೇಲೆ he went away. 304A, somebody died there and he is not
understand,
responsible.
I am not on the.
You are the driver, sir.
Yes, my lord.
ಮತ್ತೆ?
I was the driver. The allegation is that it is not a direct collision from the front side. It is from the back side. My lord, in that event, if there is from the back side, if somebody comes and hit me, that does not mean that I am negligent.
That's a matter of evidence,
That
front
is
or
with
back.
respect of that is civil liability, my lord, res ipso locutor, that has to be applied. Insofar as criminal liability is concerned,
You'll get acquitted.
No, not the, why one should have faced it, my lord.
Because you stationed the vehicle in a wrong place.
The mere stationing of the vehicle, my lord, stopping of the vehicle, my lord, that
Discharge ಆಗ್ತೀರಾ?
with that liberty, my lord, that observation.
Always there. ಮೊದಲೇ ಹೇಳ್ಬೇಕಲ್ಲ.
I have filed that for that reason, because these are the principles which I have mentioned in my grounds.
Anyway, ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲೇ ಬರ್ತೀರಾ ತೊಂದ್ರೆ. ಮೇಡಮ್, ಡಿಸ್ಚಾರ್ಜ್ ಆರ್ಡರ್ ಒಂದಿದೆ. ಯಾಕೆ? ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. ಚೇಂಬರ್ ಕೇಳಿದ್ರೆ ಹೇಳ್ತಾರೆ.
Liberty, my lord.
Liberty, sir. Always. Yes.
It may be disposed. I am just referring to Vishwas, my lord, and on that.
The Vishwas architect case, sir. That's my order.
With the Vishwas, my lord, I was referring to res ipso locutor. That is Satish judgment. And I just wanted to develop on that basis.
ಅಲ್ಲ, Vishwas judgment, but
ಅದನ್ನ ಒಂದ್ ಸ್ವಲ್ಪ extend ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ.
applicable ಆಗಲ್ಲ. Yes.
Much.
23.
Yes, sir.
He has been released, my lord. He's been released.
Why? And how?
Trial court released him on bail.
But I'm going to haul these people who have arrested him.
Your lordship may see that notice was issued.
Undoubtedly, I'm going to haul these people who are arrested him.
No,
On the same day you serve
no, it is not on
notice?
same, no, it is not on the same day.
ಇಲ್ಲ
my lord.
clear ಆಗಿದೆ ಅಲ್ಲ ಕೊಡಿ ಇಲ್ಲಿ papers ಕೊಡಿ.
Yes.
How did you arrest this?
It's also CDs.
Where? What CDs, sir?
Case
How did
diary.
you arrest this man without complying with the judgment of the Supreme Court?
No, the notice, the dates which is mentioning are the dates are
He has appeared before you. Where is the question of arrest?
dates which you pointed out are the date which magistrate court receives this paper. That the signature found on the notice of 31/7 are the signatures of the magistrate.
I'll list tomorrow. I'm definitely going to pass orders against these people who have arrested him. Yeah, you take liberty of people for a raid.
Is now,
Do anything and everything you want.
in the entire region, my lord, and I've been told that multiple people is,
What multiple, sir, whatever it is, you have to follow the law.
the 2 notices he is not
What
responded.
third notice he came?
Yeah, but he's not.
Where was the question of taking him, saying that he has not appeared and getting signature on everything on the same day?
No, it is, your lordship may
It's
see
on the
case-
same day.
No, case day, your lordship may see the signature which is talking about
It is on the same day.
are magistrate signatures. 30th signature, the date mentioned is a magistrate signature, not his
Let me see
signature.
tomorrow. Yes.
And case diary is.
ಬಿಟ್ಟಿದಾರಲ್ಲ?
Please, but that is not my case. What he's trying to say that signature, like it is done earlier. My case is that it is taken on all 31st it's
Hmm.
for the first time when I was called, or
The
rather when I
CDs, my lord, CDs reflect the fact that notice was served on him. and-
ನಾಡಿದ್ದು ಹಾಕಿ. Day after tomorrow in the fresh matters.
Please.
Yes.
224.
It's
Fourth complaint.
Huh?
Fourth complaint.
That's the fifth complaint, actually. Sorry. Fifth complaint after the injunction is refused by specifically recording a finding that the contents which she wants to allege in the complaint is not
ಕಾಪಿ
acceptable.
ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ ಅವತ್ತು ಸ್ಟೇ ಕೊಡ್ಲಿಲ್ಲ
ಹೌದು.
ಅಷ್ಟೇ. Otherwise, the matter to be stayed. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. The complainant appears to be in the habit of registering repeated complaints. The learned senior counsel submits the impugned complaint is the fifth in line. All other complaints that were registered against these petitioners by the complainant have all been set at naught by coordinate orders passed by the coordinate benches of this court.
All but one. Lordships may all but one.
One,
One was retained because they filed multiple complaints on the
all,
principles.
all
but one.
except one, anta madam. All except one. In the light of the said circumstance and the issue being repeated complaints being filed against these petitioners, there shall be an interim order of stay of further investigation in the impugned proceedings till the next date of hearing. 1 HCGP, 2 emergent notice.
Please.
Yes.
25.
420, I'm registering.
225. The petitioner is accused number 8, a sub-registrar who registers the document that is brought before him. The allegation is that the petitioner, ಇಲ್ಲಿ basement ಹೋದ್ರಾ?
Parking area.
The petitioner goes to the parking area and registers the deed as was sought. The explanation offered by the petitioner is that the signatory could not walk up to the office of the sub-registrar. Therefore, he had to go down and get the signature on the document. This prima facie cannot mean that it is an offense of the functioning of, it is an offense for the petitioner to have registered having gone down to the parking area. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner accused number 8 till the next date of hearing. 1
Investigation.
Huh?
Further investigation.
Further investigation till the next date of hearing. Qua accused number 8, the petitioner. Next.
Let's notice to our.
ಅದೆಲ್ಲ ಮಾಡ್ತೀವಿ. 1 ಮೇಡಮ್ ಅದು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 1 HCGP, 2 emergent notice common. Yes. ಅದು ನೀವು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದ್ದೀರಾ ಗೊತ್ತಾಗ ಎಲ್ಲ ಹೇಳ್ಬೇಕಾದ್ರೆ. Yes.
226.
498A and 306.
Lethal combination. 498A, 306.
All are relatives, my lord. They are no way
Don't know,
connected
sir.
with this offense.
We don't know what has instigated commission of suicide.
Even in a complainant is mother of victim. It's an all hearsay complaint which are.
No. This we will not. Let investigation go on. ಯಾವತ್ crime register ಆಗಿರೋದು?
It's in 12/6/2024.
ಮತ್ತೆ? It's an offense, 498/306, we don't know. 498/306, 498/304B, 498/307, they're all lethal combinations.
ಹಳ್ಳಿಯವರು ಅವರೆಲ್ಲ ಬೇಲೂರಲ್ಲಿ ಇರೋರು, they are residing in Bangalore.
That we'll see, let the investigation go on. ಒಂದು 4 weeks ಬಿಟ್ಟು ಹಾಕ್ತೀನಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾಗಿರುತ್ತೆ ನೋಡ. List the matter on 12th September. Yes.
227.
ಮತ್ತೆ why are you back to the court, sir? Jagdish.
Lordship, this
ನಿಮ್ಮ Attica gold.
411 or 413, Lordship.
Hello,
will not
Attica
attract-
gold, why is it?
Lordship, the 413 and 411 will not attract on the, against the accused person, Lordship. Or I'm relying on the Supreme Court judgment on this.
All right, you give it to him.
No, I will.
ಅಲ್ಲ ಕಾಪಿ ಏನ್ ಕೊಡು, 230 ಮೂವ್ ಮಾಡಿಲ್ಲ ನೀನು ಕಾಪಿ ಕೊಡ್ಬೇಕಾಗಿ.
So, Lordship, the accused must have a knowledge at the time of buying.
ಆಯ್ತು, ನಾಳೆ ತಗೊಂತೀನಿ. Let him see.
Okay.
ನಾಡಿದ್ದು ತಗೊಳ್ಳ? ಆಯ್ತು, list day after tomorrow in the fresh matters list. ಕೊಡಿ, ಫೈಲ್ ಕೊಡಿ.
Lord, kindly may I request for tomorrow, Lordship.
ಯಾಕೆ ನಾಳೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತಾರ?
No, no, because
2023 crime sir ಇದು.
I'm in Telangana, I could have some matter there.
You are going to Telangana. You begin to go
Hyderabad.
there also. Okay, yes. Oh, ಅಲ್ಲೂ ಇದೆ.
No, I don't have any other matters other than this.
ಮತ್ತೆ what do you mean? What are you talking of, Tahir? What is this?
In lighter mode, he may say
No,
many
no,
things.
I said.
He say
Tahir has
many
begun
things
to,
in lighter
no,
mode.
why I said was Tahir has begun to appear pan-India. Yes. Yes.
I will appear there in VC. I will.
Either way, sir. ಎಲ್ಲದಕ್ಕೂ ಸೀರಿಯಸ್ ಆಗಿ ತಗೊಂತೀರಾ?
Kindly have it
Yes.
tomorrow.
Tomorrow at 2:30. You should take something easy, sir. Why all serious?
Taken it, everything
Yes.
easy, Lordship.
Tomorrow at 2:30.
28.
Same, 7th, Learned Counsel B.V. Patil is directed to accept notice for the respondent, petitioner to serve set of papers. ಇದೇನೊಂದು 20 ಹಾಕಿದ್ದೀರಾ ಈಗ?
ಅದಂಗ್ ಕಾಣುತ್ತೆ sir.
ಹಾ? ಕಾಪಿ ಕೊಡಿ, ಎಸ್, ಲಿಸ್ಟ್ ಆನ್
Please, sir.
7th,
Please.
ಎಲ್ಲು 13, DA. 7 ಆದ್ರೆ 8.
229.
Respondent number 1, my lord.
Withdrawal in terms of the memo.
My lord, one more matter is there, my lord.
ಏನು?
ಅದು ಇನ್ನೊಂದು ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
ಯಾವ್ದು ಒಂದು more matter?
ಅಲ್ಲ, ನಂಬರ್ ಆಗಿಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ, ಕೊಡ್ತೀನಿ ನಂಬರ್.
ಯಾವ್ದಕ್ಕೆ?
ಇದಕ್ಕೆ my lord.
ಇದು withdrawal, ನಿಮಗೆ ಏನು ಪ್ರಾಬ್ಲಮ್ withdrawal?
ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ my lord, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಅದು ವಿಡ್ರಾ ಮಾಡ್ಬೇಕಾ?
Yes.
ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes.
ಓ, ಎಸ್, ಅದು ತರಿಸ್ಬಿಡಿ ಮೇಡಮ್, ಕಳಿಸ್ಬಿಡೋಣ ಅದು. ಎಸ್, ಇನ್ ಟರ್ಮ್ಸ್ ವಿಡ್ರಾನ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದ ಮೆಮೋ.
230.
I may be permitted to take notice of the second respondent.
ಏನು ಸ್ಟೆಪ್ಸೇ ತಗೊಂಡಿಲ್ಲ?
Steps ತಗೊಂಡಿಲ್ಲ
Lord,
ಅಂತ.
I was not aware that notice was issued, my lord, so I paid the process today, my lord.
ಹಾ,
Even I take notice of second respondent.
Taking notice then.
Learned Counsel P. Prasanna Kumar accepts notice for the second respondent. Registry to print the name of so and so is appearing for the second respondent.
Let them serve me a
Copy
copy.
ಇದೆಯಾ?
ಇಲ್ಲ, ಕೊಟ್ಟಿಲ್ಲ,
Petitioner to
ಬಂದಿಲ್ಲ.
serve set of papers upon Counsel P. Prasanna Kumar. ಯಾವತ್ತು ಹಾಕ್ಲಿ?
My lords, the issue on the last date, your lordship directed the.
Now that he is there,
Alala,
we'll
to-
hear
to
him.
Submit the investigation papers, everything arising out of clearly an agreement. And in the agreement, it is not even that we don't want to make the payments.
Additional SPP to secure investigation report. Investigation papers. ಇದೆಯಾ? ಅದೇನು ಅಷ್ಟೊಂದಿದೆ? See, so much of investigation on an agreement.
Yeah, just arising out of agreement. And
Him.
here there are clear cases of
Petition
abuse.
ಕೊಡ್ಲಿ, let me also have a look at it.
ಸರಿ.
No, it's a short
ಅಲ್ಲ,
wait then.
ಆ ಥರ ಇಲ್ಲ ಅಂದ್ರೆ he will not heavily contest.
ಅಲ್ಲ, ಇಲ್ಲಿ against two prosecutors there.
No problems. Yes, ಕೊಡಿ. ಬೇಡ, ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ. Yes, list on Friday.
Friday, but Monday.
List on Monday, 12th,
Please.
in the fresh matters list. Yes.
Admission 231.
ಯಾಕೆ ಮೇಡಮ್ ಇದು ಅಡ್ಮಿಷನ್?
Investigation paper.
ಯಾವ್ದ್ರಲ್ಲಿ?
231.
ಯಾಕೆ ಇದು ಕೊಟ್ಟಿದ್ರು ಮೇಡಮ್ ಫೈಲ್?
I appear for
ಫೈಲ್ ಕೊಟ್ಟಿಲ್ಲ, ಫೈಲ್ ಕಳಿಸಿಲ್ಲ. ಎಲ್ಲಿ ಪೇಪರ್ಸ್ ಕೊಡಿ. Day after tomorrow, fresh matters list. Yes.
Please.
Settlement.
Reporting settlement 232.
Respondents are not coming, my lord.
Not coming. Then we'll petition, we'll send the petition. Dismissed.
My lord. So mediation report ಹಾಕಿದೀವಿ ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಸೆಟಲ್ ಆಗಿದ್ದೀನಿ ಅಂತ.
ಆಗಿದ್ಯಾ?
ಹಾ,
List on 20th at 2:30 PM to report settlement if any. In the event no settlement is reported, the matter would be taken upon its merit. Investigation. ಇದೆಲ್ಲ 4 PM ಗೆ 3:30 ಗೆ ಪಾಸ್ ಅವರಿಗೆ
Additional documents also produced subsequent to incident.
Yes, sir.
Really, the two things, my lord, which I will notice, did not notice last date of occasion. Issue, my lord, on 21/2/2024, a notice was issued to him. Ask him to provide CCTV details, images and details. And he is not responding. In fact, he is not responded to that. The CDs also, my lord, speaks about the
CCTV footage ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
Footage ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ
DVR ನ ಕೊಟ್ರೆ ನಾವೇ ಮಾಡ್ತೀವಿ. DVR ನ ಕೊಟ್ರೆ ನಾವೇ
produce ಮಾಡಿದೀನಿ.
ಅಲ್ಲ, you produce whatever you want to the investigating officer.
I produce the bills also. You are asking.
ನೀವು ಏನೇನು
Just one second, one second complaint ಹೋಗ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ.
What prevented him to do all those things?
Sir, it is already over now. You can't put the clock back.
Why I am submitting your internal page, your 24 typed copy I produce your I will take only one few, let the internal page 25. ದಿನಾಂಕ 17/2/24 ಬೆಳಗ್ಗೆ 7:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕುಮಾರಿಗೌಡ ಮತ್ತು ಈತನ ಸಹಚರರು ಉಮೇಶ್ವರ್ ಜಾಗ್ವಾರ್, ಈಶ್ವರ್ ಮತ್ತು ಬೆಂಗಳೂರಿನ ಸುಮಾರು 100 ಜನ ನಮ್ಮ ತೋಟಕ್ಕೆ ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ದರೋಡೆ ಮಾಡುವ ಉದ್ದೇಶದ ಕಾಂಪೌಂಡ್ ಗೇಟ್ ನಂಬರ್ KA 51MN3655 JCB ಇಂದ ಕೆಡವಿ ಒಳಗೆ ಬಂದು ನಾನು ವಾಸವಿದ್ದ ತೋಟದ ಮನೆಯ ಕಾಂಪೌಂಡ್ ನಲ್ಲಿ ಮತ್ತು RCC ಮನೆಯಲ್ಲಿ ಅಳವಡಿಸಿದ CC ಕ್ಯಾಮೆರಾಗಳು ಒಡೆದು ಹಾಕಿ ಮನೆಯಲ್ಲಿ ಇದ್ದ CCTV, ಫ್ರಿಡ್ಜ್, ಗ್ಯಾಸ್ ಸ್ಟವ್, ಸಿಲಿಂಡರ್, ಅಲ್ಮೇರಾ ಹಾಗೂ ಅಲ್ಮೇರಾ ಒಳಗೆ ತಾಯಿ ಸಂಬಂಧಿಸಿದ ಒಡವೆಗಳನ್ನು ಮತ್ತು ಮನೆಯ ದಾಖಲೆಗಳನ್ನು ದೋಚಿಕೊಂಡು RCC ಮನೆ ಹಾಗೂ ಕಾಂಪೌಂಡ್ ಒಂದು JCB ಇಂದ ಒಡೆದು ಹಾಕಿರುತ್ತಾರೆ. ಇದರ ಮೌಲ್ಯ ಸುಮಾರು 20 ಲಕ್ಷ so. I have produced the photos also. JCB they have taken into possession. Subsequently, it has been released to the owner. My submission, your lordship, the JCB owner is the prime witnesses. Who has hired the JCB? Who has paid the rent for being used the JCB? And that has not been done. Till date. Till date.
Yes, Jagdish.
No, all those things are done, my lord. The issue is, their allegation is that we have not recovered the CCTV DVR. Now, we have issued a notice to him on 21/2/2024. So asking him to provide the DVR. In fact,
ಈಗ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಅದು?
CCTV ಎಲ್ಲಾನು DVR, CC ಕ್ಯಾಮೆರಾಗಳು, everything they have been taken away. They know it very well because it is the
Then your allegation is CCTV footage was not there. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿಂದ ತಗೊಂಡೋಗ.
ಅಲ್ಲ ನಾನು ಈಗ assuming for the sake of argument you are asking for CCTV
No,
footage.
for the sake of argument ಅಲ್ಲ, sake of investigation ಹೇಳಿ.
Yes, one ನಿಮಿಷ. I have produced the photos along with my complaint. Those are the person you are asking in pen number 46 you are asking. My father is a military man. This land has been granted to him. One ನಿಮಿಷ.
Title ನೋಡಿದ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು.
I am not saying, look, not lying that ground. Your lordship saying 47 photos have been produced to show earlier is also same incident has taken place, case has been registered against the Kumar.
What happened to that?
It's pending. It is pending. The second incident was what I am submitting. The prime witness is your lordship, the driver of the JCB and owner of the JCB.
we have recorded all those.
Before, after.
We have recorded all those things. Even we have taken all those things. It is not that we are.
What is the stage of investigation?
Investigation is still an investigation. My lord, that issue is that allegation against him, allegation against her, we are not doing a proper investigation because we have not collected a CCTV. I was also under the impression, my lord, that we have not collected the DVR which was damaged.
DVR ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಇಲ್ಲಿ ನಾವು notice ಕೊಟ್ಟಾಗ he could have responded to this notice saying that there is no DVR.
My submission, you are actually, I have produced all those.
ಈಗ investigation is still on.
Still on.
Then you appear before the investigating officer and submit whatever you want.
That also I submit your. I
ಮಾಡಿ.
went to the police station. After
ಈಗ-
counter case registered. The matter has been quashed.
Counter
That-
case.
ಯಾವುದು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ನಮ್ಮ ಮೇಲೆ
ಹಾ.
427, 447. This proceeding has been quashed by this honorable court.
All right.
I went along with and documents. They have not received. Then I sent it by postal.
ಈಗ investigation is not complete,
Not
sir.
completed.
Don't get touchy. You give everything to the investigating officer now.
Certainly.
Ah.
Certainly, Your Honor.
Ask your investigating officer
Because-
to receive whatever he is giving and
The TVR also,
take
my lord,
note.
I have been
ಈಗ
told, my lord,
DVR ಅವ್ರ ಹತ್ರ ಇದ್ರೆ ಕೊಡ್ತಾರೆ.
I have been
ಅದು
told, he
ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದ್ರೆ ಇನ್ನೇನು?
I have been told he has the DVR and he is not willing.
Then give it.
And what I am submitting.
DVR ಇದೆಯಾ ಇಲ್ವಾ?
ನಮ್ಮ ಹತ್ರ DVR ಇಲ್ಲ ಇವಾಗ. ಎಲ್ಲರೂ ಸ್ವಲ್ಪ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಯಾರು ತಗೊಂಡು?
DVR ಯಾರು accused number ಕುಮಾರಿಗೌಡ and his ಇದು auto persons. Why I am submitting? And that day I was also not in station. ನನ್ನ ಕಾಲ್ ರಿಕಾರ್ಡ್ ತಗೊಂಡ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ನಾನು ಅಲ್ಲಿ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಇದ್ದೀನ ಇಲ್ಲ ಅಂತ.
Now you appear before the investigating officer and give whatever you want. List the matter on 22nd. Let them not come. Let him appear before the investigating officer. Ask them to take whatever he gives
Yes.
and let's see. Let there be collection of appropriate documents.
ನಾನು ಇದು IGP ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದೀನಿ, ಆಮೇಲೆ DGP ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದೀನಿ. ಇದರಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಡೀತಾ ಸ್ವಲ್ಪ ಪ್ರಾಪರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಹೂ ಆರ್ ಮೇ ಇಫ್ ಐ ಆಮ್ convict, I am a offender, let them reach the case against me also. What I am requesting
I'll
is there
request
must
the
be a
SP.
fair and impartial investigation.
I'll request the SP, my lord, that investigation officer.
ಅಲ್ಲ SP ಬೇಡ ಸ್ವಾಮಿ,
Sir,
SP
I'll
ಬೇಡ.
request the
ಯಾಕಂದ್ರೆ
ಜಾಸ್ತಿ ಆಯ್ತು.
ಹೇಳ್ತೀನಿ, I approached him very next day. He said
DG and IG ಬೇಕಾ?
ಅವರಲ್ಲಿ ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ, ಅವರಲ್ಲಿ ಮಾಡಿಸಿ. ಯಾಕಂತಂದ್ರೆ ದಿ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಅಪ್ರೋಚ್ SP, ಗಿವನ್ ಆಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂಡ್ ಸೆಡ್ ಏನ್ರಿ ಇದನ್ನ ಮಾಡೋದು, ಅವ್ನು ಏಜ್ ಪರ್ಸನ್ ಬಿಡ್ರಿ
ಬೇರೆ
ಏನಾಗುತ್ತೆ.
ಸ್ಟೇಟ್ ಇಂದ ಯಾರು ಬೇಕಾ?
ಸಾರಿ,
ಬೇರೆ ಸ್ಟೇಟ್ ಇಂದ
ಬೇಡ ಬೇಡ ಬೇಡ. ಐ ಡೋಂಟ್ ಅಬೌವ್ SP ನನ್ಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬೇಕು. ದಟ್ಸ್ ಆಲ್. I want to go into fair investigation.
First appear before the IO and
You
give
will
whatever
appear
you
in
want.
court.
Let me see later.
We will appear it also.
ನೀವು ಬಿಟ್ರೆ ಬೇರೆ ಸ್ಟೇಟ್ DG and IG ನ
ಇಲ್ಲ
ಬೇಕಾ?
ಬೇಡ ಬೇಡ, ನಮ್ಗೆ we don't want that one because we having a faith with the Karnataka police.
Oh,
Yes, certainly.
very good. ಆಯ್ತು, ಈ ಟೈಟಲ್ ಗಾರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಯಾಕೆಂದ್ರೆ ಈಗ ಸ್ವಾಮಿ ಆ ದರ್ಶನ್ ಕೇಸಲ್ಲಿ ಮತ್ತೆ ಬೇರೆ ಬೇರೆ ಕೇಸಲ್ಲಿ ಹೇಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ
ಹೌದಾ?
we have to appreciate those investigating officers.
Oh. Why are you following those cases?
ಅದೇ see, that's what I am submitting, Your Worship. That is accused number 1 is in the habit of doing all those things. ಈಗ ನನಗೆ 107 ಇದು ಮಾಡಿದ್ದಾರೆ, 107 ಇದು ಮಾಡಿದ್ದಾರೆ, ಇಂಪೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ಮೆಲ್ಲ
107
ಬಾಂಡ್ ಕೊಡಕ್ ಹೇಳಿದಾರ?
ಬಾಂಡ್ ವರ್ಕ್ ಹೋಗ್ಲಿ, ವಾಂಟ್ ಚಾಲೆಂಜ್ ದಟ್ ಆರ್ಡರ್ ಆಲ್ಸೋ.
ತಗೊಂಬನ್ನಿ.
Yes, Your Worship. I'm going to file it. ಅಲ್ಲ ಯಾಕೆ ಈ ವಿಷಯ ಹೇಳ್ತೇನೆ ಅಂದ್ರೆ ಐ ಆಮ್ ಟಾರ್ಗೆಟಿಂಗ್ ಆಲ್ ಲೆವೆಲ್ ಬಿಕಾಸ್ ಐ ಅಪ್ರೋಚ್ ದ ಹೈಯರ್ ಅಥಾರಿಟೀಸ್.
9.
Yes, sir. We'll give you to the highest authority.
ಇನ್ನೊಂದು ಬೇಕಾದ್ರೆ ಅವರು ನಮ್ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ನಾವು ಅವತ್ತ
Appear ಆಗಿ sir,
ಅನ್ನೋದು
ಅವ್ರಿಗೆ
ಗೊತ್ತಾಗುತ್ತೆ.
ಏನ್ ಬೇಕೆಲ್ಲ ಕೊಡಿ, ನೀವು ಎಲ್ಲ ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಟ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೆಂಗೆ?
ಆಯ್ತು ಆಯ್ತು, you furnish it, there is no problem.
Everything. I have told investigating officer is here. Yes, let him not say, I will not take this, not take that.
No, ma'am.
You cooperate with the investigating
Certainly,
officer, a proper final report will be ready.
Certainly, Your Honor, certainly cooperate with the investigator.
Yes, sir. ಮೇಡಮ್ ಎಲ್ಲ 4 o'clock ಏನಾ? ಪಾಸ್ ಓವರ್ ಉನ್ನಿಕೃಷ್ಣನ್ ಇದಾರೆ ನೋಡು, ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Past four matters. Bill number 11.
ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಆಫ್ ಬೇಲ್ ಕಂಡೀಷನ್
408, 420 and
ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಬಿಡಿ. ಇವಾಗ ಬಂದಿರೋದು ರಿಲ್ಯಾಕ್ಸೇಷನ್ ಆಫ್ ಬೇಲ್ ಕಂಡೀಷನ್. ವೇರ್ ಡು ಯು ವಾಂಟ್ ಟು ಟ್ರಾವೆಲ್?
to US, my lord. I filed the affidavit.
ಅಫಿಡವಿಟ್ ಹಾಕಿದಾರಾ? ಎಲ್ಲಿದೆ ಅಫಿಡವಿಟ್?
There are 4 of them. Lord, in fact, in
ಇದು
this case, offense alleged
which
is only
petition, sir?
7 years.
Huh?
Offense alleged is only 7 years. And one observation of the magistrate himself when he has given the bail.
That's all right. First I will permit you to travel, ಮಿಕ್ಕಿದ ಆಮೇಲೆ ನೋಡೋಣ. One-
4, my lord.
Which petition? Criminal petition?
Criminal petition 12,786, my lord.
I am there only. Yes. The petitioner is before this court calling in question an order dated 8/6/2023 passed by the Court of Session imposing certain conditions while grant of bail. The conditions are as follows, page 52 and 53, marked portion, madam. The petitioner claims to be aggrieved by the condition that he will not leave the jurisdiction of this court without prior permission. Adondena?
Accused number 2 shall surrender his passport.
And as also the observation that the accused number 2 shall, where is that?
Page 53, my lord.
Condition
Second
number?
two. Two, my lord.
And the condition that the accused number 2 shall surrender the passport before the investigating officer. This observation, this condition that is imposed while granting bail runs counter to plethora of judgments rendered by the apex court that it amounts to impounding of the passport, and the power to impound the passport is only with the passport authorities under subsection 3 of section 10 of the Passports Act, and not with the court or a direction to the IO to keep the passport in his custody. In that light, the said condition would run foul of the aforesaid observation of it being contrary to several judgments of the apex court. Therefore, the investigating officer shall forthwith hand over the passport to the petitioner with a condition that subject to the passport authorities invoking proceedings under subsection 3 of section 10 of the Passports Act seeking to impound the same. The other condition is that the petitioner would not leave the jurisdiction of the court. The petitioner is now wanting to travel beyond the shores of the nation, i.e. to the United States of America, and has filed an affidavit to that effect. The affidavit so filed reads as follows.
Para 4 and
Flag ಹಾಕಿದೆ
D and
madam.
4.
Affidavit flag ಹಾಕಿದೆ. Reads as follows. The petitioner seeks to travel 15th November 24 ga.
15 November.
ಅದಕ್ಕೆ ಈಗಲೇ ಯಾಕೆ urgency ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Passport is not there, so I cannot even buy the ticket now. So I cannot give the that.
But passport he cannot direct. That is not permissible at all. So the petitioner, the affidavit reads as follows. The petitioner is wanting to travel between the 15th of November 24 to 25th December 2024. He is permitted to travel, subject to the condition that he would return back to the shores of the nation after on the 25th of December 2024, failing which the matter would be viewed seriously. All this would, however, be subject to the condition, subject to the liberty of the passport authorities initiating proceedings under the Passports Act, if any and if needed.
My lord, insofar as the return is concerned, since there was no passport, I have only tentative date I have given. That is subject to availability of ticket. So date may vary, but in para 6 I have made an undertaking.
New Year ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ಬೇಕಾ?
ಅಲ್ಲ ಇಲ್ಲ, ನಾನು ಟಿಕೆಟ್ ಸಿಕ್ಕ ಮೇಲೆ I will go to the magistrate and file an affidavit submitting the tickets and give the dates when I am returning it. Submitting the ticket.
ಅದು ಇಲ್ಲೇ ಮಾಡಿ.
ಇಲ್ಲಿ ಈ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಸದ್ಯಕ್ಕೆ ಆರ್ಡರ್ ಅಲ್ಲಿ list the matter on 20th in the fresh matters list. Yes.
In the connected matter.
Connected matter may be dealing.
Connected matter ಆಮೇಲೆ ಮಾಡುವ.
Please.
ನಿಮ್ದು ಅದು?
ಅಲ್ಲ, for respondent number 4 and 5.
Dealing 11.1. Yes.
Like there is a stay, my lord, in that matter.
That may be
Connected matter is stay there. Investigation has been installed in less than.
11.1.
Please.
Not my order.
No.
11.1 dealing and list it on Friday in the fresh matters list.
Obliged.
Interim order is already.
Interim order subsisting shall continue till the next date of hearing.
Obliged.
ಅಷ್ಟೇ.
Number 15.
Petition by God.
ಯಾಕ್ pass ಮಾಡೋದು? Why pass ಮಾಡೋದು? ಇದು.
Lordship, this would be the
Ah,
complaint.
page number.
52
Yes, sir.
is a typed.
ನೋಡಿ ಬೆಳಗ್ಗೆ ಪೇಜ್ ನಂಬರ್ ನೋಡಿದ್ರೆ ಇಷ್ಟೊತ್ತು ಕಾಯ್ಬೇಕಾಗಿರ್ಲಿ. Yes.
Yes.
1 HCGP 2 emergent notice. There shall be an interim order of stay of further proceedings. Quay the petitioner till further investigation. Quay the petitioner till the next date of hearing. Stay ಕೊಡೋ ಕೇಸೆ ಬಟ್ ನೀವು ಯಾವ ಕೇಸ್ ಒಂದು ನೋಡ್ರಿ. Yes.
21.
ಗೊತ್ತಾಯ್ತು ಮೇಡಮ್. 15.
Milord, appearing for petitioner, Milord. Milord, the incident happened on 3/8/2021, Milord, in Vishal Comfort. Milord, kindly peruse.
307.
Sir, Milord, page number 29, Milord. 1 minute. In para 4 of that page number 29, Milord. ಅದೇ ದಿನ ಅದೇ ಕಾರಣಕ್ಕೆ A1 ರಿಂದ A5 ಹಾಗೂ ಕಾನೂನು
ಅಷ್ಟೇ ಅಲ್ಲಿಗೆ ನಿಲ್ಸ್ಬಿಡಿ. A1 ನೀವೇ which accused are you?
A5, Milord.
A1 ಇಂದ A5 ಇಂಡಿವಿಜುವಲ್ ಓವರ್ಟ್ಯಾಕ್ಟ್ ಯಾರ ಮೇಲೂ ಇಲ್ಲ. ಎಲ್ಲ A1 to A5 ಒಟ್ಟಿಗೆ
Charged with 143.
ಹಿಡಿದು ಹಾಕಿ ಬೀರ್ ಬಾಟಲ್ ತೆಗೆದುಕೊಂಡು ಮಧ್ಯಾಹ್ನ.
That is against A1, Milord.
ಎಗನೆಸ್ಟ್ ಇಲ್ಲ, ಎಲ್ಲ A1 to A5 ಟುಗೆದರ್.
In para 3 it is confirmed, Milord.
ನೋ ಸರ್.
Milord, kindly 1 minute.
ಆಯ್ತು ಓದಿ ಸರ್.
Milord, in para 3 page number 29, Milord. ಸಾಕ್ಷಿ ರವಿಕುಮಾರ್ ಅವರು A1 ರಿಂದ A5 ರವರೆಗೆ ಮತ್ತು ಕಾನೂನು ಸಂಘರ್ಷಕ್ಕೊಳಗಾದ ಬಾಲಕ ನಿಖಿಲ್ ಏಕೆ ಈ ರೀತಿ ಹೊಡೆದು ಹಾಳು ಮಾಡುತ್ತಿದ್ದೀರೆಂದು ಗಲಾಟೆ ಮಾಡಬೇಡಿ ಎಂದು ಕೇಳಿದಕ್ಕೆ A1 ರವರು ಅಲ್ಲಿಯೇ ಅರ್ಧಂಬರ್ಧ ಒಡೆದು ಬಿದ್ದಿದ್ದ ಗಾಜಿನ ಒಂದು ಬೀರು ಬಾಟಲ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಇವತ್ತು ಮಧ್ಯಾಹ್ನದಿಂದ ನೋಡುತ್ತಿದ್ದೇನೆ, ನೀನು ಸರಿಯಾಗಿ ಸಪ್ಲೈ ಮಾಡದೆ ಕಿರಿಕ್ ಮಾಡುತ್ತಿದ್ದೀಯಾ ಅಂತ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದಿ ನಿನ್ನನ್ನು ಮುಗಿಸುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಸಾಕ್ಷಿ.
ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್?
ರವಿಕುಮಾರ್ ಇಟ್ ಸೆಲ್ಫ್.
Who is Ravikumar?
He is a supplier, Milord.
Exactly. You should know how to treat a supplier.
Milord,
I will not interfere in this. Just because he is a supplier, all of you drink and create problems and hit him also.
no, Milord,
No,
not
sir.
against me, Milord.
Whoever,
completely.
you are also there in that. ನೀವೇನ್ ಕುಡಿದಿರ್ಲಿಲ್ವಾ?
No,
ನಿಮಗೇನ್ ಸಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
no,
Just because he is supplier, you can do anything?
no, Milord. Like,
No, sir.
Milord, even it's confirmed by the eyewitnesses statement.
No problems. You can't treat supplier dehors dignity, sir. He is also a human being. But that doesn't mean you
That was
can,
made by the
in
A1
an
and
inebriated state, yes. Discharge. Charge sheet ಹಾಕಿದ್ಮೇಲೆ ಹಾಕೊಳ್ಳಿ.
Milord, charge sheet has
ಸಾರಿ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ. ಒಂದು ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಮೇಡಮ್, ಚೇಂಬರ್ ಕೇಳಿ. ಡಿಸ್ಚಾರ್ಜ್ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ, ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ, ಚೇಂಬರ್ ಕೇಳಿ. ಎಸ್, ಲಿಬರ್ಟಿ.
Interim. We should not be parting. Lordships. Informed the senior with the lordship's concern, my lord. I informed your lordship's concern to the senior. He points my permitted or with instructions, my lord. Kindly, my lord. Page number 50, my lord.
You file discharge. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ
Page number 50, my lord. Page number 50, my lord.
ಆಯ್ತು ಸರಿ ಹೇಳಿ.
Page number. This is a suit for partition, my lord. Pending consideration.
ಅದೇನ್ ಅಲಿಗೇಷನ್ ಅಲ್ಲ ಅದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನಂದ್ರೆ this suit is pending in Nenmangala, my lord.
Maybe.
And the complaint is filed in Tumkur, my lord. And he is a
That's a
practice,
different, that we'll see.
and he is a practicing advocate.
Sir, the allegations made in the complaint, I am telling you, Allah, you also should not support.
Certain my lord, will not support, my lord. My lord, the respondent being the elder son of the family, my lord. And this is a suit for partition. It is not that before advocate.
That is why I said you file discharge.
My lord,
You may get discharge on that ground that you are so and so.
my lord, before he becoming an advocate, he was a son to the family, my lord.
That ಅವ್ರ ಹತ್ರ ಕೂತ್ಕೊಂಡು ಸೆಟ್ಲ್ ಮಾಡಿ.
Certainly, my lord.
But this allegation will not go away, sir.
Please, my lord. And this complaint is filed in the Tumkur, my lord.
ಆಯ್ತು. Sunil should use his rolling stone technique. Yes.
But with one submission, Malad. Let this be CC be transferred to Nenmangla. Since Nenmangla, the suit is also pending concession.
You file discharge, seek anything, any observation I will make definitely is going to trouble you. I will make, I'm not telling, I'm not shirking my, no, do what orders to be passed.
This thing
If
should
you
not
want
have
to
done.
pass, I will, naale fresh matter haಕೊಂಡು dictate ಮಾಡ್ತೀನಿ. But this you also should not. These complaints are like that. Mata. If Ravi Shankar had come, I would have told him also the same.
With instructions, sir. That's why I communicated to my senior.
Yes, yes. No, sir. Discharge ಹಾಕೊಳ್ಳಿ ಆಮೇಲೆ ಇಲ್ಲೇ ಬರುತ್ತೆ ನೋಡೋಣ.
Grateful.
Same discharge format.
52.
Yes, sir. Just because you have rolled now, you can't gather mass antalla.
It was not told by me.
Yes.
Grateful.
52.
ಅವ್ರೇನ್ ಬರಲ್ಲ ಬಿಡಿ ಬಿಟ್ಟು. Yes. This next week. ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟೊತ್ತಿಗೆ ಫೈಲ್ ಆಗಿರುತ್ತೆ ಅಷ್ಟೊತ್ತು ಮಾಡಿ. List next week.
And then
Application filed under 311, 138.
11.
Please.
Yes, sir.
Signature is admitted, Miller. Bank manager was examination in the DW2. He was.
Next date ಯಾವತ್ತು?
13/8.
13/8.
Please.
My lord, already, Lord.
2 points there is the.
List on 12/8 in the fresh matters list. Yes.
Till such.
13th ತಾನೇ ಇರೋದು. ಈಗ
ಅಲ್ಲ ಅವ್ರದ್ದು ಇದ್ರಲ್ಲಿ
ನಿಮ್
ಗ್ರೌಂಡ್ಸ್
ಕ್ಲೈಂಟ್ ಹೇಳಲೇಬೇಕು ಎಂಟ್ರಿ ಮಾಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರ ಗ್ರೌಂಡ್ಸ್ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ
ಏನ್ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ.
ಅಲ್ಲ ಅವ್ರ ಗ್ರೌಂಡ್ಸೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಇದ್ದಿದ್ರೆ ನಾನೇ ಅಲೋ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿದ್ದೆ.
ಸೀರಿಯಸ್ಲಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಅವ್ರಿಗೆ. 2 ಪಾಯಿಂಟ್ಸ್ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ. 2 ಪಾಯಿಂಟ್ಸ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
Lordship, that check was issued in 2016. Lord.
Check was admitted, signature was admitted.
There is no legally enforceable debt, my lord.
Yes. Next.
128.
And I'll highlight the dates for your lordship's convenience. On 30/12/2023, I file a complaint against few accused persons.
Yes, madam. ಕೊಡಿ papers ಕೊಡಿ. Day after tomorrow, fresh matters list. Yes, next. ಮಾಡಿ.
132.
You dictate ಮಾಡ್ಬೇಕು ಮಾಡಿ. ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ. Yes. Interim order will continue.
Friday.
Day after tomorrow. List day after tomorrow. Interim order subsisting will continue till the next date.
On Friday, my lord, instead. Friday.
Friday na. Senior ಏನ್ ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ. ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
79.
Pray for Passover. 6 petition.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್
ಬರ್ತಾ ಇದೆ.
ಎಲ್ಲಿಂದ ಬರ್ತಾ ಇದ್ದಾರೆ?
ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ರು.
ಸಿವಿಲ್ ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ.
My lord, tomorrow, my lord, please.
ಟುಮಾರೋ. ನಾಳೆವರೆಗೆ ಬರ್ತಾರ ವಾಪಸ್ಸು?
ಬರ್ತೀವಿ. 6 petitions. 6 petitions, my lord.
ಅದೇ 6 petitions. Serial number 170, except 182, madam, up to 185. List tomorrow in fresh matters list. ನಾಳೆ ಇಲ್ಲ ಅಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ಲೇ ಇರ್ಲಿ ಅವರು. Yes.
193.
There is no representation behalf the petitioner both in the forenoon and in the afternoon. Interim order stands vacated. List the matter on 20th in the fresh matters list. Yes. Next. ಅದ್ರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದೆ, ಅದು ಮಾಡಿಲ್ಲ. ಅದು ಹೇಳ್ಬಿಡಿ. The this court on so and so had granted the following order ಅಂತ ಮಾಡಿ ಎರಡು ಡೇಟ್ ಇದೆ ಮೇಡಮ್, ಎರಡದು ಕಾಪಿ ಮಾಡಿ. There is no representation on behalf of the petitioner or respond both in the petition, both in the forenoon and in the afternoon. In the light of no information about the deposit that was directed earlier, the interim order stands vacated. List the matter on 20th. Next.
4 o'clock.
ಆಯ್ತಾ ಇಲ್ಲ? Sorry. 3 minutes. 2 minutes, yes. ಅದು 239 ಒಂದು ಮೊನ್ನೆ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ಒಂದು ಆರ್ಡರ್ಸ್ ಇವರು ಕೊಟ್ಟು BVK ಅನ್ಸುತ್ತೆ, ಅವ್ರ ಹತ್ರ ಕೇಳ್ಕೊಂಡ್ಬಿಡ್ಲಿ ಮೇಡಮ್. ಈ 239 ಇಂದ 252 ವರೆಗೆ 239 ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. 239 ಇಂದ 267 ವರೆಗೆ ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮೊನ್ನೆ BVK ಕೊಟ್ಟಿದ್ದೀನಿ. ಬೇರೆ ಬೇರೆ ಆರ್ಡರ್ಗಳನ್ನ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡೋದಷ್ಟೇ, ಅದನ್ನೇ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡ್ಬಿಡಿ, ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಅಂತ ತೋರಿಸ್ಬೋಣ. ನೋ ಅರ್ಜೆನ್ಸಿ, ಇವು ಅವರು 10 days ಬಿಟ್ಟು ಕೊಡಿ. ಆಲ್ ಡನ್, ಡಿಸ್ಪೋಸ್, ಆಲ್ ಡಿಸ್ಪೋಸ್. BVK ಕೇಳ್ಬಿಡಿ. ಮೊನ್ನೆ 57 ಮ್ಯಾಟರ್ ಮಾಡಿದೆ ಆ ಥರ, ಇದೊಂದು ಬಾಕಿ ಉಳಿದಿದೆ ಅಷ್ಟೇ. ಸೇಮ್ ಕಾಪಿ ಪೇಸ್ಟ್, ಕಾಪಿ ಪೇಸ್ಟ್.
Fresh matters at 4 PM. Number 234.
Bail matter. A2 567.
Yes, 3, 4 and 5.
A2 to A4. Yes, sir. Bail is rejected
Yes, bail is rejected in respect of all these accused.
on the score that they have performed certain overtax.
Overtax, yes.
That is the reason given
Yes.
by the court.
Now, more importantly, I would request the court to kindly permit me to state this. Except A2, others were not even mentioned in the FIR.
Yes, FIR Ibre, A1 and A2.
Only A1 and A2. Now, as the investigation progressed,
They were added.
no, they were not really added.
Then
A deeper conspiracy to kidnap her, to abduct her, detain her, and to prevent her from making any complaint before the police was unearthed.
no. First, initially it was only HD Revanna and Prajwal Revanna.
Only
HD Revanna.
Only HD Revanna and Satish Babu.
Satish Babu, one who took the lady on the bike.
Took the lady on his bike.
Yes.
Only 2 were named. But once A2 was arrested, now the deeper conspiracy started unfolding. And that is how we are before the court. May I just, in a nutshell,
Yes,
place
sir.
before the court.
ಅಲ್ಲ ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ,
ಆಯ್ತು.
ಯಾಕಂದ್ರೆ ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಹೌದೌದು.
ಹೌದು, ಕೊಟ್ಟಿದ್ರೆ ನೀವು.
ಇಲ್ಲ, ಅವ್ರು
Yes, sir. Now, Jadhav sir, ನೀವು ಯಾರಿಗೆ?
I appeal, my lord, for account number 5.
A5.
Yes, please, my lord.
Yes.
Petition is
A2 to A4 Basuraj sir ಅಲ್ಲಿ.
3 and 4 and 6 Basuraj.
Ah.
On that day argued and.
He has finished his submissions. Yes, ಈಗ ನೀವೇ ಮಾಡ್ಬೇಕಾಗಿದೆ.
But I will read to Lord's Lord the complaint.
Compilation also has been given.
Yes, that I have seen.
Lord, in all, Lord, 8 accused.
You are for Satish Babu.
I am A2.
A2. ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. Yes, ಒಂದೊಂದಾಗ ಕೇಳ್ತೀನಿ. Yes, sir.
Please. Lord, in all, Lord, there are 8 accused. Offenses alleged.
No, there are 9 accused. 9th accused is absconding.
They made a statement.
Am I
saying
correct?
that- Yes, please, ma'am, there are
Yes.
9 accused.
Yes. Yes.
Not charge sheet is not made available. No, it is, I'm told it is filed, but not it is under scrutiny.
Scrutiny ಆದ್ಮೇಲೆ ಫೈಲ್ ಆಗೋದು.
Andre PP ಕಡೆಯಿಂದ scrutiny, not, but in the office of the
All right, yes.
magistrate, not they what, not
Hmm.
whether not the documents not that are annexed in the charge sheet, not are produced, etc.
Yes, sir.
Not the complaint, not is on page 12. ಮೇಲ್ಕಂಡ
Sir,
ವಿಳಾಸ.
one ನಿಮಿಷ. Which petition are you
Not
referring?
I'm 6093 of
6093.
93 of 24.
Yes, sir.
For 234.3.
Yes.
Please, ma'am. Complaint your lordship will find out on page 12. ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿದ್ದ ನಮ್ಮ ತಂದೆಗೆ ಒಟ್ಟು 3 ಜನ ಮಕ್ಕಳು. ನನ್ನ ತಾಯಿ ಹಿಂದೆ ಹೊಳೆ ನರಸೀಪುರದ ಚೆನ್ನಂಬಿಕಾ ಥಿಯೇಟರ್ ಪಕ್ಕ ಇರುವ HD ದೇವೇಗೌಡ ಅವರ ಮಗ MLA HD ರೇವಣ್ಣ ಅವರ ಮನೆಯಲ್ಲಿ ಸುಮಾರು 6 ವರ್ಷ ಕೆಲಸ ಮಾಡಿದ್ದರು. ತೋಟದಲ್ಲಿಯೂ ಸಹ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಸುಮಾರು 3 ವರ್ಷಗಳ ಹಿಂದೆ HD ರೇವಣ್ಣ ಅವರ ಮನೆಯಿಂದ ಕೆಲಸ ಬಿಟ್ಟು ಬಂದು ನಮ್ಮೂರಿನಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಈಗ MP ಚುನಾವಣೆ ಸಮಯದಲ್ಲಿ ಇಲೆಕ್ಷನ್ 3-4 ದಿವಸಗಳು ಮುಂಚೆ ಮತ್ತೆ ಹೊಳೆ ನರಸೀಪುರಕ್ಕೆ ನಮ್ಮ ಊರಿನವರೇ ಆದ ನಮಗೆ ಪರಿಚಯವಿರುವ ಹೆಬ್ಬಾಳ ಕೊಪ್ಪಲಿನ ಸತೀಶ್ ಬಾಬಣ್ಣ A2 ಇವರು ಮನೆಗೆ ಬಂದು ಭವಾನಿ A8 ಅಕ್ಕ ಅವರು ಕರೆಯುತ್ತಾರೆ ಎಂದು ಹೇಳಿ ನನ್ನ ತಾಯಿಯವರನ್ನು ಹೊಳೆ ನರಸೀಪುರಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದರು. ಚುನಾವಣಾ ದಿವಸ ಬೆಳಿಗ್ಗೆ ನನ್ನ ತಾಯಿಯನ್ನು ಬಾಬಣ್ಣರವರು ವಾಪಸ್ ಕರೆದುಕೊಂಡು ಬಂದು ಬಿಟ್ಟರು. ನನ್ನ ತಂದೆ ಮತ್ತು ತಾಯಿಗೆ ಪೊಲೀಸ್ನವರು ಬಂದರೆ ಏನೂ ಹೇಳಬೇಡಿ, ಅವರಿಗೆ ಸಿಗಬೇಡಿ, ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಆಗುತ್ತದೆ, ಬಂದರೆ ನನಗೆ ತಿಳಿಸಿ, ನಾನು ಬಂದು ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ಹೋದರು. ದಿನಾಂಕ 29/4/24 ರಾತ್ರಿ ಸುಮಾರು 9 ಗಂಟೆಗೆ ನಾವು ಮನೆಯಲ್ಲಿದ್ದಾಗ ಸತೀಶ್ ಬಾಬಣ್ಣ A2 ಇವರು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನಿಮ್ಮ ತಾಯಿ ಪೊಲೀಸ್ನವರಿಗೆ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡರೆ ಕೇಸು ಆಗುತ್ತದೆ ಮತ್ತು ನೀವು ಸಹ ಜೈಲಿಗೆ ಹೋಗಬೇಕಾಗುತ್ತದೆ. ರೇವಣ್ಣ ಅಕ್ಯೂಟ್ ನಂಬರ್ 1 ಸಾಹೇಬರು ನಿನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬರಲು ಹೇಳಿದ್ದಾರೆ ಎಂದು ನನ್ನ ತಾಯಿಗೆ ಹೇಳಿ ನನ್ನ ತಾಯಿಯನ್ನು ಒತ್ತಾಯ ಮಾಡಿಕೊಂಡು ಅವರ ಹೀರೋ ಹೋಂಡಾ ಸ್ಪ್ಲೆಂಡರ್ ಬೈಕ್ನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿರ್ತಾರೆ. ನನ್ನ ತಾಯಿಯನ್ನು ಎಲ್ಲಿಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು ಎಂಬುದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿನ್ನೆ ದಿವಸ ಅಂದರೆ 1ನೇ ತಾರೀಕಿನಂದು ಮಧ್ಯಾಹ್ನ ನಮ್ಮ ಊರಿನ ಸ್ನೇಹಿತರಾದ ಧನು ಮತ್ತು ಯಶು ನಮ್ಮ ಮನೆಗೆ ಬಂದು, ಲೋ ರಾಜು, ನಿಮ್ಮ ಅಮ್ಮಂದು ವಿಡಿಯೋಗಳು ಮೊಬೈಲ್ನಲ್ಲಿ ಬಂದಿದೆ, ನಿನಗೆ ಗೊತ್ತಾಗಲಿಲ್ವಾ ಎಂದು ಕೇಳಿದರು. ಆಮೇಲೆ ನನ್ನ ಭಾವಂದಿರಾದ ರಂಗಸ್ವಾಮಿ, ದೇವರಾಜು ಅವರು ಸಹ ನನಗೆ ಫೋನ್ ಮಾಡಿ, ನಿಮ್ಮ ಅಮ್ಮನ ವಿಡಿಯೋ ಬಂದಿದೆ, ಅದರಲ್ಲಿ ನಿಮ್ಮ ಅಮ್ಮ ಕಾಲು ಕಟ್ಟಿದರು, ಪ್ರಜ್ವಲ್ ಅಣ್ಣ ಬಲಾತ್ಕಾರ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಹೇಳಿದರು. ಈ ಬಗ್ಗೆ ದೊಡ್ಡ ಕೇಸ್ ಆಗಿರುವುದಾಗಿ ನನ್ನ ಭಾವಂದಿರು ನನಗೆ ತಿಳಿಸಿದರು. ನಂತರ ನಾನು ರಾತ್ರಿ ಬಾಬಣ್ಣವರಿಗೆ ಫೋನ್ ಮಾಡಿ, ನನ್ನ ತಾಯಿ ಎಲ್ಲಿದ್ದಾರೆ, ಅಡಿಗೆ ಮಾಡುವವರಿಲ್ಲ, ನನ್ನ ತಾಯಿಯನ್ನು ವಾಪಸ್ ಕರೆದುಕೊಂಡು ಬಾ ಬಾಬಣ್ಣ ಎಂದು ಹೇಳಿದೆ. ಆಗ ಬಾಬಣ್ಣ ಈ ಹಿಂದೆ ರೇವಣ್ ಸಾಹೇಬರ ಮಗ ಬೇರೆಯವರ ಜೊತೆ ಗಲಾಟೆ ಮಾಡಿದಾಗ ನಿಮ್ಮ ಅಮ್ಮನೂ ಸಹ ಡೊಣ್ಣೆ ಹಿಡಿದುಕೊಂಡು ನಿಂತಿರುವ ಫೋಟೋ ಬಂದಿದೆ, ಅದಕ್ಕೆ FIR ಆಗಿಬಿಟ್ಟಿದೆ, ಇನ್ನು ಬೇಲಲ್ಲಿ ಬಿಡಿಸಿಕೊಂಡು ಬರಬೇಕು ಎಂದು ಹೇಳಿದರು. ಈ ಬಗ್ಗೆ ನಿನ್ನ ಫೋನಿನಲ್ಲಿ ಮಾತನಾಡಬೇಡ, ಬೇರೆಯವನ ಫೋನಿನಲ್ಲಿ ಮಾತಾಡಬೇಕು ಎಂದು ಹೇಳಿದರು. ನನ್ನ ತಾಯಿಯು ಪೊಲೀಸ್ನವರಿಗೆ ಸಿಗಬಾರದು ಅಂತ ಹೇಳಿ ಸತೀಶ್ ಬಾಬಣ್ಣವರು ದಿನಾಂಕ 23/4/24 ರಾತ್ರಿ 9 ಗಂಟೆಗೆ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ನನಗೆ
ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಇರಲಿಲ್ಲ? ಯುವರ್ HD ಮನುಗೌಡ.
Yes, please. But except accused number 1, accused number 8, and not
Accused number 1, 8 and 2.
They are
Complaint
named in
ಇದ್ದಿದ್ದೆ
the-
ಅಷ್ಟು.
they are named in the complaint.
But initially FIR is registered only against 2, accused number 1 and 2.
1 and 2.
A8 also comes in later.
8 is named.
As senior counsel said,
But
deeper conspiracy emerged.
But there is reference to the name of.
A name of Bhavani is
Number
there,
8 is
yes.
there, but she is not read as accused in the FIR. Then, my lord, I was reading to lordship page 13. ನನ್ನ ತಾಯಿ ಪೊಲೀಸ್ನವರಿಗೆ ಸಿಗಬಾರದು ಅಂತ ಹೇಳಿ
ಅಲ್ಲ, ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿಲ್ಲ ಬಿಡಿ.
ಅಷ್ಟೇ. So, my lord, my first submission to lordship is, my lord, number 1 is that, my lord, accused numbers 3 to 6 and 3 to 7, my lord, are not named in the accused. My lord, as can be seen, my lord, at the present scenario, but my submission is there are 3 varieties of accused in the instant case.
3 variety.
How? Accused number 1 and 2, my lord, they are a different category.
Primary variety.
Accused number 2, but is a person who tried to execute, and other accused, my lord, they are all innocents and my lord, accepting the case, my lord, they obeyed the command of accused number 1. Ultimately, this is the case. But as can be seen from my lord, the material collected and my lord,
The 3 types of accused would have been better. Variety, sir. Yes, early. Yes, sir.
But what I am trying to submit is, as can be seen from the observations in the, the order of the learned session judgment while rejecting, or not at the time of granting anticipated bail to not accused number 8, not by this on.
Why is your bail rejected? ನಿಮ್ದು ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು?
But ultimately, they abetted the commission of the offense, and ultimately, that is the observation. But my submission is, even as can be seen from the objection statement, but which runs to pages, but there is absolutely no reference except stating that they also abetted. That is the.
ಆಯ್ತು, ಆಮೇಲೆ.
But that your lordships will find out on page 25 of the objection statement, para 25 of the objection statement. This is the one blood that is relevant according.
Para 25.
Please, madam.
Objection statement. What objection ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲದರಲ್ಲೂ?
Common objection.
Common objections. Common, this one?
Para 25, please.
Para 25.
25. Now that is with reference to blood, accused numbers 3 to 6. It is further submitted that the investigation reveals that accused number 2, along with accused number 3 to 6, at the instance of accused number 1, accused number 8 and others hatched a criminal conspiracy to abduct the victim in this case by using the car belonging to accused number 4 and accused number 6, and executed the criminal conspiracy together. After the arrest of the accused number 2, some of the accused went absconding and were finally traced on 7/5/24. Now, para 28 is also that is specific. It is submitted that on 3/5/24, after coming to know about the arrest of accused number 2, accused number 3, Sujay, called accused number 4, and stated that it is likely that they too be arrested for their involvement in the offense. Then accused number 4, Madhu, brought his car to the house of accused number 3. Then accused number 3 also called accused number 5, and accused number 6 planned to abscond in order
Anticipatory bail or regular bail?
The present one is not regular bail. All these.
ಅಲ್ಲ, ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದೆ ಅವ್ರು.
Regular bail.
Regular bail.
Regular bail.
Yes.
Well, that is one. Then, Lord, lastly, para 52, please, madam. Given the nature of the offense and the role of these petitioners and other accused persons, who are also powerful and influential persons, it would be difficult to infer from the aforesaid submissions that there is apprehension of the victims and witnesses turning hostile in fear of consequences and of the petitioner, etc. So, Lord, my first submission to Lordship Lord is, so far as the present petitioners are concerned, petitioners 3 to 6 are concerned, they are not in the FIR. No specific attacks are alleged against them. Then, Lord, as can be seen from the observations, but it is only on the first accused number 2 is came to be arrested on 2/5/24, and on the basis of his statement, but subsequently the present petitioners.
All of your role is in para 28, what they've stated.
Yes, yes.
25 and 28, if they are read together,
Please.
what you have done and where you went and later on stood
But except
absconded.
stating that accused number 2 called accused number 5, accused number 5 called.
Para
accused
28 it is described.
Yes, there is nothing, it will not incriminate any of these petitioners, is my submission.
Conspiracy 364A.
Not with regard to conspiracy, Lord, no date, time, place, is made available. But as it is not, now it is made clear stating that now.
Anyway, you are arguing for bail, not for quashing.
Yes, yes.
Yes.
But that is the second submission. And my lord, the main allegation is that the petitioners are very powerful. Powerful persons are already out and.
Already out?
Yes. Session judge was pleased to grant to accused number 1.
ಅದೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, so far as we are concerned, that order is holding the field as on today.
Yes.
And even with regard to the accused number 8, my submission is the observation of the coordinate bench of this court is that no offense can be made out from the allegations that.
Bail is a rule.
No, not only that, 364A is not made out. And bail is a rule. And ultimately, they are all agriculture. They have no criminal antecedents at all. And if bail is granted by imposing certain conditions, they will abide by the conditions. They undertake now that they will not interfere with course of justice.
ಅಲ್ಲ ಅದೇನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಬೇಕಾಗಿದೆ you bound to.
ಅಲ್ಲ,
Yes.
that's there. Madam. So.
Next
Madam,
accused.
they are in custody now since almost 3 months.
Right, next accused.
Accused
What
number-
ನೀವು ಯಾವ accused ಗೆ?
This is accused number 3, 4
Ah.
and 6.
You sail with the petition, sail with Jadhav sir,
No, my independent.
independent sailing. Yes sir.
Basiraj senior counsel.
ಅದು ಮಾಡಾಗಿತ್ತು, ಅದು ಅವ್ರದ್ದೇ ಅಲ್ವಾ?
Yes. Kindly see in page number 103, remand application.
ಅದು you come in the remand application.
Remand application, my lord, that allegation which they have made first time, because my lord, that we are not, the complaint has not been registered against us.
I know.
Only remand application that accused
ಹೇಳಿದ
number-
HK Sujay ಅಲ್ಲ?
This is 103 page.
ಅಲ್ಲ, petition is 5923.
Yes. 59.
102.
Yes. ಪ್ಯಾರಾ 3 ಮಿನಿಟ್ ದಿನಾಂಕ 15/5/2014 ಆರೋಪಿ 2 ಮತ್ತು ಆರೋಪಿ 6ರವರ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯರನ್ನು ಸಾಲಿಗ್ರಾಮದಿಂದ ಕಾಳೇನಹಳ್ಳಿ ತೋಟಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಬಳಸಿದ್ದ ಆರೋಪಿ 6ರವರಿಗೆ ಸೇರಿದ ಮಹೇಂದ್ರ ಮೊರೋಜು ಕಾರನ್ನು ಹಾಗೂ ಆರೋಪಿ 6ರವರ ಕೃತ್ಯದ
That's in the remand application.
This is remand application. This is, my lord, that we have brought. My lord, then my lord, kindly see in page number 106. Only, my lord, the page para 6, the ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಗಳಾದ 3, 4, 5 ಅವರಿಂದ ಮೊಬೈಲ್ ನನ್ನು ಅಮೌಂಟ್ಸ್ ಕೊಟ್ಟಿದೆ. Apart from this, there is no any allegation. Trial court, my lord, kindly see in page number 34, in page number 51, internal page number 34. That apart, it is also taken to note that the accused number 2 had sought the assistance of other accused persons, that's the accused number 3 Vijay, HK, accused number 4 Badhu, and accused number 5 HD Manu Gowda towards commission of offence. The remand application clearly indicates that accused number 3 to 5 had played a definite overact with in respect of taking away the victim. It is stated that initially the victim had traveled in their car belonging to accused number 4, and also they had played active role to confine victim in the farmhouse of accused numbers. This is the only allegation. Apart from that, there is no any allegation. Trial court has, my lord, while rejecting the bail application, has held that my lord, we have supported, my lord, accused number 6 betraying. There is no remand application illa idrallu. Therefore, my lord, 364A is not. There is no any ingredients and there is no any allegation made against us. Under those circumstances, accused number we have produced with compilation. That, my lord, the accused number 1, my lord, is under bail. Now, therefore, my lord, the
parity.
That's all. That's the submission.
You are the prime accused. Jadhav sir ಹೇಳ್ದಂಗೆ you are the first variety.
1 and 2 are of first one. I will read, my lord, the complaint once again.
Complaint ಅಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿದೆ.
ಇದೆ.
You are the one who took the lady.
2 was 364A. Other, my lord, the allegations prima facie, my lord, attract, my lord, the relevant, my lord, the ingredients is the only question that will arise for concern.
Because it is, punishment is life.
Please.
Death also. Death or life.
Death or, my lord, the use of force, my lord, is one aspect of the matter.
In 364A.
64A, which is, my lord, not for.
ಮತ್ತೆ voluntary ಬಂದ್ರ ಅವರು? Bike ಅಲ್ಲಿ.
On 2 occasions, my lord, I went and at the behest of my lord first accused, I have gone there. Request. Also to the request, my lord, she has come. My lord, I understand a stranger being pulled in. My lord, and she is taken elsewhere, my lord, and she was, my lord, admittedly was working at some point of time with A1. Lord, I also, my lord, worked at the relevant point of time. The first, the victim, my lord, being, my lord, known to me. My lord, I've acted, my lord, as per the, my lord, command of my lord, first accused, I've gone and fetched her and she has come. But I understand, my lord, in first occasion, there must be an my lord, element of force. But it was all probable, my lord, second occasion also she would not have joined.
You tried second occasion also.
No, but that's what, my lord, the complaint says, that apart. Once, my lord, she is said to have been brought back and again, my lord, called in and.
Second occasion, you've threatened and taken.
No, my lord, that's not, my lord, is the allegation. My lord, what should, my lord, must be there, my lord? There must be a reasonable apprehension of, my lord, causing death or threat, my lord, to, my lord.
For 364A?
364A, which is, my lord, is not forthcoming. Ransom, my lord, is another element which is there. I take my lord's attention straight away to, my lord, how, my lord, the learned church, my lord, has dealt with this.
Order I've seen.
Only one sentence. my
Nimdu
lord.
heli.
Page 52 of my petition,
Which is your petition now?
5765. Paragraph 25, my lord. Order page 35, paragraph 25.
Page 35.
Page 35, paragraph 25. The relevant.
Para 25 of the order.
Please.
24 onwards, internal page 30.
Yes. Only to indicate how the consideration is. The aforesaid acts are carefully appreciated. It indicates that though there was no demand for ransom or a specific threat given by any person on life or causing hurt to the victim, it would be appropriate to hold that the act and conduct of the accused number 2 in taking away the victim from her house and subsequently stating that she was kept in a safe.
ಈಗ ಎಲ್ಲರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ? 364A. What are the offenses ಕೊಡಿ? ಈ ತರ ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿದ್ ನಾನು ಇವತ್ತೆ. ಸ್ಟೇಟ್ ಈ ತರ ಎಲ್ಲ ಮಾಡ್ತಾರ? ಎಲ್ಲದ್ರಲ್ಲಿ ಯಾಕೆ ಮಾಡಲ್ಲ ಹೆಂಗೆ? ಇದೇ ತರ ಮಾಡ್ತಾ ಇದ್ರ?
ನಾರ್ಮಲಿ ಆಲ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಓ ಇಲ್ಲ ಕೇಸ್ ಅಂತದ್ದು ಅಂತ ಹಾಕಿದ್ದೀರಾ? ಎಸ್.
Therefore, my lord, court observes that, my lord, there is no threat or ransom.
364A, 365, 368 do not destruction of evidence ಯಾಕೆ? ಯಾರ ಮೇಲೆ?
ಮೊಬೈಲ್ ಫೋನ್. ಮೊಬೈಲ್ ಫೋನ್.
ಓ ಮೊಬೈಲ್ ಫೋನ್ಸ್ ಡಿಸ್ಟ್ರಾಯ್ ಮಾಡಿದಾರಾ? ಎಸ್.
Further is, my lord, accused number 2 in taking away the victim from her house and subsequently stating that she was kept in a safe place for the reason of registering of a criminal case would certainly cause apprehension in the mind of any prudent person that the person may be put to death or hurt, and same might have compelled the complainant to lodge a written information on 2. What is not there in the complaint, my lord, is sought to be read into, which is, my lord, is
in the order.
Please, that cannot be, my lord, a consideration.
All right. ಅಷ್ಟೇ. ಎಸ್ ಹೆಗ್ಡೆ ಸರ್. Your accused number?
7.
Rajagopal.
Rajagopal.
The house
Farmhouse
to which they went.
Yes, she was staying there.
Yes. ನಿಮ್ಮ ಮನೆ.
ಹೌದು, ನಮ್ಮ ಫಾರ್ಮ್ ಹೌಸ್.
Farm house.
ಫಾರ್ಮ್ ಹೌಸ್ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ರು ಅಂತ. There is no overtact from the accused number 7.
ಅವ್ರನ್ನ ವೆಲ್ಕಮ್ ಮಾಡಿದ್ದೆ ಓವರ್ಟೇಕ್.
ಇಲ್ಲ, ಕೊಟ್ಟೇ ಇಲ್ಲ. ಅಲ್ಲೋ ಅವ್ರು ಕರ್ಕೊಂಬಂದ್ ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. At least they have to show the knowledge or intention to commit the crime. That is not at all forthcoming in their statement of objection also. What they say is they have transferred over phone various times. That is after the incident. That's what
ಬರ್ತಾ ಇದೀವಿ ರೆಡಿ ಇರಿ ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ ಇಲ್ಲ,
ಅದೇ ಅಲಿಗೇಷನ್ ನಿಮ್ಮ ಮೇಲೆ.
ಅಲ್ಲ ಬರ್ತಾ ಇದಾರೆ ರೆಡಿ ಇರಿ ಅಂತ ಹೇಳಲ್ಲ ಎಲ್ಲೂನು. No where it is mentioned. See now, see all other issues or facts they have argued. Only I am arguing insofar as the accused number 7. Now he is aged about 71 years. And his leg is amputated. He need assistance. Now the last almost 2.5 months he is.
You are in custody.
Yes, custody. And he fully cooperated with the police. Before arrest itself, he has surrendered his mobile phone. And 6th time he appeared before the police. And I have produced those documents also whenever he has appeared before the police. Therefore, the question of either derailing the investigation or tampering with the witness does not arise because he was fully cooperating. In spite of that, I take your lordships to the documents I have filed before this honorable court. In remand also, there is no specific allegation except saying that they were talking to each other. That after that.
In continuous conversation with each other and all of them, the lady was taken to your house.
Yeah, that's the
Farmhouse.
only allegation. That is the only allegation.
Yes.
And insofar as the conspiracy is concerned, 120
B.
120B also, there is no ingredients insofar as this accused is concerned. Because conspiracy should take place prior to the incident. It is not after that. So as to attract 364A. There is no meeting of mind prior to that. And there is no material produced before the
Meeting of minds in meeting 8th.
ಅಲ್ಲಿ ಮೀಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ ಇವ್ರದ್ದು ಮೀಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ ಫೋನಲ್ಲಿ ಮಾತಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ದಟ್ ಇಸ್ ಲೇಟರ್ ನಾಟ್ ಪ್ರಿಯರ್ ಟು ದ ಇನ್ಸಿಡೆಂಟ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ದೇರ್ therefore my humble submission is he was fully cooperating in so far as 364A is concerned. Just I take
Odi.
that is most important.
Yes, sir. Odi. So according to you, it can at best be 362 and 365
365.
and not 364A.
Yes.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Just not only that, I take your lordship to 364A, the second portion. Just I read the entire provision. Whoever kidnaps or abduct any person or keeps a person in detention after such kidnapping or abduction, in this case kidnapping is ruled out, only the abduction what they say, and threaten to cause death, this is also not there, or hurt to such person, such other person, or by his conduct give rise to reasonable apprehension of such person, in the other person's mind it should happen, not the victim, may be put to death or hurt, or cause hurt or death to such person in order to compel the government, this is not applicable, or any foreign state or
or for ransom
organization, that is also not
or
there.
for ransom.
Any other person to do, this is very important, or abstain from doing any act or any act or pay ransom. These two ingredients are totally missing in this. Totally missing. Therefore, 364A is, my humble submission is totally ruled out. It is intentionally fastened on these accused to harass.
Charge sheet is filed.
Charge sheet is filed. Your lordship is fully aware that the charge sheet also is the subject matter of question before this honorable court. In many matters,
ಮಾಡಿದೀರಾ?
ಇದರಲ್ಲೂ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ I heard about it. Somebody has done it.
ಅಲ್ಲ, I don't think ಅದೇರೆ ಯಾರು ಮಾಡಿಲ್ಲ.
I don't know. It may come up. We don't know. Because
No, I think
not that
even
once the charge sheet
himself has filed.
once the charge sheet is filed, the charge sheet
Even
is
is
the gospel truth.
FIR.
The charge sheet is not a gospel truth. My humble submission is, it is only.
Nothing is gospel truth.
Nothing is gospel truth. Therefore, it
ಅದಕ್ಕೆ
cannot be-
ಎಲ್ಲ ಎವಿಡೆನ್ಸ್.
Yes, it's a matter of evidence. Therefore, the ingredients of ransom or to do some particular thing is totally absent. And insofar as this accused is concerned, my lord, see, before his arrest, he has been threatened by the police that he should name a particular person. For that, he has written a letter to the National Human Rights Commission prior to his arrest. And CJ of this court and Governor and President of India and CJ also. I have produced those letters also before this honorable court. Those letters, the timings is very important. Prior to his arrest, one is the National Human Rights Commission letter is on 24/5/2024, 10:52 AM. But his arrest was shown at 11:20 AM. Prior to the arrest, this was given, and all other this thing also. But this is an intentional act on the part of the police to mention 11:20. In spite of that, they failed, because earlier there was one letter, it was sent to the National Human Rights Commission. In that particular letter, categorically stated they are threatening me to name a particular person. That since I have not named, in spite of my full cooperation, they have arrested me, and now I am in jail. Therefore, I am entitled for bail.
It's a common thing. ಅವರು ಒಂದು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಇಡಿ ಅಫಿಷಿಯಲ್ಸ್ ಹಿಂಗೆ ಹೇಳಕ್ಕೆ ಹೇಳಿದ್ರು.
ಅದನ್ನು ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಅದು ದಟ್ಸ್ ಅ ಕಾಮನ್ ಥಿಂಗ್ ಫಾರ್ ಅಸ್.
ಅದಕ್ಕೆ ನನ್ನ ಈ ಟೈಮಿಂಗ್ಸ್ ತೋರಿಸೋದು ಅವರು. In spite of I cooperating, your lordship may kindly see the whenever I visited the police station, I have produced those documents also before this honorable court.
ಏನ್ ಮಾಡಿದ್ರು?
ಅಲ್ಲ ಅವ್ರು ಯಾವಾಗೆಲ್ಲ ಕರೆದಿದ್ದಾರೆ ಹೋಗಿದ್ದೀನಿ ನಾನು 6 ಸಲ ಹೋಗಿದ್ದೀನಿ.
ಆಯ್ತು ಸರಿ, ಅಂದ್ರೆ ಈ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದೀರಲ್ವಾ?
ಅಲ್ಲಿ ಹೀಗಿದ್ದೀನಿ 120 ಪೇಜ್ ನಂಬರ್ 120.
ನೆಕ್ಸ್ಟ್ ಅಕ್ಯೂಸ್ಡ್.
Yes, 20.
ಅಷ್ಟೇನಾ?
122 onwards. They cannot say that I have not cooperated and I have deliberately avoided them. All those things are not available for them because it may be available for some other accused, but for me it's totally absent.
Yes,
in remand application also nothing is there. In the order of the trial court also there is no proper reasoning in so far as accused number 7 is concerned.
Yes, sir. Sir.
My lord, one judgment on 360. Just I. This is Neeraj Sharma versus State of Chhattisgarh. Relevant paras are para number 12, 14 and 15. There, the ransom is very, very important ingredient.
No, there
This
facts were of ransom there.
Facts, my lord, this is on 307 and 364A.
Yes, sir.
364A, and he was convicted. Matter went up to the Supreme Court. Supreme Court.
364A ಮಾತ್ರ ತೆಗೆದಿದ್ದಾರೆ.
364A ನ ತೆಗೆದು ಬಿಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ. Because ingredients.
And they have said it is 363.
363 ಅಂತ ಹೇಳ್ತಾರೆ. And reduced to 307 and 360.
Yes, 363 and 307. 364A is removed.
Removed.
Yes.
And this is aptly
ನೋಡಿದೀನಿ.
the case on it.
Yes.
No ransom, I agree.
No, no ransom.
No ransom. Now just
Sir.
in order to cut short the time,
Yes.
may I request the court to kindly, now that the charge sheet is in the hands of the court, kindly permit me to read one paragraph at page 36. Column 17.
I am there, sir.
ಕೇಸಿನ ಸಂಕ್ಷಿಪ್ತ ವಿವರ.
We can go of offense by offense. Page 39, accused number 2.
Before that, whole plot is.
Preamble.
brought- Yes.
Yes,
Whole
sir.
plot is brought under the.
Yes, sir.
What is the nature of conspiracy that is listed? ಪ್ರಕರಣದ ಆರೋಪಿ 1 ಎಚ್.ಡಿ. ರೇವಣ್ಣರವರು ಹೊಳೆನರಸೀಪುರ ಕ್ಷೇತ್ರದ ಶಾಸಕರಾಗಿರುವುದರಿಂದ ಪ್ರಕರಣವು 42ನೇ ವಿಶೇಷ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೋಗಿದೆ. ಪ್ರಕರಣದ ತನಿಖಾ ಕಾಲದಲ್ಲಿ ಸಾಕ್ಷಿದಾರರಿಂದ ಸಂಗ್ರಹಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು, ತಾಂತ್ರಿಕ ವಿಶ್ಲೇಷಣೆಯಿಂದ ಸಂಗ್ರಹಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು, ಸಾಂದರ್ಭಿಕ ಸಾಕ್ಷ್ಯಗಳಿಂದ ಸಂಗ್ರಹಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ಖಚಿತಪಡಿಸಿದ್ದೇನೆಂದ್ರೆ ದಿನಾಂಕ 21/4/2024 2024 ಸಾರ್ವತ್ರಿಕ ಲೋಕಸಭಾ ಚುನಾವಣೆ ವೇಳೆಯಲ್ಲಿ ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರದ ಅಭ್ಯರ್ಥಿ ಹಾಗೂ ಹಾಲಿ ಸಂಸದರಾಗಿದ್ದ ಶ್ರೀ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣರವರದ್ದು ಎನ್ನಲಾದ ಅಶ್ಲೀಲ ಫೋಟೋ ಹಾಗೂ ವಿಡಿಯೋಗಳು ಹಾಸನ ನಗರ ಹಾಗೂ ಹಾಸನ ಲೋಕಸಭಾ ಕ್ಷೇತ್ರದಾದ್ಯಂತ ಬಿತ್ತರವಾಗಿರುವ ಬಗ್ಗೆ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ, ಪ್ರಕರಣದ ಆರೋಪಿ 1 ಎಚ್.ಡಿ. ರೇವಣ್ಣ ಹಾಗೂ ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣನವರಿಗೆ ತಿಳಿದಿರುತ್ತದೆ. ಸದರಿ ಅಶ್ಲೀಲ ಫೋಟೋ ವಿಡಿಯೋಗಳಲ್ಲಿರುವ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯರ ಪೈಕಿ ಒಬ್ಬರಾದ kindly omit the name ವಿಡಿಯೋ ಸಹ ಒಳಗೊಂಡಿರುತ್ತದೆ. ಸದರಿ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯನ್ನು ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣರವರ ಸಂಬಂಧಿ KR ನಗರ ತಾಲೂಕಿನ ಹೆಬ್ಬಾಳು ಗ್ರಾಮದ ಆರೋಪಿ 2 ಸತೀಶ್ ಬಾಬುರವರು, ಆರೋಪಿ 1 ಎಚ್.ಡಿ. ರೇವಣ್ಣ ಹಾಗೂ ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣರವರ ಮಗನಾದ ಸೂರಜ್ ರೇವಣ್ಣರವರಿಗೆ ಸೇರಿದ ಗನ್ನಿಕಡ ತೋಟದಲ್ಲಿ ಈಗ್ಗೆ ಸುಮಾರು 4 ವರ್ಷಗಳ ಹಿಂದೆ ಕೆಲಸಕ್ಕೆಂದು ಸೇರಿಸಿದ್ದು, ಸದರಿಯವರು ಗನ್ನಿಕಡ ತೋಟದಲ್ಲೇ ಇದ್ದುಕೊಂಡು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಕರಣದ ಸಂತ್ರಸ್ತ ಮಹಿಳೆ ಸೋಣ್ಸೋ ತನ್ನ ಮೇಲೆ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯವೆಸಗಿರುವ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣರವರ ವಿರುದ್ಧ ಪೊಲೀಸರಿಗೆ ದೂರು ನೀಡಬಹುದೆಂದು ಹಾಗೂ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯು ತನ್ನ ಮೇಲೆ ಜರುಗಿದ ಅತ್ಯಾಚಾರ ವಿಚಾರ ಬಹಿರಂಗಗೊಳಿಸದಂತೆ ಹಾಗೂ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯು ಸದರಿ ಅಶ್ಲೀಲ ವಿಡಿಯೋಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಇತರರ ಸಂಪರ್ಕಿಸಿದರೆ ಸದರಿಯವರ ಮೇಲಾದ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಬಹಿರಂಗಗೊಂಡು ದಿನಾಂಕ 26/4/2024 ನಡೆಯಲಿರುವ ಲೋಕಸಭಾ ಚುನಾವಣೆಯಲ್ಲಿ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣರವರ ಚುನಾವಣಾ ಫಲಿತಾಂಶದ ಮೇಲೆ ದುಷ್ಪರಿಣಾಮ ಬೀಳುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಸದರಿ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯನ್ನು ಸಾರ್ವಜನಿಕ ಸಂಪರ್ಕಕ್ಕೆ ಬಾರದಂತೆ ಗೌಪ್ಯವಾಗಿರಿಸುವ ದುರಾಲೋಚನೆಯಿಂದ ಆರೋಪಿ 1 ರೇವಣ್ಣ, ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣ, ಆರೋಪಿ 2 ಸತೀಶ್ ಬಾಬುರವರೊಂದಿಗೆ ದಿನಾಂಕ 22/4/24 ಆರೋಪಿ 2 ಸತೀಶ್ ಬಾಬುರವರ ಮೂಲಕ ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯನ್ನು ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣರವರು ಕೆಲಸಕ್ಕೆ ಕರೆಯುತ್ತಿದ್ದಾರೆ ಎಂದು ಹೇಳಿಸಿ ಹೆಬ್ಬಾಳು ಗ್ರಾಮದಿಂದ ಕರೆಸಿಕೊಂಡು ಆರೋಪಿ 8 ರವರ ನಿರ್ದೇಶನದಂತೆ ಆರೋಪಿ 2 ಸತೀಶ್ ಬಾಬುರವರು ಮೈಸೂರಿನ ಬೋಗಾದಿಯಲ್ಲಿರುವ ಆರೋಪಿ 8 ಭವಾನಿ ರೇವಣ್ಣರವರ ಸಂಬಂಧಿಕರಾದ ಶರತ್ ರವರ ಜೊತೆ ಕಳುಹಿಸಿದ್ದು, ಶರತ್ ರವರು ಅವರು ಪರಿಚಯಸ್ಥರ ಮನೆಯಲ್ಲಿ ದಿನಾಂಕ 23/4/2024 26/4/2024 ಗೌಪ್ಯವಾಗಿ ಇರಿಸಿರುತ್ತಾರೆ. 26/4/2024 ಸಾರ್ವತ್ರಿಕ ಚುನಾವಣಾ ಮತದಾನದ ದಿನದಂದು ಸಂತ್ರಸ್ತ ಮಹಿಳೆಯನ್ನು ಮೈಸೂರಿನಿಂದ ತನ್ನ ಗ್ರಾಮಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದು ಬಿಟ್ಟಿರುತ್ತಾರೆ. This is the first episode of abduction. Second, ದಿನಾಂಕ 28/2/2024 ಈ ಪ್ರಕರಣದ ಆರೋಪಿ ಎಚ್ ಟಿ ರೇವಣ್ಣ ಹಾಗೂ ಅವರ ಮಗ ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ ಅವರ ವಿರುದ್ಧ ಸದರಿಯವರ ಮನೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಶ್ರೀಮತಿ ಸೋನ್ಸೋ, ನಾಟ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಹಿಯರ್ ಆರ್ ದಿ ವಿಕ್ಟಿಮ್, ಅನದರ್ ಲೇಡಿ, ನೀಡಿದ ದೂರಿನ ಮೇರೆಗೆ ಹೊಳೆ ನರಸೀಪುರದ ಟೌನ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮೊಕದ್ದಮೆ ನಂಬರ್ 107/2024 ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುತ್ತದೆ. ಅದೇ ದಿನ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸರ್ಕಾರವು ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ನಂಬರ್ 28/4/2024 ಹಾಸನ ಜಿಲ್ಲೆಯಲ್ಲಿ ಮಹಿಳೆಯರ ಮೇಲೆ ನಡೆದಿರುವ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಹಾಗೂ ಈ ಸಂಬಂಧ ಹಾಸನ ಜಿಲ್ಲೆಯ ಹೊಳೆ ನರಸೀಪುರ ಟೌನ್ ಪೊಲೀಸ್ ಠಾಣೆಯ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 107/2024 ಕಲಂ ಸೋನ್ಸೋ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣದ ಸಮಗ್ರ ತನಿಖೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ತಾಂತ್ರಿಕ ಪರಿಣತಿ ಇರುವ ರಾಜ್ಯದ ವಿಶೇಷ ತನಿಖಾ ಸಂಸ್ಥೆಯಾದ ಸಿಐಡಿಯ ಒಂದು ವಿಶೇಷ ತನಿಖಾ ತಂಡ, ಸ್ಪೆಷಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೀಮ್ ಅನ್ನು ರಚಿಸಿ ಸದರಿ ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ ಪ್ರಕರಣದ ಕುರಿತು ರಾಜ್ಯದ ಇತರೆ ಪೊಲೀಸ್ ಠಾಣೆಗಳಲ್ಲಿ ದಾಖಲಾದ ಅಥವಾ ದಾಖಲಾಗಬಹುದಾದ ಪ್ರಕರಣಗಳನ್ನು ವಿಶೇಷ ತನಿಖಾ ತಂಡ, ಸ್ಪೆಷಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟೀಮ್ಗೆ ವರ್ಗಾಯಿಸಿ ತನಿಖೆಯನ್ನು ಕೈಗೊಳ್ಳುವಂತೆ ಸರ್ಕಾರವು ಆದೇಶಿಸುತ್ತದೆ. So this is the critical development.
No, that
On
I've read.
28.
The other things I've read.
Yes. No, on 28, the SIT was constituted.
Yes.
Till then, they did not apprehend much. Now I request the court to kindly mark this. This lady was in employment 4 years earlier.
The act of all these begin after that.
Yes.
What is narrated in the subsequent
Paragraph is the issue that
crux of the issue.
Yeah. That
Now, against these, page 39 is accused number 2, the individual role.
yes.
Accused number 227, 2
Accused
to
number
8.
39 is accused number 2.
Yes. Accused number 440
Page 40.
is there in continuum.
Yes, continue.
Yes. Who is this accused number 9? He is the one who has leaked the videos?
No, no. No,
Who?
he is the person.
Huh.
I go down to this question. May I request the court to kindly straight away come to the main charge sheet.
I am at page 43, accused number 9.
Accused number 9 is there. I request the court to kindly come to page 532.
Yes.
532.
Huh.
Sir, on 28/2, The first complaint was lodged against accused one herein and his son, Prajwal Revanna, then a sitting member of the parliament. Same day SIT was constituted. Now immediately, kindly look at the actors. All of them get into action. A criminal conspiracy is hatched on 29th evening at
So ಇದೇನು
6 o'clock.
mobile conversation between all of them.
Meeting of the minds over phone. This is a high-tech crime that is committed. Kindly look at this. Sir, the extreme left-hand column is Rajgopala, who is accused number 7. In between, we find A6 and A9. Now, A9 phone is the one which is used by A8. Once SIT was constituted, she stopped using her phone.
So the phone used by A8 was A9's.
A9's phone was employed by her.
A9 was employed with A8.
A personal assistant, driver, so many roles he has played. Anyway, he is absconding and his phone is not traceable. Be that as it may. Then to the right hand side is accused number 2.
Yes.
Sir, this man, he claimed that he is a lame man, he has no legs.
Accused number 7 has no legs.
No legs.
A2 alla.
Allah, A7.
A7, yes.
Over 40,000 calls have gone from his phone. We have all the call records.
40,000 calls.
40,000 calls.
ಅದಕ್ಕೂ ಕಾಲಿಲ್ದೇ ಇರೋದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
ಏನಿಲ್ಲ. ಕಾಲ್ ಇಲ್ದೇ ಇದ್ರು ಕಾನ್ಸ್ಪಿರಸಿ ಸಾಧ್ಯ ಇದೆ.
ಅಲ್ಲ ಅದು ದಟ್ ಇಸ್ ಮೀಟಿಂಗ್ ಆಫ್ ಮೈಂಡ್ಸ್. ಲೆಗ್ಸ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
ತೋರ್ಸುದು ಅಲ್ಲಲ್ಲ. ಇಟ್ ಇಸ್ ಇರ್ರಿಲೆವೆಂಟ್. ಕಾಲ್ ಇದೆಯಾ ಇಲ್ವಾ ಅನ್ನೋದು.
Legs ಅಲ್ಲ. He says legs are amputated. That is for the purpose of bail.
Legs
but
are
meeting of minds, legs are not necessary.
Yes.
Yes.
Now, so this is the conspiracy starts at annexure A2, who is at the center. And from then onwards, in between is one Mr. Ajit.
ಅಲ್ಲ ಇವರು ಯಾವ್ದು ಸೈಬರ್ ಕ್ರೈಮ್ ಅಲ್ಲೂ ಇಷ್ಟು ನೀಟಾಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಲ್ಲ.
I bow down to that authority. I was myself surprised.
Even in the strongest of cyber crime cases, such charge sheet is not drawn with such clarity.
In fact, it took 2 days for me to understand the dynamics of this conspiracy. Where did it start? Where did it end? Now, from start to finish, everything is captured diagrammatically and graphically. We have all the call record details.
Fine. Now that
all the calls are duly certified by the service providers.
At the time when the court passed the order, charge sheet ಇನ್ನೂ ಹಾಕಿರ್ಲಿಲ್ಲ. ಈಗ charge sheet ಹಾಕಿದ್ದಾರೆ.
At the time when the court passed the order, even the FSL reports had not come.
Yes, that is true. Now charge sheet is.
We have the.
You have everything now.
We have except 3 phones. Revanna's phone is not yet recovered. Bhavani Revanna's phone is not recovered. And A9 is not traceable.
ಅಲ್ಲ A9 is not yet recovered. Phone ಬಿಡಿ.
A9
he himself is not recovered.
Yes. And more importantly, all these people, they absconded the moment A2 was arrested. Otherwise, their names were not there in the FIR. Why should we suspect them? ಕುಂಬಳಕಾಯಿ ಕಳ್ಳ ಅಂದ್ರೆ ಹೆಗಲ್ ಮುಟ್ಟು ನೋಡ್ಕೊಂಡಂತ. Suddenly they vanished.
Why did you go in search of them?
No, that after the call records.
Because A2 revealed their names and you went in search of them.
A2 revealed the name. Moreover, A7, my learned friend is entirely right. He started cooperating with us. And that is what we thought. Till we discovered
that he was cooperating.
He is misleading. He is misleading us. Misleading the investigation. In fact, he has given a voluntary state pursuant to which recovery was. What he did not know is his own phone was recording the entire conversation. There was an auto record which was on. That application, he did not even know, possibly, that it was being recorded. We have all the records. So,
now the question is,
yes.
Now that the charge sheet is filed,
yes.
Why do you need them?
No, A9 the kingpin.
A9 is not there, but.
We have to trace A9.
So
who
these
is-
people should be in custody to trace A9.
No, we are, one.
No,
one-
charge
one-
sheet
one-
hakovarge,
one
it's fine.
factor I should place it before the court.
No,
The
just ask, because
FSL reports.
364A definitely, which is punishable with death. that
FSL
may
report,
not entail them to be released.
FSL reports are still avoided in respect of A3, A4 and A5.
In telephones.
FSL.
What FSL? Telephone.
Telephone records, record the voice details. We have sent it to FSL. Maybe we should be able to receive it in a week or two.
All right.
At any rate, now who are they? Are they entitled to bail? Sir, very interesting feature is this victim is the only lady who falls outside the clan of Revanna Republic. All others are relatives.
Revanna Republic, yes.
All others are relatives. Kindly take my statement, I am demonstrate. Every one of them is related to him. Number one, by blood or by marriage or by party affiliation. And all of them are active participants in every crime that has been committed, and we have given the details of it.
We'll see. It's because it's not for quashment, but it's for bail.
Bail, for
Considerations.
purposes of bail, I request the court,
Considerations are different.
I therefore request the court to kindly mark this statement that all of them are relatives, close relatives of A1 and A8. And it is impossible to make any headway to take the investigation forward.
Investigation is agoytalla.
If they are
No, investigation is over. Charge sheet file. Once further investigation ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
A9 we have to.
A9 you do it, yes.
No, we don't know what is the depth of the conspiracy, because this is a conspiracy.
But A9 who was with A8 is already out.
A8 is out on a very special consideration.
Woman.
The new jurisprudence.
Woman.
An international covenant has been invoked. First time in this honorable court.
No, preferential treatment for women is always there. In the
I
case
do
of
not
bail.
dispute, but first time an international covenant has been invoked to grant bail. We are not at it anyway. That is being tested before the honorable Supreme. So far as these people are concerned, my very respectful submission is kindly look at their antecedents. If they are allowed to come out, they will. Now, this is the only victim that has now been subjected to this kind of a trick. Now, every other victim, possibly 50 or 60 victims are there.
Who has come forward?
Four have come forward.
Anybody else have registered crimes?
Four are already. Four complaints are already there. So if these people are let loose, now no other person will be in a position to come before the police and.
We'll see. Yes, Ashtas.
May I request the court to kindly take note of their criminal antecedents. I've given a graphic detail.
Yes.
Of their criminal antecedents. Kindly permit me to show. I have given a synopsis.
That ಅವತ್ತೆ ಆ ಕೇಸಲ್ಲೇ ನೋಡಿದೆ ಸಿನಾಪ್ಸಿಸ್.
ಅಲ್ಲ ಇದರಲ್ಲೂ
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಇದರಲ್ಲೇ ಇದೆ. ಅದರಲ್ಲಿ ಇರಲಿಲ್ಲ. All synopsis is in this.
I respectfully agree.
Yes.
Before arguing that case, I should have placed the charge sheet.
Because
I fully appreciate.
I had to take the synopsis from this case to look into that case.
I appreciate. I should have placed that.
It's all right. Now that it is there,
that charge sheet before this court. That would have enabled the court. Now, so all of them are from the same place, same community, and from the same clan. Their relationship is so thick. And more importantly, all of them are office bearers in one or the other political institution. Those details I have given.
Yes.
May I request the court to kindly see the details.
That is accepted. That's a matter of record.
One of them is a rowdy sheeter. The so-called innocent man is a rowdy sheeter.
They are amputated.
A5.
A5.
A4.
A7 ಇಲ್ಲ ಯಾವುದು ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇಲ್ಲ.
A4 is Madhu.
A4. He's a rowdy sheeter.
A4 ಯಾರಿಲ್ವಲ್ಲ?
ಇದಾರೆ 2, 3, 4 ಅವರೆಲ್ಲ ಒಟ್ಟಿಗೆ ಬಂದಿದ್ದಾರೆ.
But appeared, yes.
So they are not people who can be trusted with a law abiding.
ಹಾಗಾದ್ರೆ whatever complaints rowdy sheeters would initiate should
I'm
go.
not saying that. For the moment, they are not entitled to bail is my
That I will consider.
number one. Prima
My
facie
only
case.
question was, now that charge sheet is filed,
Sir, by-
till you recover or discover A9, you want them to be inside.
Yes. Inside, and more importantly, may I request the court to kindly look at the order of the trial court.
That I have seen.
Very elaborately,
Yes,
every aspect of the matter.
No, more than the aspect of the
Oh,
matter.
yes. And more importantly, the tripod test. The learned judge has applied the tripod test in letter and spirit and has found all of them.
No, it's not actually a tripod test, a quad pod test.
It is
Fourth one.
seven tests to be applied.
Yes.
Tripod is a part of it. That is the major part of it that he has accepted.
Yes, sir.
So with this now repeatedly 364A
Would not, is not attracted.
is being questioned. Now when they say, I am taking because Revanna Saab has called me. Where did he take him? Where did he
A7.
take the victim?
A7's farmhouse.
He took her to A8.
No, A8 then comes in there.
No, A8, he deceit. Very
That is
deceit.
what, deceitfully victim has been taken.
Taken out of the house.
So if deceitfully victim has been taken out of the house,
Yeah.
whether it would be 364A or 362 or 365.
364A is the reason for.
No, if you see 365, deceitfully taking someone is 365.
No,
And 362 also to the same effect.
no 364A.
Both of them are 7 years.
Both 364A also. Number one, the initiation should be deceitful or forceful. I don't say it is
364A is forceful.
forceful. Or
362 and 65 are deceitfully.
364A is also a deceitful. Yes, may I request the court kindly permit
Yes,
me
sir.
to read.
Kidnaps or abducts.
Abducts.
Ashte. If you see 362, forcefully compels or by deceitful means induces.
No.
That is 362.
Abduction is abduction by definition.
Definition. Now 365.
Now kindly see the definition of abduction.
Yes. Compels
Whoever by force compels or
by deceitful means
by
induces.
deceitful mean induces. Here, deceit is running through and through. First deceitful act is saying that
No problem. Then it is 362, it's abduction.
abduction. So then afterwards, a continuous deception is there is a criminal case against her. She will be arrested by the police.
So
where is the criminal case?
No.
That is deception.
That is this definitely we will accept it is 362. Ingredients of 362 are fully found.
Once that
Where
is
is
satisfied,
364A
once
then?
that is satisfied, the next this thing is
Because they are all kidnapping. Punishment for kidnapping is 7 years. Kidnapping for ransom where ingredients are found in 364A is death.
my very respectful submission is they are all investigated thoroughly.
No, I will see.
And
I'll
all
look into
loose ends are tied and fully supported by corroborative evidence as well as direct evidence.
No, that is for the trial to go on.
So
Bail,
therefore, at this
what-
point of time,
We are on considerations of bail.
now what is the conduct? What is the conduct? He tells her, that lady, that he is taking her to Revanna's house. Now,
That's-
when the complainant discovers that she is not taken to Revanna's house, that is when he gets the apprehension which is fortified by the fact that she was raped by the son of Revan. Which fact is,
No, that is an altogether different
no, that
circumstance.
video is out. No,
No,
why did
true.
he- what?
That all that is
No,
fine.
that, sir, the issue is compounded by the fact that the video has been published. It has gone viral, and that has come to the notice of this complainant, who says, now I apprehend for the life of my mother because she is a victim of rape. And she has been, though 4 years ago she has been raped, now she apprehends because she may not be allowed to file the complaint.
We're answering bail. So we'll consideration of bail, we'll do it. Yes.
So for purposes of bail also, my
ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ದು ಒಳ್ಳೇದಾಯ್ತು. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಫ್ರೈಡೆ ಮಾಡ್ತೀವಿ.
ಅದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಕಾನ್ವರ್ಸೇಷನ್ ತಾವು
ಯಾವ್ದ್ರಲ್ಲಿ? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ?
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ.
Page?
What went on?
Page?
Page 2121.
2-1.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಇದೆ.
ವಾಲ್ಯೂಮ್ 2 ಕೊಡಿ. ಎಷ್ಟು ವಾಲ್ಯೂಮ್ ಇದೆ? ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಇದು ಕಾಲ್ ರೆಕಾರ್ಡಿಂಗ್?
Yeah, call record ಇದೆ.
Before lodging a complaint.
This was before the, why did he get the apprehension?
How did you tap the phone?
No, we have not tapped the phone.
Then?
It so happened that when the conversation was taking place between A2 and the complainant, one of the witnesses was present. When one of the relatives, he was a relative, he has recorded in his phone.
It is not wiretapping.
No, not a case of wire.
Yes.
He has recorded, and that is how. Now kindly see the details are given at the top of the page. Satish Babu, that is accused number 2, ಹಾಗೂ ರಾಜುರವರ ನಡುವೆ 1/5/2024 ಮೊಬೈಲ್ ಫೋನ್ ಮೂಲಕ ನಡೆದಿರುವ ಸಂಭಾಷಣೆಯನ್ನು ಶ್ರೀ ನಾರಾಯಣಾಚಾರ್ಯರವರು ತಮ್ಮ ಮೊಬೈಲ್ನಿಂದ ಮಾಡಿರುವ ವಿಡಿಯೋ ಚಿತ್ರೀಕರಣದ ಆಡಿಯೋ ಲಿಪೀಕರಣ. He was standing there. He has recorded the whole.
ಇದು ಓದ್ದೇ ಇದ್ರೆ ಬೇಟಿ.
Sorry?
ಇದು ಓದೋದ್ ಬೇಡ ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ ಓದಲ್ಲ. ಅಲ್ಲಲ್ಲ, ತಾವು 364 ಬರುತ್ತಾ ಅಂತಂದ್ರಲ್ಲ, ಇದು ಒಂದು ಓದ್ಬಿಡಿ ಸಾಕು. This will.
That will see.
Yes, that's all what my.
ಇನ್ನ 2 ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಏನಾದ್ರು ರೆಫರೆನ್ಸ್ ಇದೆಯಾ? ಏನಿಲ್ಲಲ್ಲ.
All details of investigation, all the call details.
Yes. These two enough.
Including the 161 and 164 statements.
The video of the victim being recorded.
And there is one very interesting this thing. Now, these so-called innocent
A7.
A3 to A7. Now, immediately after A2 was arrested, all these people, they rushed to A7's house and attempt to shift the victim from that place. And also in the meanwhile, they prepare one more video of the victim saying that ರೇವಣ್ಣ ಸಾಹೇಬ್ರು ಏನು ಮಾಡಿಲ್ಲ ನನಗೆ ಅಂತ. She gives a video statement. ಭವಾನಿ ಅಮ್ಮ ಏನು ಮಾಡಿಲ್ಲ ನನಗೆ. And that is telecast in a local this thing. So these are very innocent people, but they managed to get that statement from the victim during the time when she was kept in illegal detention.
Anyway, that will have no credence. At the trial ಅಲ್ಲಿ ನೋಡು. Yes, all these reserved. 2 ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ Friday.
One argument which was advanced. ನಾನು only ಕಾರ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಾನು ಬರೀ ಕಾರ್ ಸಪ್ಲೈ ಮಾಡಿದ್ದೆ.
ಯಾರು A7?
ಅಲ್ಲ,
4 and 6.
4 and 6.
4 and 6.
Swift car.
ಸ್ವಿಫ್ಟ್ ಕಾರ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಅವರು ಬಹಳ ಇನ್ನೋಸೆಂಟ್ ಆಗಿ ಭವಾನಿ ಅಮ್ಮನ ಹತ್ರ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಒಂದು ಕಾರ್ ತರ್ತಾರೆ. ಅಲ್ಲಿಂದ ಅಜ್ಞಾತ ಸ್ಥಳಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಇನ್ನೊಂದು ಬೇರೆ ಕಾರ್ ತರ್ತಾರೆ. ಬಟ್ ಆಲ್ ಟುಗೆದರ್ ಅಲ್ಲಿಂದ ಅಬ್ಸ್ಕಾಂಡ್ ಆಗ್ಲಿಕ್ಕೆ ಆಲ್ ಟುಗೆದರ್ ಎ ನ್ಯೂ ಕಾರ್ ಕಮ್ಸ್. ನೋ ಆಲ್ ದೀಸ್ ಆರ್ borne out. Only one aspect I would like to. Now, at a time when Revanna's application was considered, criminal conspiracy angle was not before the court. Incidentally, on the same day, on 13/5.
No, adana submission, because that's already reserved.
ಅಲ್ಲಲ್ಲ ಅದ್ರಲ್ಲಿ ಮಾಡ್ತಿಲ್ಲ ನಾನು. ಇವರೆಲ್ಲ ಕಾನ್ಸ್ಪಿರೇಟರ್ಸ್. Should they also be guilty of the same acts which are attributed to A1, A2 or A8? Now that aspect I will just cite two judgments.
Citation.
First one is AIR 1961, Supreme Court 1762, celebrated judgment of Justice Subrao. In Major E.G. Barse versus State of Maharashtra, court may kindly recollect, when India attained independence, there was a deep malaise in the armed forces. Lot of corruption was this. So people were prosecuted wherever they were
Paragraph, sir.
caught red-handed. Now, of the 6 persons who were prosecuted, 3 happened to be public servants. Against whom alone there could have been a complaint of Prevention of Corruption Act. Kindly come to para 31.
Yes.
Only one para, I will not trouble the.
I have seen.
Yeah. 7.
They are public servants and charge of conspiracy cannot be laid against them.
That was the defense.
That is declined.
That is the difference.
Yes.
Now, what is important is,
Yes.
kindly come to the right-hand column of 1778. The gist of the offense of an agreement to break the law. The parties to such an agreement will be guilty of criminal conspiracy, though the illegal act agreed to be done has not been done. So too, it is not an ingredient of the offense.
Last 2 lines of that paragraph 31. Yes.
They are all guilty of the offense of conspiracy
Yes.
to do illegal acts, though for individual offenses, all of them may not be.
That's all. That is what you want to submit.
In an identical set of facts, 4 boys were accused of committing a gang rape. And
No, gang rape is different. Circumstances different.
gang rape only against 2 boys, rape was established. Against 2 others.
No, even accomplices there are held of the same offense.
Yes. So
Yes.
conspiracy, part of conspiracy.
That is for conspiracy.
Kindly para 30 to 33
Yes, sir.
of Moizullah versus State of Rajasthan.
Good evening.
Paras 30 to 30.
Yes.
They cannot say that we did not ourselves abduct, we did not ourselves detain the lady. Paras 30 to 30.
Yes, I will look.
Yes, that's all. Please.
Heard reserved. All charge sheet ಇದೆ ಅದ್ರ ಜೊತೆಗೆ.
Please.
A1 I have challenge ಮಾಡಿದ್ರೆ that I have reserved along with that will do. Yes, heard ಎಲ್ಲಾರು ಹಾಕ್ಬಿಡಿ senior counsel so and so ರವಿ ಕುಮಾರ್ ಹಾಕ್ಬಿಟ್ಟು for the state senior reserves. Yes.
Please.
But this RR was a good coinage.
40 years, sir.
Allah.
I cannot understand how such a thing can be perpetrated.
That we'll see.
Except in a republic
Allah, ಅದಕ್ಕೆ
of this nature.
RR was a good coinage.
For 40 years.
Yes, sir. Yes.
That is why the government had to constitute a special investigation team.
That we'll see. I am not on merits.
Nothing,
Bail ಆಗತ್ತಾ
In
ಇಲ್ವಾ?
Hole Narsipur police station, nothing would move forward. Therefore, we had.
No, that is
Sir,
SIT
the other
constitution
details,
was.
I am sure that will also be coming before the court.
That will see.
Other
We
details.
don't know about that.
No, the DC says,
Yes, sir.
go and hold his feet. I can't do anything.
We'll
Imagine
see.
the plight of the people there. Please.
Yes.
PM.
230? 235.
For petitioners counsel.
But
the e-report has been filed, my lord, against which a protest petition is filed. Now, my lord, cognizance has been taken. But the allegation is that, my lord, in fact, I was a, my lord.
What ground are you on, sir? Page 48 to 50 is the order of cognizance.
Yes.
Detailed order.
Yes.
Why B report is rejected and cognizance is taken?
But my lord, the only allegation against the petitioner is, my lord, in the FIR complaint, my lord. But my lord, he was a conspirator and his presence was not at all there. But the
ಇಷ್ಟೊತ್ತು
moment,
ಆರ್ಗ್ಯೂ ಮಾಡಿದಲ್ಲ ಕಾನ್ಸ್ಪಿರಸಿ ಏನು?
lot of pen drives are coming now, my lord. You're actually to say, ask my lord every time, pen drive, pen drive. But here, my lord, the complaint, in the complaint environment, my lord, the complainant says.
ಅಲ್ಲ
my
ಅವ್ರು
lord,
ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಇಟ್ಸ್ ನಾಟ್ ಎ ಬಿ ರಿಪೋರ್ಟ್ ವಾಸ್ ನಾಟ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಇನ್ ದಿಸ್.
No, my lord,
Erroneously filed.
my lord, they have, my lord, improved the case my lord, stage by stage. My lord, in the complaint, they
We'll
say,
see.
the complainant say, my lord, in the complaint,
Get the
that-
complainant. One
but
HCGP,
in the order of process is bad. The special court, my lord, has not taken cognizance.
ಯಾರು MLA ನ ಇದು?
The MLC, my lord,
MLC.
ಹೌದು.
But why do the courts do this? Magistrate has taken cognizance.
The magistrate, my lord, Chikkanahalli, my lord, can cognizance.
ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ. Why sir?
Has to be
And
ಎಲ್ಲಾದ್ರಲ್ಲಿ.
sworn statement also not recorded in accordance with law. Therefore, my lord,
Heard the learned.
I think, my lord, can only be transferred to that court. my lord.
That's all I'm going to do. This B report was not to be filed in this. The heard the learned senior counsel Arun Sham appearing for the petitioner. The petitioner calls in question an order of taking of cognizance, which ought to have been by the special court, but is taken by the learned magistrate. Therefore, in that light, there shall be an interim order of stay of further proceedings till the next date of hearing. List on Friday in the fresh matters list. I'm going to transfer it to special court. Ashte.
but,
I'll quash the order of cognizance, send it to the special court.
notice, my lord, the complainant, my lord, now the state has filed B report, my lord, the complainant is before the court.
Produce petition ಹಾಕಿದ್ರಲ್ಲ ಅಲ್ಲಿ.
ಹಾಕಿದೆ.
Then we will not stay it. Then
Cognizance ತಗೊಂಡಿದ್ದಾರೆ, my lord, your lordship.
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ಅಲ್ಲಿ
The order is bad in law, my lord, per se, my lord.
bad in law, we will send
But
it there.
jurisdiction, my lord, therefore.
List on 22nd in the fresh matters list. Emergent notice to the second respondent returnable by the said date. ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಇದ್ರಾ? ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ.
Sir, ಮಾಡಿ.
Petitioner is also
my
at
lord,
liberty to 22nd and 21st. 23rd. The petitioner is at liberty to serve on the counsel who represents who had represented the complainant before the concerned court.
It's NPML at 20.
MPML. On
22nd.
23rd, 22nd, 22nd.
Thursday. Thursday, my lord.
Thursday, 22nd.
Meantime, my lord.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇವತ್ತು ನಿಮಗೆ ಹೇಳಕ್ ತೊಂದರೆ ಇಲ್ಲ, ಸ್ಟೇ ಆಗಿದೆ ಅಂತ. ಅವತ್ತಷ್ಟೇ ಕ್ಲೋಸ್.
Like,
36.
Your Lordship, we've endured half a day of variety, Your Lordship, maybe at least for that. Your Lordship, this is a case where all we are asking is to substitute. Might I pass on, Your Lordship? Page 10 is the application filed by them. Page
What
10.
is the impending threat?
Your Lordship, what has happened is the wife's two properties, which are residential.
That's fine. What is the impending threat now?
Your Lordship, day before yesterday, I had mentioned the urgency. Yes, on Saturday, the matter was taken up. We had mentioned that the matter is pending since there was no hearing on Friday. It's taken up on Monday. Kindly hold on. He said no, he would not. And he's proceeded to pass an order.
Special court.
Special court. Your
What
Lordship.
order?
On the interim attachment, Your Lordship. Your Lordship, all I'm stating is that this property was purchased by this man in 2004 and 2008.
This has the shades of the apex court's order. Madam, ನೀವು ಹೊರಟ್ಬಿಡಿ. ತಾಳಿ ಇದೊಂದು ಮುಗಿಸ್ಕೊಂಡು ಹೊರಟ್ಬಿಡಿ. ಇನ್ಯಾವುದು? ಅದು ಇದೆಯಾ? Sorry, yes.
Your Lordship, for a minute, Your Lordship, page 10.
We'll take it day after tomorrow. Day after tomorrow. I'm not inclined to grant any order.
Your Lordship,
But
all
now
four
that he has
pages.
passed some order, let me see.
Please.
What is the order?
Please.
Day after tomorrow in the next date.
Will
ಯಾವತ್ತು?
also be permitted to serve R2.
Next date ಯಾವತ್ತಲ್ಲಿ?
8th.
List day after 7th, yes. List day after tomorrow in the fresh matters list. Yes.
Might I also pass this on, Your Lordship? Section 3, I think the.
MMDR,
No, Your Lordship,
Then?
this is under the criminal amendment, Your Lordship.
ಕೊಡಿ. Whatever, give it.
Section 3. This is
I'll
the
read-
application that
I'll
they
read it.
filed under, Your Lordship. In that itself, we have a provision for.
Wednesday, fresh matters. That order passed by the court?
I've
Yes.
produced that also.
Yes,
Online
Witness.
copy, Your Lordship. We weren't able to get.
that's all right. No problem. Yes, 230 move matter ತೊಗೊಂಬಿಡಿ.
That's 30 more.
Fresh matter. Number 1.
ಹಿರೇಮಠ್
Raymond.
ಸರ್ ತಗೊಂತೀನಿ ನೆಕ್ಸ್ಟ್ ಇದಾದ್ಮೇಲೆ ಪರವಾಗಿಲ್ಲ.
For me to request you, not have to hear me after 5 o'clock.
No, that's all right.
That should make it.
I'll take it. No, that will hardly take any time.
It takes, because you lot of wanted me.
216(4), 230 and 231 proceedings. Hello, we'll see. We'll at least make some beginning.
Please.
We have begun, we'll take it a little forward. Yes, it's just 230 mood matters ಇದೆ ಅದಕ್ಕಷ್ಟೇ.
Praveen Kumar here.
So after 10 years of marriage, my lords, wife filed a.
ಈಗೇನ್ ಅರ್ಜೆನ್ಸಿ 230 ಮೂವ್ ಮಾಡಿದ್ದು?
My lords, second FIR again, one more FIR is filed, my lords. On 16th.
ಫಸ್ಟ್ ಒನ್ ಸ್ಟೇ ಆಗಿದೆಯಾ?
Stay again. At page number 120.
ಸೇಮ್ ವೈಫಾ?
Of course.
Yes. ಅಲ್ಲ ನಿಮ್ದು ಹೇಳಕ್ಕಾಗಲ್ಲ. So please, 1 HCGP 2 emergent notice, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Only wife, only accused. Husband, only accused.
Only has against the petitioner. Yes, next.
Bill number 2.
Withdrawal, yes. In terms of 3, Ranjit,
Number 3, Shri Ranjit, go to.
memo for withdrawal ಅಂತಿದೆ?
Yes, my lord. In 6.61, my lord, I seek for withdrawal of the petition with the liberty to file fresh petition, my lord. Inadvertently.
Where is the memo? Learned counsel for the petitioner seeks leave of this court to withdraw the petition, reserving liberty to file a fresh petition on the same cause of action. The liberty so sought is granted.
Inadvertently, wrong CC has been challenged.
All right. So and so, yes. Next.
Number 3, Shri Ranjit, go to.
That's for the petitioners in this.
ಇದರಲ್ಲಿ 1 HCGP 2 emergent notice, there shall be an interim order of stay spread for till the next.
Only government.
Sorry, 1 HCGP, there shall be an interim order of stay till the next date of hearing. ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಲ್ವಾ?
Bill number 4.
ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ? ಸರಿ, ಎಸ್.
Ashwath Narayan Reddy, C.
ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕು. ಯಾವ ಕೋರ್ಟ್ಗೆ?
Instead of filing a criminal appeal, I have filed a criminal petition.
Very good, sir.
Your lordship permit me to withdraw and liberty reserved to file an appeal before. the-
Judgment reserved, yes. In terms of the memo disposed, yes.
Liberty may be reserved because.
ನೀವು ಮೆಮೋಲಿ ಏನ್ ಕೇಳಿದ್ದೀರಾ?
ಕೇಳಿದ್ದೀನಿ ಅದು.
ಕೇಳಿದ್ಮೇಲೆ ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ ಬಿಡಿ. ಅದು ಬೈ ಮಿಸ್ಟೇಕ್ ತಪ್ಪು ಬರೆದು ಬಿಟ್ಟಿದ್ದೀರಾ?
7518 ಅನ್ನು.
ಇಲ್ಲ 7763 ಇದು.
Narayan Reddy,
ಹೌದು.
ಅದು ನೀವೇ ಅಲ್ವಾ?
776.
ಅಶ್ವತ್ಥಾನ ರೆಡ್ಡಿ ಅವರೇ?
ನಾನೇ.
ಹಾ, ಎಸ್.
Sorry.
ಅಷ್ಟೇ, ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋ.
Liberty may be reserved to. ಅದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ರಿಟರ್ನ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
A registry is directed to return the certified copies appended to the petition forthwith.
Yes.
ಬೇರೆ ಏನ್ ಬಾಕಿ ಇದೆ ಮೇಡಮ್?
ಉನ್ನಿ ಕೃಷ್ಣನ್.
Siddaramaiah.
ನಿಮ್ದೇನು?
ಇಲ್ಲ, ಉನ್ನಿ ಕೃಷ್ಣನ್.
ಅದಾಯ್ತಾ?
ಆಗ್ಲೇ ಆಗೋಯ್ತೆಲ್ಲ. ಯಾರಿಗೆ ಡಿವೈಡ್ ಮಾಡ್ಬೇಕೀಗ?
ಸೌಮ್ಯ ಮೇಡಮ್.
ಹಾ, ಅವ್ರವ್ರಿಗೆ, ಎಸ್. ಉನ್ನಿಕೃಷ್ಣನ್ ಸರ್, ಯು ಆರ್ ನಾಟ್ ದೇರ್ ಎಟ್ ಆಲ್. All disposed. All disposed, sir. Yes.
I will, my lords, 248, my lords, in this matter only. My name, my lords, wrongly mentioned, shown.
Huh?
248, serial number 248.
ನೀವಲ್ವಾ ಅದು?
KL ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ, KG ಅಂತ ಆಗ್ಬಿಟ್ಟು.
ಏನ್ ನೋಡಿ ಮೇಡಮ್, ಎಸ್.
And another one thing, my lords, we have the complainant had 4 accounts, my lords. Out of that, my lords,
ಈಗ ಯಾವ 5 ಕಾಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಸರ್? ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ? ಎಸ್. ಎಸ್, ಕೊಡಿ. ಮೇಡಮ್, ಅದಕ್ಕೆ ಇದು ವಿಡ್ರಾಯಲ್ ಸರ್, ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋ. ಇಲ್ಲ, ದಿ companion petition has been withdrawn, and therefore the counsel for the respondent has moved this matter, seeking to withdraw the subject petition as well. Therefore, the petition stands withdrawn in terms of the said submission. Madam, word put in. Any other, madam? Yes, sir.
Bill number 2.
Officers may not have taken a 173 very seriously in that matter.
Huh?
Our officers have taken 173 very seriously.
Very seriously,
Investigated
sir.
in 12 hours, my lord.
ಈ ತರ ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಮಾಡ್ಬಿಟ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ. ಮೇಡಮ್ ನೀವು ಹೊರಟ್ಬಿಡಿ, ಎಲ್ಲಿ ಕಾಯ್ಬಿಡಿ. ಅದು ಬರೀ ಹಿಯರಿಂಗ್ ಅಷ್ಟೇ. No, more than I think 250 cases.
I may take some time.
That's okay, sir. Yes. No. Start ಮಾಡಿ. Yes, sir. ಅದನ್ನು ಫೈಲ್ ಕೊಟ್ಬಿಟ್ಟು. Yes, sir.
I'm sure my learned friend Mr. Prasanna would agree with me. I have raised a serious and important question of law before your lordship in this petition, warranting a decision. My lord.
Just one moment, sir. Any other matter who's waiting? Nothing? ಯಾವುದಿಲ್ಲಲ್ಲ? ಅದು ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೇ ಮೇಲೆ ಹಾಕ್ತೀನಿ ಅವತ್ತ. ಅದೆಲ್ಲ ಆಕ್ಷನ್. No other matter, right? Yes. Yes, sir.
But what is said in section 216, probably we may have to first go to 216(3).
Yes.
Then we have to go to 216(4).
Yes.
And thereafter section 217.
Yes.
But I have also been able to lay my hands upon some judgments of the Supreme Court. What the Supreme Court has said also I shall take your lordship. But unless and until someone says that I am prejudiced, then the court can't act upon section 216(4). But conferring power that is clothed upon a court is something different from need to exercise such power. Just like a power to
That is
arrest.
settled.
A power to arrest is something different from need to arrest. But may I just now invite my lord's kind attention to first we will go to section 216.
And there's
Any court may alter or add any charge at any time before the judgment is pronounced. What your lordship would find under section 216, one is altering or adding. Now we'll go to 2. Every such alteration or addition shall be read and explained to the accused. That has been done in this case. Subsequent to the filing of an additional report, which is in addition to the report that has already been filed. It can't be a supplementary report or a new report. But I don't know, I should invite my lordship and attention to. For 30 years back, I had the occasion to argue this matter before this court. That was a revision petition.
division bench.
Division bench, Justice Ravindra and Justice Rajendra Prasad. Yes. That was also under 173(8). First, they would submit a B report. Subsequently, further investigation came to be taken up pursuant to a direction given by the government. But the further investigation, according to the wisdom of the investigator, did disclose the commission of an offense. After the filing of the report, B report, and the acceptance of the B report, then they would file an additional report, which would indicate the commission of the offense by the accused. But a revision petition came to be filed, questioning the legality and correctness of the order of taking cognizance on the strength of the additional report. Though, my lord, it was a revision petition to be decided, heard and decided by a large single judge of this court, in view of the
Importance.
seriousness and the importance, as my lord would be saying quite often, my lord, the personality that is involved in the case, because then the chief secretary of the state. But it was
Yes, sir.
referred to a division bench. A division bench came to be constituted especially to hear and dispose of this revision petition. Well, may I request your lordship to kindly have a look at the 1996.
But
Single
one,
lawyer-
one clarification.
I'm sorry.
This further investigation thing is already decided by the division bench. I can't go back on that.
No, I'm not at that point.
No, because 173(8) ಆದ್ಮೇಲೆ,
ಹೌದು.
once the supplementary charge sheet is filed or the charge sheet is filed, there cannot be an occasion to file something else.
Quite right. That's exactly my submission also.
No, true, but that is already,
No, I'm not at that point at all.
now you're on 216 drawing inference
Actually,
from that. Yes.
Only for the limited purpose of inviting my lord's kind attention that this is only a report which is in addition to the report that has already been filed. Only to that limited extent I am saying it. But original report that has been filed under 173(2) in the form of a charge sheet is on record. That is in existence.
Yes.
It has not vanished.
Yes.
It is there.
Yes.
On the strength of that report, the persons who are labeled as accused in the case were put on trial. Trial went on. 63 witnesses came to be examined. 313 statement of the accused came to be recorded. It was set down for hearing arguments / the defense evidence.
CBI takes over later.
It was at that point of time, well, it assumes all the importance. It was at that point of time, my lord, the CBI takes over the investigation that they would file an additional report. It is only for that limited extent.
Yes, yes.
I am drawing my lord's kind attention. But in this judgment, this is what their lordships would
Yes,
say.
sir.
Paragraph 16, my lord, they kindly permit me to take your lordship to
Yes.
paragraph 16. Only for the limited purpose of inviting my lord's kind attention that the report that has been filed, it can't be called a charge sheet. It has got to be said as a report which is in addition to the report that has already been filed. Wherein some additional evidence came to be collected against the accused in the case, except in that nothing else. However, the learned counsel for the petitioners urged that if the police are given such powers, it would result in reports being submitted ad infinitum, and the parties concerned would be put to great harassment. We do not think so. The interest of justice may require further investigation into a matter, and a fresh investigation report may have to be placed before the court. Ordinarily, it is desirable that the police should seek permission of the court when the report has already been made to the court as observed by the Supreme Court. When further investigation under the control and supervision of the court, we do not think that such results can occur, there being sufficient safeguard in that regard. The learned counsel for the petitioner, however, urged that such reports can only be supplemental to the original report made to the court, and unless the original report had been made to the court, and that report is still in existence, my lord, this is what I wanted to submit to your lordship. In this case, my lord, that was no longer in existence because the court had passed an order accepting the B report and closing the case. But the division bench would negative my contention, and the question of making a further report would not arise. In this context, the learned counsel for the petitioners laid upon some of the decisions referred to earlier of section 173(8) of the code. And this is very important. Section 173(8) CRPC does not in terms refer to any supplementary report being made. What is provided under section 173(8) CRPC is sending a further report where a report has already been made under section 173(2) CRPC. A report sent after one report had already been made is a further report. That is the law which came to be laid by this court. Now, my lord, here an additional report has been filed subsequent to the report that has been filed earlier, on the strength of which report the accused came to be put on trial after paying the charges.
That's by the CBI.
By this. Well, now we will go to section 216.
Yes, sir.
Already, I read to your lordship 1 and 2. Now we will go to
Three.
subsection 3 of section 216. This will be very, very important.
Yes.
In the alteration or addition, but in the instant case, your lordship may take it, some addition has been made or some alteration has been made, be it addition or be it alteration in the form of addition or alteration to the charge that was in existence on the day when the accused was put on trial in the case, which order came to be confirmed not only by this court but also by the apex. If the alteration or addition to a charge is such that proceeding immediately with the trial is not likely, in the opinion of the court, to prejudice the accused in his defense or the prosecution in the conduct of the case, the court may, in its discretion, after such alteration or addition has been made, proceed with the trial as if the alter or added charge had been the original charge. But
Prejudice to the.
that is very, very important. But unless and until I should take the plea, the prosecution should take the plea. Consequent to the addition or consequent to the alteration,
So there is nothing in the case at hand.
a
Yes,
prejudice has been cast, either to
Yes.
the accused or to the prosecution.
yes,
Well, now we will go to section 4, subclass 4.
yes.
Well, unless and until a prejudice is there, an issue of prejudice is raised either by the prosecution or by the accused, it cannot exercise jurisdiction under 216 subclass 4. We will come to the next question that is involved under section 216 subclass 4, whether it is a new trial or not. We'll come little
That
later.
is what is, next question, yes.
That is the next question. First, we will see my lord, when he could exercise the powers clothed upon him under section 216 subclass 4. If the alteration or addition is such that proceeding immediately with the trial is likely, in the opinion of the court, to prejudice the accused or the prosecution as aforesaid, the court may either direct a new trial or adjourn the trial.
Again, prejudice to the
Again, the
accused.
prejudice. Not otherwise, my lord. Simplicity, he can't say, look here under section 216 subclass 4, I have the power to order a new trial. No,
Just because the power is there, unless prejudice is there,
Yes.
cannot, yes.
no, my lord. What is new trial now? Now, what we need to see, later part may not be
Either
applicable.
direct a new trial or adjourn the trial for a period as may be
He has
necessary.
not adjourned, he has
So
not.
he has only directed a new trial to
New
be,
trial. What is new trial, my lord?
according to you, from the stage at it, where it stopped.
Is it permissible under law is the question. That's it. Well, a new trial means,
Getting new accused, as a new statement of witnesses.
well, right from beginning, commencement, we are going back to stage 1. As if the accused has appeared before the court today. All these accused persons have appeared before the court. There may be some new accused. We are not on that issue. New trial means afresh from the beginning. But it is just like a de novo trial. There is absolutely, according to me, my lord, there is absolutely not much of a difference between a new trial and a de novo trial.
ಎರಡು ಒಂದು.
ಎರಡು ಒಂದೇ. But the Oxford dictionary would say,
De novo is anew.
ಅಷ್ಟೇ ಎರಡು ಒಂದೇ. ಅದು ಯಾವಾಗ ಮಾಡ್ಬೋದು ಅಂತಂದ್ರೆ ಕೋಟಾಸ್
Yes, ಕೊಡಿ.
ಪ್ಲೀಸ್ ಪರ್ಸನ್. ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳುತ್ತೆ. ಇದು ಓನ್ಲಿ ಅಂಡರ್ ಸೆಕ್ಷನ್ 386, ನಾಟ್ ಅದರ್ವೈಸ್.
Dictionary meaning, yes.
Dictionary
Yes.
meaning, I am sorry, my lord. Just for my anxiety, I am just.
Yes,
inviting
no
my
problem.
lord's attention.
Yes, yes, not an
De novo means afresh, beginning again. But new means again the same thing, not
ಅದಕ್ಕೆ ಎರಡು ಒಂದೇ.
existing before, now afresh. ಎರಡು ಒಂದೇ. De novo and afresh. But retrial is again, my lord, conveys the same meaning.
Yes,
Retrial also
same meaning.
conveys the same meaning. Well, retrial means that commences from the stage after the framing of charges. Well, as the Supreme Court has said in 2014 in Hardeep Singh's case, my lord, a constitutional bench of the Supreme Court has said trial in a warrant case commences after the framing of
Yes,
the charges. It leaves, no, that's the.
because that was under section 319, interpretation of 319.
9,
That is again said in Supal Singh Karya
the
in
constitutional
2020.
bench has said, my lord, we are
Second
bound- we are
constitution
bound by
bench.
that. Therefore, my lord, may I now invite your lordship's kind attention to section 386 per second.
Hmm.
Have a look at section 386 per second.
Yes, sir. Yes,
After perusing such record and hearing the appellant or his pleader, if he appears and the public prosecutor if he appears, and in case of an appeal under section 377 or section 378, the accused if he appears, the appellate court, my lord,
So-
ordering retrial is a
So,
power. that
power
is
of the appellate court,
That court,
under,
not that of the trial court.
correct.
If my lord were to agree with me, my lord, that new trial,
Retrial.
retrial, de novo trial virtually conveys the same meaning. De novo trial, new trial, or my lord, a fresh trial trial means it is only after the framing of charges and not otherwise.
Correct.
In all these three connotations,
Trial would commence only after that.
so in all these three, well, be it new, be it fresh, be it retrial, or be it de novo, well, it is only after trial and not otherwise. I mean, for the purpose of trial, that means it is only after the framing of charges and not otherwise. Now have a look at this, my lord. If it considers that there is no sufficient ground for interfering, dismiss the appeal or may, well, A,
That the accused be retried.
yes, in an appeal from an order of acquittal, reverse such order and direct that further inquiry be made, or that the accused be retried or committed for trial as the case may be, or found guilty and pass sentence, etc. So, my lord, it is the power, although, my lord, your lordship would get under section 216(4), my lord, a new trial. Well, if my lord were to agree with me that the new trial conveys the same meaning as we get a fresh trial or a de novo trial.
So the court could not have excised it.
Not merely because he has the power to do it. Then, my lord, what should happen to the evidence which the investigator would have collected and brought on record in the case in the form of an additional report? What should happen to it? Then, my lord, your lordship may have to go to, well, before I take your lordship to this, let me invite your lordship's attention to one judgment of the Supreme Court. A full bench judgment of the
This
Supreme Court.
216(4) is not interpreted by apex court. ಇದೆಯಾ sir?
ನಮ್ಮ ಕೋರ್ಟ್ನವರೇ ಮಾಡಿದ್ದಾರೆ. ಕೊಡ್ತೀನಿ ಸ್ವಲ್ಪ little later will
That's all right. Yes, yes, yes.
Let me, because now I am under 386, what
Yes,
the
sir.
Supreme Court has said is, my lord, if it is a case of fresh trial, if it is a case of new trial, if it is a case of de novo trial, well, the entire evidence that has been recorded gets wiped out. That is what the Supreme Court has said.
That is power of the appellate court.
That is the power of the appellate court. But here, if he orders a retrial or a new trial or a de novo trial, it is nothing short of saying that whatever that has come on record in the case as evidence, be it oral or documentary, gets wiped out. But what he would say is, what the learned judge would say is, no, I am going to read that evidence also. No, he has no power to read that evidence. When the law is that it gets wiped out. How can I read it? You can't read it at all. But may I just request your lordship to have a look at this is in 2022, volume 2 Supreme Court cases 89. May I request your lordship to kindly go to paragraphs 19, 20, 23 and 24. But at paragraph 19, internal page 109 of the judgment, power of to direct retrial. Well, while dealing with section 386,
yes,
well, their lordships would say like this is full bench judgment. I shall skip these things, my lord. Section 386, I shall skip. Then, my lord, I shall take your lordship to paragraph 20. The scope of the power of the appellate court to direct a retrial has come up before this court for interpretation in several decisions. The judgment of a constitutional bench in Ukhakole versus state of Maharashtra has dealt with the issue extensively. In that case, the appellant was tried before the judicial magistrate for the offense of rash and negligent driving while under the influence of liquor, thereby causing the death of one person and injuries to 4 others, and for offenses under the Motor Vehicles Act. The trial judge held that the evidence was not sufficient to prove that the appellant was driving the motor vehicle at the time of the mishap and acquitted him of the offenses under the Motor Vehicles Act and the Penal Code. But he held that the evidence established that the appellant has consumed illicit liquor and committed an offense punishable under section 66, subclause B of the Bombay Prohibition Act. The appellant was convicted and sentenced to imprisonment for 3 months and was directed to pay fine. On appeal, the Sessions Court set aside the order of the trial court and ordered retrial on the ground that a fair and full trial had not taken place.
23.4
23.
paragraph. Yes, that's the crux.
That is exactly, I was about to invite my lord's attention. Kindly permit me to take your lord 23, 23.1, 23 and 4.
The finding is at 23.4.
Another future which emerges from the above decision in Ukhakale case is that an order of retrial wipes out, is what I submit to your lordship, wipes out from the record the earlier proceeding and exposes the present accused to another trial. It is for that reason that the court has affirmed the principle that a retrial cannot be ordered merely on the ground that prosecution did not produce proper evidence and did not know how to prove their case. But he can't say, as against the law laid down by the Supreme Court, no, I'm going to read that evidence, don't worry. No, he can't. He has no jurisdiction to read. Well, this is what the Supreme Court. But in another judgment of the Supreme Court, this again, my lord,
About retrial.
again
Yes, sir.
retrial. One full bench judgment is sufficient.
That's enough, sir.
But still, my lord, I shall read one small paragraph, my lord.
Yes, sir,
Paragraph-
yes.
Paragraph 12. Kindly go to paragraph 12. Internal page 702. My lord, under the guise or under the name, a new trial.
Yes, sir.
What does it mean? A new trial means, what does it mean? And that too, he would say, my lord, what the learned judge would say is, no, I have permitted the prosecution to adduce evidence on section 230 and 231.
Yes.
It comes under chapter 19. A first trial, a de novo trial. De novo trial means a new trial
Yes.
ordered by an appellate court but in exceptional cases when the original trial failed to make a determination in a manner dictated by law. The trial is conducted afresh by the court as if there had not been a trial in the first instance. Undoubtedly, the appellate court has the power to direct the lower court to hold a de novo trial. But the question is, when such power should be exercised? Well, in so and so. An order of retrial, well, kindly permit me to
Yes,
take the
yes,
lordship
sir.
to this. An order for retrial of a criminal case is made in exceptional cases and not unless the appellate court is satisfied that the court trying the proceeding had no jurisdiction to try, or that the trial was vitiated by such serious illegalities or irregularities, or on account of misconception of the nature of the proceedings, and on that account, in substance, there had been no retrial, or that the prosecutor or an accused was, for reasons for which he had no control, prevented from leading and tendering evidence material to the charge.
Best Bakeries cases.
They have followed
In
the
trial, yes.
They have referred to that. And in the interest of justice, the appellate court deems it appropriate, having regard to the circumstances of the case, that the accused should be put on his trial again. Well, it is nothing short of accused being put to trial again. But who are the witnesses? I shall take your lordship a little later. Same witnesses. Very same witnesses whose names would find a place in the first report that has been filed under 173(2), and who came to be examined as prosecution witnesses, PWs 1 to 63, some of whom came to be treated as hostile. Again, my lord, a pretense of recording the further statement is made by the CBI. That statement is brought on record in the case, and they are cited as witnesses again. Then what is the procedure to be followed? Is it a case of continuation of the evidence of that witness? Or could it be said that he is a fresh witness who is to be examined by the prosecution? But I have no quarrel on the issue.
If it is continued,
Recall.
recall those witnesses.
That is what is mandated under section 217. Recall. Do it. Well, here, earlier during trial, my lord, one witness is named as PW1. Today he is summoned, examined as PW5, PW65. It can't happen. It should not happen. Kindly permit, let me finish
Yes,
it.
yes.
An order of retrial wipes out from the record the earlier proceedings and exposes the person accused to another trial, which affords the prosecutor an opportunity to rectify the infirmities disclosed in the earlier trial. That is what has been done in this case.
Again, interpretation of 386,
Again, 386. Ultimately, it is for the appellate court to find out.
para 16 in that judgment.
Please.
Yes, yes.
Yes. In Zahira Habibullah versus State of Gujarat Best Bakery case,
Extraordinary circumstance.
being an extraordinary case. And the Supreme
So even there it was not permitted.
Incidentally, what is the prejudice that is cast? To whom the prejudice has been cast? The learned judge cannot take on his mantle, my lord, a prejudice is caused either to the prosecution or to the accused.
No, nobody has, no accused has pleaded prejudice.
No, no, basically it is the accused who has got to plead.
That is what, prejudice of the accused.
Prejudice. It may cause prejudice to the prosecution also, but it can't cause prejudice to the prosecution and seek for a first trial or a new trial or a de novo trial because the interest of the prosecution is protected under section 217.
Recalling of it.
Kindly have a look at section 217 now for a second. But even otherwise, 311 is also there.
No, 311 is always there.
Always.
Yes,
Any
that is
time,
at any time.
anybody.
At any time, anybody.
Anytime, anybody. The judge could pick up the
No,
witnesses.
what happens is 217 is a consequence of 216. Once the charge is altered, you will have to recall the witnesses to answer the altered charge.
Then he can't say, no, no, I'm doing a new trial. No, that is impermissible.
No, whether
He
it
has to
is-
be having the power.
Whether it is only a statement made of new trial or actually new trial is commenced.
No, that too, new trial he could order when? When the accused pleads before the court that my interest is getting
Prejudice,
jeopardized.
yes.
My interest is prejudiced. But there is no plea. I have not asked. They will file an additional report. They will cite additional witnesses and record the further statements of the witnesses who are already examined, 63 witnesses. And they want to examine them now as fresh witnesses. And then the learned judge says, no, 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 proceed under section 230. What is 230? After the recording of evidence, after the framing of charges.
Yes.
Is it not, does it not amount to a de novo trial? First, charges are framed. Consequent to the filing of an additional report, on the basis of the evidence which the investigator had collected, additional charges are framed or charges came to be altered. Then, my lord, what the learned judge says is, no, proceed in accordance with.
230, 231 may not have been.
But that is what he has written.
No, that is the order.
That is the order. But what?
Because 230 and 231 would commence immediately after framing of charges.
That, no, my lord, what the learned judge is how ಸಾಯಬಾರದು ಕೋಲು ಮುರಿಬಾರದು ಅಂತಾರಲ್ಲ ಆ ತರ 216 ನಲ್ಲಿ ನನಗೆ ಅಧಿಕಾರ ಇದೆ ನಾನು ಮಾಡ್ತೀನಿ but I will protect your interest. I will look into that evidence also, but let them record evidence under 230 and 231. No, it can't happen. Well, it is for this reason. Kindly imagine this situation. But I shall give you, your lordship, one simple example in this very case itself. There are 6 eyewitnesses came to be examined on the earlier occasion. I don't say first trial, second trial. On the earlier occasion. Well, all the 6 witnesses came to be treated as hostile by the prosecution.
Yes.
Well, they were subjected to the test of cross-examination by the prosecution as well as by the defense, and then a re-examination would not have been done because when once the prosecution exercises the right oath upon it in examining the witness and also in cross-examining, they lose the right of re-examination. They can't have the right of examination, cross-examination and re-examination. That is impermissible under law. Well, now the same witness is examined with a different nomenclature of PW something else other than PW1. Well, he does not support the case of the prosecution. That is what has happened here. So even second time also. Can he be treated again hostile manner?
We'll see.
How many
We'll
times?
continue tomorrow.
Please.
Tomorrow, day after
Please.
tomorrow.
Help me not to say.
Get
But
ready
it
for
is a
the
serious
day.
and important question of law.
Yes, we will answer, definitely answer.
Chips,
Yes, yes. ಅದು this court judgment ಯಾವುದು ಅಂದ್ರೆ 216 ಅದು ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ನೋಡ್ಕೊಂಡ್ಬಂದ್ಬಿಡಿ.
Honorable Justice Vishnu Shetty is.
ಹಾ, ಎಸ್ ಸರ್. ಇದು ಕೊಡಿ ಮೇಡಮ್.
ಓಡಿ ಪರವಾಗಿಲ್ಲ ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು.
ಧಾರವಾಡ.
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ನಾನು.
ಹಾ, ತೊಂದರೆ ಇಲ್ಲ.
What the Supreme Court has said in a situation of this type. But otherwise it leads to a serious prejudice if this were to be allowed. Not otherwise. Under section 216(4). What his lordship would say is the remedy that is available to the prosecution subsequent to the alteration or addition of the charges is only under section 217 and not otherwise.
Yes. Day after tomorrow, we'll,
Please.
3 o'clock, 3:30. Be ready. we'll
Please, I'll
finish.
wait.
Yes. ಅವ್ರು ನಾಗೇಂದ್ರ ನಾಯಕ್ ಅಲ್ಲಿ ಕಾಣ್ತಾರೆ. ಇಲ್ಲೇ ಇದೆ. ನೀವು ಸೇಮ್ ಸಬ್ಮಿಷನ್. ಸೀನಿಯರ್ ಮಾಡಿದ್ಮೇಲೆ ಇದೆ. ಎಸ್.